recording.
Good morning and welcome to the December 5th meeting of the Committee of Bar Examiners. As a reminder, this meeting is being recorded. I am now calling this meeting to order. Devin, could you please call the roll?
Bolton,
He stepped out, but he is here.
Burns,
Present.
Cow,
Here.
Gongora,
Present.
Kaplan,
Here.
Kramer, Lawrence,
Here.
Lee,
Here.
Masiwala,
Here.
Montgomery,
Here.
Peak, Reed,
Here.
Reyes,
Here.
Reyna,
Here.
Silva Guzman,
Here.
Smith,
Here.
Yokelson.
Here.
We have a quorum.
Thank you. Excuse me. We have 6 members appearing remotely today as required by the Bagley-Keene Open Meeting Act. Members are appearing remotely must appear visibly on camera except if a member is unable to appear by video due to connectivity challenges. If that is the case, please provide an explanation. Otherwise, members should also raise their hands when leaving and returning to the meeting if they will be absent for more than 5 minutes. So at this time, I'm going to call for public comment. I understand that there is, first up on the agenda is a call for public comment. Before we begin, I would like to remind everyone that under the Bagley-Keene Open Meeting Act, public comments must pertain to items that are on the agenda or be related to matters that are within the jurisdiction of this agency. Specifically, the committee exercises oversight on admissions matters, including the California bar exam, the first-year law students exam, moral character applications, and law school regulation. The CBE does not have authority over attorney discipline, and there are no attorney discipline matters on the agenda for today's meetings. Members of the public wishing to comment were encouraged to submit written comments prior to the meeting to ensure that the committee would have time to consider these comments. The committee has received and read all the public comments, and we thank you for that. To facilitate hearing as many members of the public as possible, I encourage you not to repeat points that were made by previous speakers. And additionally, we have a full agenda for today's meeting. As the chair of the CBE, I'm going to exercise the option to limit each speaker's time to 2 minutes or to close public comment after 2 hours, which includes a 15-minute break, or after the first 100 speakers, whichever occurs first. For those who are participating by Zoom video, you should have a function for virtually raising your hand. It is a hand icon and should appear at the bottom center of your screen. If you wish to address the committee, please click on the hand icon now, and the committee coordinator will call on you in the order that hands are raised. For those of you who are participating by phone, you may virtually raise your hand by pressing *9. That is the star key, then number 9. Doing so will alert staff that you would like to make a comment, and the committee coordinator will then call on you and open your microphone so that you can address the committee. For those of you who are participating from a noticed location, please alert the committee member or the State Bar staff member present in the room that you would like to make comment. Staff will have an on-screen countdown timer visible to all attendees during the duration of your public comment. The timer's 2-minute countdown will begin as soon as you start your comment. The on-screen timer will flash through the final 10 seconds. The committee coordinator will now call on members of the public who signed up in advance. However, I understand that there is a member of the public present, Justice Masiwala, and we'll take their comment first. And before we do that, let the record reflect that Member Kramer has arrived and is present. And Dr. Bolton is also present in the room. And sir, you have the floor.
Good morning, all members. My name is Kai Ong from Sacramento. The last two meetings, I talked about, I complained Robert Bronter and T.N. Ho because they did not investigate Sacramento DA office provide me fake defendant Jung So Fong that hit and one kill my father Woon Kong on DA case number 99F0875. I request State Bar for an internal investigation, but it didn't happen. It seemed that State Bar is helping to cover up a Sacramento law enforcement scandal 26 years ago. I did email all the document and evidence to this meeting. I report this incident to their office in January 2024, almost 2 years, but they still did not take any action. And also State Bar did not force T.N. Ho and Robert Bronter to investigate my case. All committee members, you serve the State Bar is to try to keep a healthy and integrity legal system in California. However, State Bar has some misconduct issue. So it like that if they're doing something, it's contradict what you are doing. You are doing some good, but they are doing something bad. So I appeal that all the members can discuss with other committee in State Bar and help to address this issue to the public. Also, Sacramento City Council even used a UC Davis internship student to email me a fake police report. I went to UC Davis Law School Dean office to submit a letter and
Your
report
time is
to them.
concluded.
But
Sir, thank you. Your time is
Okay.
concluded.
Thank
I
you.
just want to say, I know you've been to many of these meetings.
Yeah.
We just want to indicate that these are not matters that are within the purview of either the Committee of Bar Examiners or the State Bar, and a member of State Bar staff will be contacting you to explain this further. Thank you very much, sir. Thank you.
Thank you. Thank you.
Thank you. For those of you who are participating by, strike that, excuse me. The committee coordinator will now call on members of the public who have signed up in advance. Devin, do we have any members signed up, or members of the public signed up in advance?
Our first advance sign up is from Benjamin Cohn.
Thank you. Mr. Cohen, you have the floor for 3 minutes.
Thank you. I wanted to first address your agenda item 4.4 regarding the future California bar exam to give notice regarding and specifically the proposal to potentially use NCBE products for the entirety of the exam. The NCBE, as you discussed at your last meeting, has been putting, or you've said that they've been putting considerable restrictions on what testing accommodations can be granted, and they seem to be applying on a blanket basis, at least as far as live proctoring, live remote proctoring, or any sort of remote proctoring that is not live and in person. To say that you provide individualized consideration, for example, of what substitute accommodations to offer instead for a disability-related need that could cause an applicant to request this, or that you do individualized consideration on how to assert the an alleged fundamental alteration exception in whenever the request is for something that the NCBE would not allow, that's not the level of individualized consideration that the analysis that the ADA requires, and that the ADA requires you to refrain from contractual or licensing arrangements that would disallow. The individualized consideration is about whether the accommodation proposed by the applicant would best ensure a level playing field to someone without that disability-based need, unless either you prove and assert that the accommodation would inherently render the exam incapable of factually incapable, not by policy of a vendor incapable of testing the skills or knowledge that the bar exam is designed to test, or that it would put such a financial burden on you that it would be grossly disproportionate to an applicant's interest in an opportunity to qualify to practice law. The uh, uh, that there was a lot of confusion that you would not be allowed to give a separate test, and you wouldn't have to give a separate test, or that you wouldn't be able to give a test at all because you have to by statute use the NCBE's questions. The reality is that if the NCBE's policy facially violates the ADA, and it does to the extent it prohibits this individualized consideration, the ADA would preempt the notice requirement to switch away from the NCBE for all applicants and prohibit contracting with the NCBE for the MBE or for Next Gen, allowing you to use Kaplan immediately. Thank you.
Thank you.
Our next public comment is from Michael Hanna.
Mr. Hanna, you have the floor.
Good morning, and thank you, committee members, for allowing me the opportunity to speak today. I'm here to talk about the admission process. I believe I'm in a unique situation which presents a challenge for the admission process. I spent the first half. I'm 51 years old. I spent the first half of my life in the military. When I was discharged, the government, the United States Department of Defense, spent over $250,000 sending me to law school so I would become gainfully employed in the civilian area. I had some challenges getting through law school because I did have a family. I was advanced in age, so it presented hardships that most students don't realize. When I graduated law school, the COVID pandemic hit. That presented challenges with the bar exam. I think I was a part of the very first administration that was remote, which actually contributed to me being disqualified in the first bar exam. I would have passed, but for the proctoring the challenges that occurred. So I took the bar exam the very next administration and passed. I began the moral character process, which is where I'm at now. For 4 years, I've been doing this. And I believe that the moral character process has become disconnected from the profession in that it's acting more as a barrier to entry that's not rationally related to the profession, rather than a protective tool to prevent people who would be a discredit to the profession from becoming licensed. And thank you.
Thank you, sir. And thank you for your service. Steve, next speaker.
Our next public comment is from Stephen Hargrove.
Mr. Hargrove, you have the floor.
Thank you, Chair and committee members. Today, in closed session, the committee will be reviewing my appeal regarding whether my entire first semester of law study should be nullified based on a de minimis 30-hour shortfall, a shortfall that was more than remedied in the following 12-month period. I just wanted to take this opportunity to thank the committee for their consideration of my appeal and for taking the time to review the comprehensive memorandum that I submitted to the committee in support of my appeal. On another note, I wanted to acknowledge the admissions staff. Despite this being a very busy time, the staff were professional, courteous, and responsive throughout this process. They always answer the phone promptly, timely responded to my emails, and one staff member even provided me with their direct phone number. My appeal is not a criticism of their efforts. It's simply a request that the committee exercise its discretion to recognize completed study that clearly meets the purpose of the governing rules. Thank you very much for your time and consideration. I know this committee's time is very valuable, and I appreciate this opportunity.
Thank you, sir. Next speaker.
Our next public comment is from Abdi Muna, who I do not see in attendance. Next advance sign up is from Gil.
Hello, my name is Gil Pelez. I'm an attorney, legal educator, and co-chair of the Future of Lawyering Committee at the LA County Bar Association. Today, I speak on my own behalf regarding item 4.4. In 2024, the CBE received a PowerPoint presentation from Measure Learning. The PowerPoint looks remarkably similar to a PowerPoint you will see today by the NCBE, including Measure emphasizing, quote, more than 20 years of working with high-stakes exams. As you know, even though Measure had great reputation and long history, the CBE moved too quickly, and the Measure decision turned into a disaster. Similar to Measure, today's Next Gen presentation is filled with promises based on reputation. The Next Gen and Nevada exams have not launched or even been beta tested. What will the pass rates be? Are there discrepancies between genders or ethnicities? The Next Gen is internet based. What percentage in a large state had technical issues? How have accommodations for disabled applicants worked? We will not know these answers for another 2 years. Imagine if California commits to the Next Gen exam or Nevada exam and the technology fails, or if either exam receives terrible feedback. California will be the only state stuck without recourse with a bad product because of the 2 year statutory notice. If this happens, February 2025 will look like a walk in the park. This is a decision you do not need to make this year. Nothing is changing about the exam except the multiple choice vendor. The state bar has already committed to pay Kaplan a minimum of $6.1 million for multiple choice. Use the product you paid for. State bar leadership has said many times that Kaplan was not the reason behind issues in February, and Kaplan questions were excellent. Accordingly, the CBE should adopt what I call option 4, the responsible option. Use the Kaplan questions as a temporary bridge and make a long-term decision as soon as 2028 when we have more data about all the options, including a solid proposal for a remote and reformed California exam. Let's learn lessons from February and make decisions carefully based on proven data and not PowerPoints. Thank you.
Thank you. Next speaker.
Our next advanced sign-up is from Jules Sarkar, who I do not see in attendance. That concludes our advanced sign-ups. Our next public comment is from Claire.
Thank you. Claire, you have the floor for 2 minutes.
Good morning. I apologize. I am a disabled presenter and I inadvertently did not note that. I hope that I will conclude within the 2-minute mark, but if not, I hope that I will have the extension of additional minute. I'm Claire Solot. I am the co-founder of the Legal Service Funders Network. I am very excited and happy to be presenting to you today. I'm going to be speaking on item 4.4. With regards to program design, it is always best to work with those with expertise in the subject matter area. In this case, it's examinations. From the standpoint of reliability, time needed, and economics, it is always advantageous to adapt designs that have been developed and tested. This is the approach that I used when creating the One Justice Executive Fellowship Program, which is the premier program to help legal aid executive directors and administrators learn to effectively run their organizations. We also used this approach when we created the LSFN Fellowship, which has now had over 50 new bar school graduates participate in our program. And next year, we will be morphing this program to become statewide with LAC leading the program. In the case of the bar exam, it is for these reasons that it would be more advantageous to use either the NCBE exam, the Next Gen, as its new name, or the Nevada plan. Trying to create a new exam specifically for California not only will be the most cost prohibitive model, but it also creates the most risk. For those who are trying to argue that the court order should be a limiter or prior comments about preference for remote, these are both red herrings and they are being advocated by members of the private bar and by individuals such as Gil Pels who have an economic stake in the game as bar prep leaders. If this group is interested in truly caring about the needs of Californians, it would be much more advantageous to spend the time looking at things such as extending the duration of the registered legal aid attorney program, such as was done most recently with the military spouse rule.
And Claire, if I could just interrupt you for 1 second, you have an additional minute.
I appreciate that. Thank you so much. We all know that the February bar exam was a total disaster. It was not tested properly. It was not conceived of properly. Sadly, we now know, based on the staff report, that many of the examinees based outside of California will not plan to use the waiver that they have been granted by this group, specifically because they have no intention and never had an intention of practicing law in California. While due diligence is important, it is crucial that this group do so in a timely manner to give State Bar staff and the examinees the ability to move forward and prepare. Therefore, we urge you to make a decision in the next few months rather than have this matter drag on for years as it's been done in the past. Thank you so much.
Next speaker.
We do not have any additional raised hands.
Thank you. Then that concludes our time for public comment. Next item is item 1.1, the chair's report. So for the first item on our agenda, I want to start with welcoming a new member to our committee, Crosby Burns. Crosby, will you raise your hand? Welcome, and we look forward to working with you. Thank you. I also want to take a moment to recognize our new executive director of the State Bar, Laura Speed. Laura, I think I see you on.
Yes, Chair, I'm here.
There you are. If you want to take a moment and just, if you have any comments.
Certainly. Thank you so much, Chair and members of the CB. This is my first meeting with CB, and I'm excited to be here. I'm Laura Enderton Speed. I assumed my role as executive director about a month ago, the first week of November. I come from a background of public service. Most recently, I was a director over at the Judicial Council of California for Leadership Services. But in addition to that, I was a law professor for 15 years and specifically teaching courses related to the bar exam, essay writing, multiple choice. So I have a lot of background from the student/professor perspective in relation to admissions in the bar exam. I am committed to working with you and the Board of Trustees to ensure an accessible, equitable, and fair future bar exam. And I know that's the biggest thing on our plate right now is the future of the bar exam and the changes that need to happen there. I thank you all for your service on the committee, and I really look forward to building a collaborative relationship with you all. Thank you, Chair.
Thank you, Director. Also, if we can go back to Crosby for just a second. Crosby, you want to take a moment and introduce yourself? I should have had you do that before.
Yes, absolutely. It's great to be introduced to you all. My name is Crosby Burns, California resident here in Marin County. I actually work for the county. I'm the Chief Digital and Innovation Officer, and I was very excited to join the committee here. I'm very excited about the trajectory that the board is taking us in the next couple of years. Looking forward to contribute however I can.
Thank you, and we look forward to working with you. So next, I want to update the committee on a few things that have happened since the last CBE meeting, just a few things. There have been appointments to the Law School Council. At the last CBE meeting, I mentioned that the appointments to the Committee of State Bar Accredited and Registered Schools, CS bars, that I made in consultation with our Vice Chair and Chief. Now I want to share that our new appointments to the Law School Council. Chris Edidon, reappointed as chair. He's from UC Davis School of Law. We have new members, Lindsay Harrington from the McGeorge School of Law, Nagin Miragabi from the UC San Diego School of Law, and they will join the following returning members of the Law School Council: Susan Bakshian, Mary Basic, Devin Kenyon, and Carly Sassy from the she is from Western School of Law. Second, at the first meeting of the Subcommittee on Exam Administration, which was conducted on November 24th, the subcommittee approved the business requirements for the first year law students exam and the rubric to assess the validity of and the ability of a vendor to deliver the exam. Those documents will be incorporated in the RFP that we expect to issue in early January. The subcommittee will next meet in early January to review the business requirements and rubric related to the exam driver for the bar exam. The final approval of those documents will occur at CBE's joint meeting with the Board of Trustees on January 23rd. Finally, attached to the agenda for today's meeting is the updated list of subcommittee assignments. These changes reflect only the addition of our newest member to 2 subcommittees and the reduction of committee member or reassignment of committee members. Vince Reyes' subcommittee load by 1, since Vince was the only CBE member who was previously assigned to 3 subcommittees. So he's down to 2 now. And we'll hear more about this later from State Bar staff. But I did want to tee up for the committee that at its November meeting, the Board of Trustees decided to continue the California Board of Legal Specialization for at least 3 more years. I mention this because if CBLS were sunsetted, CBE would have taken on some of its responsibilities. So we don't need to consider these additional responsibilities when we consider and discuss CBE's work plan in a few minutes. And that's the conclusion of the chair's report. So next on the agenda is approval of the October 10, 2025 open session minutes. Does anybody have any comments or suggested additions to the minutes? Seeing none, do I have a motion to approve the minutes?
I also move. This is Justice Maciwala.
Kareem Gore. Okay. Justice Maciwala moves, and I saw Dr. Cow seconds. Oh, okay. Kareem seconds. That's fine. Devin, can you call the roll, please?
Bolton,
Yes.
Burns,
Here. Yes.
Cow,
Yes.
Gongora,
Yes.
Kaplan,
Yes.
Kramer,
Yes.
Lawrence,
Yes.
Lee,
Yes.
Maciwala,
Yes.
Montgomery,
Yes.
Peak, not present, Reed,
Yes.
Reyes,
Yes.
Reyna,
Yes.
Silva Guzman,
Yes.
Smith,
Yes.
Yokelson,
Yes.
with 17 yeses and 0 nos, the motion passes.
Thank you. Next on the agenda is the consent calendar. There's only one item on today's consent calendar, the report on administrative updates regarding law schools. Do any members wish to pull this item off the consent calendar? Seeing none, do I have a motion?
Yes, to approve.
Mr. Kramer moves to approve.
This is Mike, I'll second that.
And Dr. Kyle seconds. Devin, please call the roll.
Bolton,
Yes.
Burns,
Yes.
Cow,
Yes.
Gongora,
Yes.
Kaplan,
Yes.
Kramer,
Yes.
Lawrence,
Yes.
Lee,
Yes.
Maciwala,
Yes.
Montgomery,
Yes.
Peak, not present, Reed,
Yes.
Reyes,
Yes.
Reyna,
Yes.
Silva Guzman,
Yes.
Smith,
Yes.
Yokelson,
Yes.
with 16 yeses and 0 nos, the motion passes.
Great. We have several presenters today who are external to the State Bar to give them a relative time certain for their presentations. And because we could not anticipate the length of public comment at the time we posted the agenda and numbered the agenda items, we are going to jump around a bit. We will be starting with item 4.6 on the CBE work plan. then, or about the CBE work plan, then move to item 4.5 on the admissions budget, and then return to the top of our business agenda at item 4.1. So let's move now to discussion of item 4.6, the 2026 Committee of Bar Examiners Work Plan. This item is being presented by several members of the admissions leadership team. I'm going to ask the Chief of Admissions, Donna Herskowitz, to kick off the presentation. Donna?
Good morning, everyone. I'm going to be joined by at least Tara Clark and Cody Hunanian as we walk through the work plan. But first, let me ask Tara and Cody if there's anybody else on your teams that will be joining that we should make sure to promote right now.
Not at this time.
Okay, perfect. So as the committee recalls, we revisited the 2025 work plan several times last year, most recently at the June and the August 2025 meetings. We looked at the 2025 work plan to update it based on the information that we then had, because we knew we were going to be spending a lot of energy and a lot of time on the bar exam, the future bar exam. And so we looked at delaying certain items. We moved certain items off the work plan. We updated a few things. And so this year's 2026 work plan builds on what we did in 2025. What Cody and Tara and I think is probably going to be the easiest way to walk through the work plan. And Devin, I'm sorry, could you share the work plan?
Yes, one moment.
Well, we think the easiest way to walk through the work plan is to go through each of the categories and identify what's changed since the 2025 work plan, since we did talk about that so recently. So we can highlight for you where we have added things, where we have taken things off, where we have modified the language, because we thought that the language as was written perhaps was already completed, but we may have modified that. And we want to walk through that with you. As you know, I believe as you know, this is the first opportunity for us to talk about the 2026 work plan. The idea for today is just a discussion to get your feedback, to get your suggestions, and then we'll come back with the revised work plan based on that feedback at the January meeting for adoption. So today is just intended as this staff initially putting pen to paper and asking for your feedback, so then we can put together a final plan that meets with your needs. Mr. Kramer?
Yeah, I have a couple sort of precatory questions. Is this, in essence, our planning meeting for the year, this discussion? Or
It is.
It is, okay. God, I put a lot of work a few years ago into trying to make the planning meeting a little bit more than just going over the work plan. And to those who thought that was a worthwhile effort, I apologize that I appear to have failed. But in essence, I think what you're saying is today we're going to give you our feedback, and you're going to come back with something that you're hoping that we can adopt very quickly. So today is the planning meeting.
Yes.
And today we should be discussing and actually deciding things to instruct you to put it into the final draft.
Yeah, I'm not anticipating motions when you say deciding things. Certainly, that is always your prerogative. But I'm anticipating you giving us feedback that we will bring back in the next draft, and you'll be voting on that draft in January. If either further amending it if we did not properly capture your suggestions, or if you have other suggestions in between then and now.
Okay, but because we're jointly meeting with the Board of Trustees in January, I suspect there will be very little time for us to do anything significant then. So we really should work things out today as best we can.
We should work things out as best we can. The expectation is that the joint part of the meeting with the Board of Trustees on January 23rd will be in the morning, where we'll be talking about the future direction of the bar exam. At the end of that discussion, we'll break off into a CBE only meeting for the rest of the day. Staff have worked closely with the chair and vice chair plan out sort of where key items are scheduled for the agenda through the rest of the year, so we can have sufficient time for things like this. So I don't anticipate a heavy agenda in January after the discussion of the roadmap. So there's always going to be time if there are further discussions that need to happen. And as you know, obviously we do revisit the work plan multiple times throughout the year, and as things change, priorities change, those are always open to being
Right,
changed.
and that's why we have it on the agenda every meeting, is in case we want to make a change to it. We don't have Bagley-Keene issues having to put it off. So for the new members, this is your shot to basically talk about things you think you'd like to see us work on. I suspect, given all the time that has to go into the new bar exam, that there is almost no bandwidth for any new initiatives. I don't think the things I'm going to talk about today are new, but they keep getting put on the back burner, and I'm going to make a pitch again today for those when the appropriate topic area comes up. But for you as well, this is your shot, to quote rather popular musical.
Okay.
And I would note that we left on the work plan at the end 2 pages that we added in August of 2025 when we looked at that, which were future work plan items. I think we took all the 2026 items and moved them into the work plan proper. We left the 2027, 2028 items that we'd previously talked about on that page. There may be ones that are missing, and we can certainly add to that as well. And also we left as the very last page of the work plan as a reminder to you and a reminder to staff ourselves, frankly, of some items that we took off the 2025 work plan that we still need to do some follow-up on to make sure that those happen. And so that's just a reminder for you that staff are still continuing to do that. So with that, then let's just start at the very beginning of the work plan. The admissions administration items. This is a sort of a new heading that we added to this time. And so this included an ongoing item that we carried over from the last year's work plan about investigating making public comments more easily accessible for committee members and the public. And then in the recurring items section, adding the process of the committee approving the budget for the Office of Admissions, and then receiving various updates that affect the Office of Admissions, updates on actions that the board took, that the legislature took, receiving updates on admissions data. So that's what was added from the 2025 work plan. If there, as I was looking at this, frankly, I think one of the things that we should say under the recurring assignments, not only receiving updates regarding admission statistics, but it should be clear that it's updates regarding the admissions budget and statistics. And then we are in this category asking for any additional thoughts of other things that should be added.
Are there any other thoughts, committee members? Okay, let's move on, Donna.
Turn it over to Tara Clark.
Good morning, everyone. And so you can see under the moral character one-time assignment.
Actually, hold on one second, Tara. Mr. Kramer?
Is this where the eligibility rules would fall?
No.
Okay. I'll wait.
Okay, thank you. I'm sorry, Tara, go ahead.
That's okay, and I can point those out when that section comes up, Paul. Okay, so for moral character, so we moved up on the future items. We had the possibility of exploring the video recording and formal conferences, so we've put that on the work plan for this year for the one-time assignments. And then the recurring assignments have stayed the same. The committee is the review body for any adverse determinations rendered by staff. Is there any discussion or comment on that section?
I would just like to emphasize, I think it's really important to video these conferences. Personally, I believe that committee members should participate in the conferences. I know that's not going to happen this year, but I think it's very important when considering appeals to be able to at least view the demeanor of the applicant. So I really urge staff to continue working on making this possible.
Thank you, Alan. Okay, not hearing any others. I'm going to keep going through my sections and we can come back to Cody. So we have now we combined examinations and exam administration. This was previously on the work plan, but we did update the deadline date. This is evaluating whether to phase out handwriting options for non-testing accommodation applicants. And the reason it's back on here is just since we're talking about the future of the bar exam and whether or not this is a modality we want to continue for applicants or not. Let's see, and going forward, we just added a couple of dates. So for example, we have the report of the productive mindset program. You likely know that as the bar exam strategies and stories. We'll have an update for you December 2026. You'll continue to do the appeals for anybody seeking an exemption to the state bar's policies. And this was again already on the work plan, but related to what you had reported out earlier, Ellen. We have the selection of the vendors for the bar exam and the first year law students exam that the exam subcommittee will be doing. And any questions or comments on that section before I go on to testing accommodations?
It doesn't appear so, so go ahead.
Thank you. Okay, and so since the test and accommodation rules are going into effect December 21st, we have gone ahead and renamed the subcommittee section. So this is now testing accommodations and eligibility. You'll see we have the provisional licensure program key data we're going to report out for you later this year. The special admissions rules. So these are the MJP folks. We have the other out-of-state attorney programs, ProHawk BJ, out-of-state attorney arbitration council. And so, Paul, this is the section where the eligibility rules would go. I think maybe what you're getting at is that the eligibility rules are still on the future items plan. And the special admissions rules, I just want to point out, are listed tentatively for April. That's because the State Bar does have a new process for any rule proposals have to go through an approval process before we can even bring it to you all. And so with the work that's going on with the exams, we were trying to space out the rules efforts. See if there's anything on the next page, and then just continuing to consider appeals. So any comments on this section?
Yeah, Paul, go ahead.
Tara, are you referring to I forget the term, but the rule drafting attorney has prepared some internal standards, I guess, and
that's part of it, yes. And so it's any rule revisions now have to be approved by the leadership team, just because of the mass effort it requires, not only from admissions committee, but also the Office of General Counsel and potentially IT and other offices.
Okay, and that's a critical path item that's still being worked on. Mm-hmm. And no rules can go forward until that's finished. I have one thing to add. It's come to my attention as a part of one of the law school inspections that we'll talk about today, that it is possible for somebody under our current eligibility standards to never receive a JD degree, but if they have studied diligently and in good faith for 4 years, they qualify to take the bar exam. And I'm wondering, I think we should revisit that because that standard is so vague. It causes us difficulty, I believe, I'm told, in reviewing those sort of cases. And also, I think it might be too generous. It might be letting some, I don't know what diligence is, but if that just means showing up and getting a participation credit for the time you showed up, but you never got a JD degree, so your school never really put their imprint or approval on you. I have my doubts about whether that person should be taking the bar exam and becoming a lawyer. So all I'm asking is that at some point in the probably distant future, we look into that as maybe, ideally it would be part of the eligibility rules review, but if that slows the whole thing down too much, it could be a future project. But I'd like it put on the list.
So that would actually have to be a statutory change. Our rules followed the statute on that. And so, the only reason that I bring that up is I'd like for you to think about when should we sort of, I guess the question, so we should put that on the agenda at some point for this committee of bar examiners to talk about whether they agree that is something that should be changed. So then we would make it a legislative priority for the following year, potentially.
Right.
Okay.
I just want to, raise it so it doesn't get lost.
Yeah, absolutely.
Thanks.
Tara?
Any other comments? Not hearing any. I'm going to go back up to exam development and hand it over to Cody.
Great. Thank you so much, Tara. So I'm going to start with our exam development one-time assignments. Donna briefly noted, but part of the kind of changes in this year's work plan is aligning these headers with our subcommittees, and the examination development is a more recent addition to our subcommittees. Listed there in our one-time assignments for exam development is a task to begin the necessary steps to actually execute the future bar exam approach that's adopted by the CBE, the Board of Trustees, and ultimately approved by the Supreme Court. We have that listed as starting as early as August 2026. Of course, the Supreme Court will need to approve what the CBE and Board of Trustees, or adopt what the CBE and Board of Trustees approves before July of 2025 or 2026 to allow us to provide the necessary notice. So following Supreme Court order, which based on that timeline can be estimated summer of this year, we would start that work in August. I just want to point out this essentially in part replaces a previous work plan item to pursue a California specific exam directed by the Supreme Court in October 2024. You've likely heard this in several of our recent meetings, but I feel it's worth reiterating. Everything is back on the table for the Committee of Bar Examiners to reconsider the future of the bar examination. So we've removed that verbiage from the last 2025 work plan that spoke directly to the Supreme Court's order.
If I could just clarify, right, Cody's absolutely right. Like, as you all know, we are spending a lot of effort sort of considering whether there should be a change you should be recommending a change to the Supreme Court in terms of what the future for the bar exam is. To be crystal clear, the October 10, 2024 order of the Supreme Court is a current order of the Supreme Court. We are based on what happened in February of 2025, the board, the Committee of Bar Examiners, and frankly, some on the court are reevaluating whether there should be a different path. So ultimately, that same language could come back onto the work plan. But I just wanted to make sure to provide that context because when we talk about all options are on the table, they are for us to be thoughtful in coming up with a recommendation. But I just wanted to be clear that the court order is still in force.
Yeah, thank you for that. Before I move on, I do also just want to point out there are obviously a number of examination development related tasks that are currently ongoing. I don't want this August 2026 date to imply that anything is on hold. Kind of our typical exam development work will continue, and there'll be a number of examination development discussions that we bring to the subcommittee to help inform the Committee of Bar Examiners as it makes its choice for the future exam. And that's maybe not clear just based on this one bullet point. As far as our reoccurring tasks, some of these are familiar. Obviously, the Committee of Bar Examiners will continue to select questions for upcoming bar exams, our essay and performance test questions in April and December of each year. A new item is the level of oversight of reviewing and approving the state bar's developed multiple choice questions if use of those questions is ultimately adopted. As a reminder, in the recent rule of court amendments, there's a requirement that all new questions drafted for the exam or used for study guides are reviewed by either the Committee of Bar Examiners or its designated content validation panels. The CBE has already approved a recruitment policy for those panelists, and that policy is pending Supreme Court approval.
Cody, I had a question on one of those items. What level of
moderation is occurring with artificial intelligence, if any?
Meaning, is it being used to draft questions?
Yeah, or in the review or evaluation of the questions.
At this point, not at all.
Okay.
And at the last Board of Trustees meeting, the board reviewed a artificial intelligence framework that I believe the best way is to summarize it lists using artificial intelligence for exam development as kind of the highest level of risk and would require kind of board approval before those tools are used.
Awesome, thank you.
Yeah.
Cody, Josh has his hand raised.
Sure.
Yeah, hi friends. I'm sorry. My VPN through my work location is not working, so I can't turn my camera on right now. But I just wanted to go back to Tara's presentation really quickly. My understanding is that she bulleted a point about testing accommodations raised by applicant Shirlene Cleish, and I would like to propose that it get moved up to 2026, early 2026 instead of 2027. Only because I care deeply about accommodating applicants that struggle with disabilities or other limitations that the average applicant does not.
And I'm sorry, can I ask, are you referring to the evaluating the impact of the revised rules, Josh?
Yeah.
Okay, and give me 1 second, actually. And I apologize, maybe I didn't point this one out. So for this year, we actually have this new item to develop metrics to analyze the impact of the revised rules. And so that's for October in 2026. And then, so that's why we have the full analysis on for 2027 as well, also to give us the full administration cycle after the rules go into effect. And again, they're going to go into effect on December 21st.
All right, that makes sense. So you don't think it's feasible to move it up?
Unfortunately not. We just do want to give it the full benefit of the time frame.
Sounds good. Sorry for interrupting you, Cody.
Not a problem. Okay, returning to the last bullet point in the examination development recurring assignments. This is a new addition. This is based on the charter that was approved for the examination development subcommittee, and we have an ongoing task added to establish and review item selection criteria, content rotation protocols, and security measures related to bar exam questions. To some extent, there are a number of policies and rules already in place as far as how question content is handled, but the examination development subcommittee, I think, will be reviewing that in more detail in the future. Any questions or feedback on the examination development tasks before I move on to educational standards?
Go ahead.
Okay. Moving down to our educational standards one-time assignments. First is a task to consider changes to CS BAR's term length, member composition, calendar, and feedback loop. This is in response to the Board of Trustees' approval of recommendations following what's called the 5-year sunset review, in which staff reviewed all of the State Bar sub-entities. Ultimately, what the Board of Trustees approved based on those recommendations was a general framework that recommended perhaps shortening the term lengths for members to kind of improve participation amongst all of the law school deans who could participate, aligning the Committee of Bar Examiners and CS Bar's calendars in a different way to kind of better facilitate the relationship between CBE and CS Bars as an advisory body, and just generally kind of strengthening the feedback mechanism where the CBE sends referrals to CS Bars and CS Bars sends back its feedback. The recommendations approved by the board, again, kind of provided a general framework. There's kind of some specifics that we would like to bring to the Committee of Bar Examiners and seek your guidance as far as making those final determinations. For example, if we shorten the term lengths, should that be a 2 or 3 year term as opposed to the current 4-year term? So that's something we are planning to explore in March 2026. We have set for April 2026 a revisiting of a discussion that was on the 2025 work plan. And this is to explore requirements for California accredited law schools to require courses regarding the competent use of generative AI. And just as a reminder to provide new members some of the context here, the Committee of Bar Examiners considered this in 2025, and at that time ultimately recommended that staff kind of prepare a less formal practical guidance document as opposed to revisiting the rules or guidelines. There's been some ongoing discussions and really proactive participation from CS Bar's members, and through that work, they've produced, the law school deans have produced kind of a number of recommendations that are perhaps maybe outside the scope of this initial recommendation from the board. All of that, along with kind of the very dynamic and changing landscape of the legal education space, I think has led staff to think that this is a discussion kind of worth revisiting and also refocusing around the board's initial directive to staff.
Yeah, Cody, I was in a visitation recently inspection, and it's happening in real time at the CALs. So I think any opportunity you can to move this up sooner would be helpful. They're dealing with it their own way, but obviously government typically has a way of getting in when things have already occurred or have become chaotic. So any opportunity to move this up, I would recommend. Just for the sake of it's already happening, and they're dealing with it on a crisis type basis.
Happening in the sense that they are introducing courses or the other AI related
Are there more
issues?
grading and evaluation areas that are working its way up to student performance?
Okay, thank you for that.
Yeah, no worries.
Is that encompassed in the scope of what you got here?
So it's not encompassed in what's on the task here, nor was it kind of part of the board's original directive. So that's kind of part of the revisiting process, is that we too kind of heard from law schools, and as I mentioned, CS Bar's members in working on this topic introduced a lot of other kind of intersecting areas where artificial intelligence is important that isn't captured by this directive. So I guess a question for the committee will be kind of first and foremost kind of what a response to the board's directive, and then I think perhaps a recommendation on how we should proceed on some of these other issues that Mr. Gongora and law school leadership have raised for us.
Okay, this just refers to accredited law schools, but should it also refer to the registered schools?
The board's original directive applied to California accredited schools only. So this could be a question.
That we extend it.
Yeah, that's certainly within the purview of this committee. We can add that.
Add the word registered.
Sure.
This is Julie Smith. Kind of going on that, my comment is to extend it to law study programs as well. If there's any kind of guidelines we can make as far as we can present that to supervisors. I guess my concern is if students are using AI for doing their tests or their assignments, I think that's an issue, and how closely are supervisors looking out for that and making sure that students are actually studying and not using AI to complete their assignments. So I would extend it to the law study program as well, if we could do that.
That seems reasonable. Can we do that? Yeah. Thank you, Julie.
Okay, that was very valuable feedback. Moving to the next page. This is an item that continues over from our 2025 work plan, which is to explore opportunities to collect enrolled student demographic data that comports with the State Bar's data. Again, just to provide some context, the State Bar several years ago modified the data that we gather from law schools to align with kind of federal data requirements. However, in recent years, the State Bar has been rolling out across all of its programs kind of a unified demographic identifier regime that kind of addresses more nuanced ways of personal identification. And so we would like to start a discussion with law schools about whether the feasibility of requiring them to include in their compliance reports to us demographic data that comports to our new regime. And I think that would facilitate some comparative analysis between other State Bar data. We have that set for August 2026, and of course, that would include extensive discussions with CS bars.
It says June here, the data.
Oh, I'm sorry. I was looking at, thank you. I was looking at the row below. So yeah, so June 2026 is a target date for that. For August 2026, thank you for that correction, we have a task to explore whether to develop performance targets for key indicators of law school performance. Recently, and especially last year when reviewing the unaccredited law school rules, the Committee of Bar Examiners considered, for the unaccredited rules, adding a minimum bar exam pass rate, and at that time opted not to explore a attrition minimum measurement of attrition data. However, the law school performance report has now been launched, I think, for 3 years and will be going on our 4th year, which has given us the added benefit of having some kind of trended data over several years. And so we think it's worth, in August, when the new law school performance report is launched, to bring that to the Committee of Bar Examiners to look at kind of medium-term trends and see if that maybe informs establishing more kind of more formal requirements on these important performance metrics.
Yeah, and this is one of my, one of the big items on my list that I'd like to see go forward. The next item is considering revisions to the unaccredited law school rules, and these thoughts might be a part of those, but that's a bigger project that keeps getting pushed back by February cleanup at this point and other things. So what I'm hoping is that we can work on this priority as staff is proposing. And then I have one other priority I'll mention after Cody says whatever else he wants to say after I just introduce the next item. So if we have to piecemeal improvements to those rules, if that's the best we can do, I would still like to do that.
And one of the things that I would note, so when we have for consideration of those rules, October 2026 is the deadline, that does not mean we come to the committee in October of 2026 and say, okay, now we'd like to start working on these rules. Can we have 2 volunteers to work with us? So the staff are working up a calendar of what I am have badly named sort of the pre-work. In order to get this to you in October 26, what's the calendar like, and for all of the development efforts that need to happen? So this would be something that would be starting, and I think we completely understand that this is something the committee has wanted to work on, and we think it's important to work on. We've also heard the Board of Trustees, when we presented the performance report to them, also suggest that this is important to work on. So we certainly anticipate putting real effort into this year.
Completely do your job on the next
well, you guys got it ahead of me, but so for October, as Donna mentioned, this is sort of kind of a final deadline. There's a number of tasks that need to be done prior to that. For those that were members in our last term, you'll remember we did quite an extensive review. I think we have a good foundation to start with. So that will be continuing through 2026. I think, Paul, you were starting to get to this point. One of the challenges in our last review process is that there are a number of rules that are contingent on changes to other admissions rules, like the eligibility rules, and perhaps we can break those out so we can advance some rules now, and perhaps maybe revisit others at the time that the eligibility rules are considered as well.
And so the other component of those rules that I would like to get on sooner than later is we call it the compliance process, but discipline is just as good a word. It's where a law school is not performing up to standards. The process for waking them up, making them come in and show us a plan for improvement, and then if improvement doesn't occur, taking steps such as putting them on probation and then maybe eventually revoking their registration is a very long and cumbersome process. We some years ago when we fixed the accredited school rules, we made that process much more streamlined, and I'd like to do the same for the unaccredited registered school rules. that I think is separable from eligibility issues.
Yeah, that would, and I think if I recall correctly, the committee had started to make some improvements in removing an inspection requirement following probation, because probation typically came out of the results of an inspection.
Did we actually make a change? Because I've forgotten. I know that Natalie, Vince, maybe even Alex Lawrence, back when he was chair of the subcommittee, we were starting to talk about this kind of thing. So we've been at it for a long time. And Vince, I assume that you would like to volunteer with me to be working with staff on that. Is that correct?
Sure, I would be happy to.
We're the chair and vice chair of that subcommittee.
Yeah, it's a major concern.
Okay, thanks.
Okay, let me just turn to our recurring assignments for educational standards. The first is engaging with law schools regarding options for bar exam development and bar exam administration. This effectively replaces a item on the 2025 work plan in which we had identified the goal of kind of enhancing engagement with law schools based on feedback that we had received from law schools about their kind of preferred communication. I will say we've implemented some enhancements. We have quarterly dean meetings that have now been implemented. Obviously, CS bars and law school council discussions continue. So this has sort of been reframed as opposed to focusing on enhancements. This is focusing on the kind of topics that we want feedback on. And of course, the top priority is the future of the exam and exam administration. And then there's a number of just kind of typical and ongoing tasks. The launch of the 2025 Law School Performance Report in August. We produce that each summer annually, and staff and the committee obviously will continue to review applications for registration and accreditation, major change requests, progress reports, and annual compliance reports, as well as the minimum cumulative pass rate for accredited law schools. And then the last bullet point is a continuation of a goal that our previous chair, Alex Chan, had established on the 2025 work plan, which was to expand committee member participation in law school inspections. I will just take a moment to thank some of our newer members. We've had new members already join recent law school inspections. We'll continue to reach out to all members when there are opportunities to do so. And then lastly, just to point out a few items removed in the work plan, there is at the bottom of the document a note that exploring the need for mandatory accreditation is sort of put in the parking lot pending the review of the unaccredited law school rules. The committee has considered this a number of times, and this is an area that also would require statutory amendments, and so there was a refocusing last year around the unaccredited law school rules and working within the existing rule framework. And then lastly, another item removed from the work plan, enhancements to the annual compliance reports. Staff made some improvements to the compliance reports, particularly the instructions to law schools about how to fill them out. And this was based on some feedback that we received from law schools. So this removed mostly because that task has been completed. And that's it for me. Thank you for the time. I'll take any other feedback or questions on the educational standards.
Okay.
Okay, thank you very much.
Thank you, Cody. What's next, though?
So as Member Kramer noted at the beginning of this item, this work plan may seem less ambitious than some years because we know how much work we have to do between now and the middle of the year in terms of developing a recommendation for the future bar exam. So that's why we were reluctant to pile on multiple rule revisions, and we're trying to space those out so we can actually meet the timelines that we set here. This is not in any way to stymie any further discussion about what is missing and if there are other things that you would like on the work plan, but that is something that we very much have to keep in mind is how much work that staff will be doing, how much work the exam development subcommittee will be doing, and the full committee will be doing over the next several months on really that one of our very big priorities on the development of the direction for the bar exam.
and that is a huge undertaking. However, given all of that, as Paul indicated at the beginning of this is the opportunity for anybody to bring up any other priorities or things we ought to be working on in the coming year. So are there any other comments or suggestions or wish list items?
I would, Chair, we haven't really approached this, and I know our function is admission related, but any kind of communications to applicants, I guess taking an analysis of what we've done, have been doing, I've yet to see in my 7 years here. And so I'm thinking that more of a noticing. A lot of the responses I get from participants is how our noticing works. It's very, how do I say it, man? I guess as I'm working through this, and I've been here 7 years now, I guess they don't feel like we have enough communications, but we've never really took an analysis of if it's enough or if we should be doing less or more. We kind of just respond as needed according to our own policy.
Well, the notices that go out are pretty detailed.
Yeah. This comes up more during crisis time.
Sure.
Mm-hmm.
Sure.
But we've never taken an analysis of it. So we've said, yes, it works because we believe it works, but we're essentially not even polling or having any level of engagement with our participants or our stakeholders on if it's enough. I think we do at the CS bars level because we have these regularly occurring meetings, but we don't often engage beyond that.
I'll ask staff, is there any way to do any kind of polling or
Yeah, so that's what I thought maybe you were getting at is some survey of our applicants and asking them about the communications. I mean, it is something that we have historically asked about in our post-bar exam survey. So after every bar exam, we do a survey, and we do ask about the communications from the vendor, the communications from us, if they were helpful, if they were clear, if they were consistent. So maybe the first thing I can do is I'll bring let me bring the comparative data over the last several surveys. I think we took that out for this most recent survey, but for all of the after the July exam. But let me pull that information, and it may also be in the survey that we do after the first year exam. So let me pull some comparative data, and we can certainly bring that to the next
I'm in
meeting, and then we can
chats
see.
And I get I got this at 11 p.m. And it's obviously I'm not narrowed into that level where I know what's occurring, but I'm just saying I'm hearing a lot more of that. So
yeah, I mean, obviously, if we are communicating in a way that we think makes sense, but it's not making sense to the applicants, then we need to do something different.
Yeah.
So happy to bring this and
you,
then start figuring out if there are things that we should be doing differently. One of the things that we do, I want to make sure that everybody knows that we do this, in the 6 weeks in the lead up to a bar exam every Friday, and we're going to move that date. Actually, our plan is to move it earlier in the week, but every Friday we send out a communication to everybody who signed up for the bar exam to give them updates. And Cody actually took the lead before the July exam and revamped those to make them what we believe to be sort of better and more user-friendly, coming up with a more sort of rational approach to what was going to be said in each of those countdown emails, summing up at the beginning what you heard last time and telling us at the end what you're going to hear next time, and the things that we're going to focus on. So I think we made a lot of progress on that. We instituted it. I think for the first time we instituted it with the most recent first-year law students exam. We did a similar type of communication, a countdown email in the 4 or 6 weeks prior to the exam. We were also doing it for the legal specialization exam. So we are building that into our communication methods because I think we have some of the same thoughts that you do, that we want to make this better and more effective.
I receive a weekly blast that is incredible. So the team that puts that together is top par. So I'm just wondering if that's being reciprocated. And obviously, I'm coming from a place of where I'm in different group chats where I'm getting these concerns. So thank you so much. Appreciate it.
One thing, if I could just briefly add, since you kind of mentioned analysis, we the weekly emails that Donna mentioned, we do review kind of the open and click rate and kind of the statistics that are available, particularly for the bar exam. The vast majority of test takers open and view that email. So we know for that particular series of emails, it's well received. That's the kind of analysis we've done. Maybe more can be done, but I just wanted to share that with you.
Even just taking an inventory and taking our wins is enough for me.
Yeah.
The bars, are we still doing the bar stories program? Okay, cool.
Okay. Thank you. Michael, you had a comment?
Oh, yes, just something for the work plan is the engagement with the law schools regarding development of the bar exam. You're looking, at the bar passage statistics. There's a very, very noticeable disparity between the ABA schools and the Cal schools and the unaccredited schools. And I think that's something that we should really zero in on and coordinate and talk to those schools and try to understand what do they think is causing this disparity, because the ABA California domestic schools and out-of-state schools scored I think a very, very healthy pass rate. But then we have a challenge for the others. So I think trying to dig into that early and understand that will really help us move forward, not just on the administration of the schools, but the development of the exam overall.
Would that come under what, the heading of CS bars or law school council?
Yeah, we can certainly include that in our discussions, both with CS bars, law school council, and I mentioned we have our quarterly meetings now with law school deans. That includes specific calls with our CALs and with the unaccredited law schools. So we can certainly bring that up. Just as context, since Mr. Lee's a newer member, you all might recall when we visited the unaccredited rules last year, one of the pieces of data that we brought to you was the impact of the minimum cumulative pass rate for the CALs. And after that policy was put in place, we actually saw an across-the-board average increase, and that kind of informed the creation of the proposal at the time that we maybe bring that minimum pass rate over to the unaccredited law school rules. So we certainly can engage the schools about the disparities, but certainly kind of the committee's role in creating the rules plays a part as well.
And it also relates to the study of the attrition question, setting standards for that, the first year logs, student exam, all that. So it's all mixed together. I think I don't think the bar is equipped to be trying to help the schools improve their teaching, the details of that. And I think a lot of schools would resist that because they want to, they want to be in charge of their own programs. But it's worth looking at in that context.
Okay. Thank you, Michael. We'll work
just to focus, I don't think we want to dictate the curriculum. I think I'd just be curious what their view is why that they're getting that result. If they have some understanding that they think, that why is that happening on their side?
Okay. Anybody else? Any other thoughts about the work plan? Okay.
I'll just make a comment. I'm over here, Alex.
There you are, Alex. I was like, where'd that come from?
I know, it's like a mouse in a house.
Okay.
So I just want to say I think it's really good on the one item about just having more updates about the budget. I know it's gotten a lot more robust over the last couple years for a lot of urgent reasons, but to keep that as part of it is going to be really good.
And apropos of that, our very next item is item 4.5, discussion and action, if appropriate, on recommendations for the 2026 budget for the Office of Admissions. This item is being presented by Chief Financial Officer Araceli Montoya Chico and Finance Officer Justin Ewert. Are they here? Or Devin, can you promote them? I see Justin.
Hi. I think it would just be me for this presentation for right now.
Great. You have the floor.
Okay. Thank you. Thank you. I will start by sharing my screen. I have a brief PowerPoint presentation to help walk the committee through the budget. And once I get confirmation that people can see my screen, I will begin.
You can see it here in LA.
Okay, great. Today, I will walk the committee through the draft 2026 admissions fund budget. This is an early stage budget, and the purpose of today's discussion is to receive input on the assumptions that we use to build the budget. We are still working on these numbers, and they will be refined further through December and January. No official action is requested at this meeting, and we will be bringing this budget back to the CBE in January for further review. So I will see everyone back here next month. This first slide has to do with revenue. The proposed budget includes total projected revenue of $31.5 million. We have groupings or categories when we budget. Those categories are other fees, exam fees, investment income, and transfers. Other fees include all of those other programs in admissions. That's MJP, law school accreditation, Pro Hoc Vice, law student registration, moral character, provisional licensure, and out-of-state attorney arbitration. Of those groupings, moral character is the largest component. It's about 42% of that $15.5 million. Exam fees are the bar exam fees, the regular bar exam fees, and the first-year law student exam fees. Of the 15.2 million, 14.7 million is bar exam related, and that is about 47% of all admissions revenue. So the bar exam is the largest single component of admissions fund revenue. These figures incorporate the service fee increases the board adopted in November. I want to highlight one important change. The CBE recommended a $150 increase for general bar applicants at your October meeting. The board ultimately adopted only a CPI increase of $27. This decision resulted in approximately 1.2 million less revenue than would have occurred under the CBE's recommendation. I also want to point out that the budget includes a 1.5 million revenue reduction from the remaining fee waivers tied to the February 2025 exam. We expect that many of those fee waivers will be used during the administrations of February and July this year, or in 2026. But because the 2026 exams will be offered only in person, we expect some of the waivers for out-of-state and foreign attorneys to lapse. But as you can see, the overall impact is still significant. On the slide here towards the bottom, you will see that we expect 100% usage from the foreign educated, the law office study students, the California US law students and graduates, and the disciplined attorneys. But we only anticipate 50% usage from the foreign attorneys and out-of-state attorneys. Those numbers in parens represent the amount of applicants in each of those groups. So the total unused waiver amount, kind of the liability that we're not incorporating into the budget, is $357,000. So if every single person who had a waiver used it, the budget could be negatively impacted by that amount. One final consideration that I want to note is that exam capacity is not finite. So the use of a fee waiver slot does not displace a fee paying applicant. So some of the revenue loss may be offset if first-time time test takers or repeat takers who do not qualify for a waiver register in greater numbers. And then the other lines on this is investment income. You can see there's a reduction in investment income that has two factors. One is the Fed has dropped interest rates, which will have a small impact on this number. But the other larger impact is that the fund balance at the beginning of 2025 was 9 million. We're projecting 3.4 million at the end of this year. So if you have less money to invest, you earn less interest. The transfer in has to do with legal specialization employees. Some of the legal specialization employees for the annual renewal are in regulation, but there's a transfer in to help cover the cost for those legal specialization employees that remain in admissions. The next slide has to do with expenses, and I broke up the expenses into two slides because I couldn't fit all the information in one slide. The three categories that I want to focus on this slide are personnel costs, building operations, and services. Personnel are all the costs related to employee salaries and benefits and temp health costs. The budget includes converting one limited term position to a permanent position and a 2% COLA for admission staff that was negotiated with the most recent MOU. The conversion is related to the return to in-person, so that's why we are converting that position. Admissions had a reorganization last year, and those positions that are still actively being recruited for are included in the 2025 budget and therefore not new for 2026. The building operations line basically includes the telephone expenses. So if people have cell phones or desk phones, so that's what that includes in that line. And then services. Services is approximately $4 million. Within services, we have a category called professional services related to bar exam development. Of that group, the largest cost is the Kaplan contract. Then there is $500,000 for content validation. We have $2 million on consultants on exam administration and development. And then there's a $100,000 placeholder for other exam development work pending the decision on the future of the bar exam. There are other additional professional services not directly related to bar exam development, and those are for testing accommodation, psychometric services, law school inspections, and the bar exam strategies and stories. This next slide has to do with the other expenses. It includes the supplies, equipment, other expenses, exam-related expenses, and indirect costs. Supplies are for small dues and subscriptions and postage. It's not a very large amount. Equipment totals about 0.8 million, most of which is 0.7 million annual subscription to the Salesforce platform that runs AIMS, the Admissions Information Management System. Other expenses include all the travel-related expenses to the bar exam. It also includes the CBE's travel-related budget. The budget includes $20,000 for 2 in-person CBE meetings. Exam-related expenses are those directly related to putting on the exam and include facility cost, proctors, security, tables and chairs, graders, and electrical. For 2026, we expect 13 sites for the February exam and 14 to 16 sites for the July exam. That hasn't been finalized, but we are actively working to finalize that. 2 February sites are the State Bar office locations that do not require any rental costs, as we're trying to save costs where we can. Indirect costs are $8.2 million and follow the same methodology reviewed and validated by the state auditor twice since I've been at finance, most recently in 2023. We understand this is a substantial number and its impact on the admissions budget. In 2024, the indirect costs in the adopted budget were $9.6 million for admissions due to a lot of one-time costs contained in that particular budget. At the end of the year, the actual spend for those indirect cost departments was much lower and the budgeted amount. We trued up those costs at the end of the year and reduced the indirect cost to $8.1 million, resulting in a $1.5 million savings to admissions. There are various reasons for the lower spend. An example was there was an elevator project in the LA building that got postponed, and so the spend wasn't there. And I just bring this up to say that we make every effort to only charge admissions what is actually spent, and we will do this true up in future years as well. My next slide shows the expenses as a whole. I just wanted to bring up the total expenses. As you can see, the total expenses is $33.5 million. If you subtract the revenue, that shows a deficit of basically $2 million. That's the deficit for 2026. The projected fund balance at the end of 2025 is $3.4 million. This balance is sufficient to absorb the projected $2 million deficit in 2026. But it also highlights that while the one-time impact of fee waivers will be resolved after 2026, a structural deficit of about $5 million still remains. So that is my presentation. I'm happy to go back. I can take down the presentation, we can have a discussion, or I can go back to slides if there are committee's questions on particular slides.
Member Kramer.
2 things. I think the structural deficit was $500,000. You said $5 million? Did you?
$500,000.
Yeah, I didn't clench up too much. My other question is about, I'll just note that in the staff report that was published for us, the narrative about the waivers was confusing. I'm not going to try to dig into it because your explanation was clearer, but please revisit that language if you're going to use it again. The math didn't add up, for one thing. My second and final question is, has it been determined we're only going to get 2 in-person meetings this year, or is that still being discussed?
That is, yes, that is being discussed. Justin built the 2 meetings into the version that he's presenting today because that is what the board has currently authorized. This is exactly the opportunity for you all to say, we've taken a look at the numbers that you've presented. We don't think that, assuming this is what you're going to say, we don't think that the addition of X number of additional meetings is going to turn the budget, topple the budget. So we are asking you, budget staff, to add into the budget X number of additional in-person meetings. And then ultimately that will be decided when the board adopts the final budget in February.
And
we
are
could
asking.
Start with all, but 2 more would be good.
We are asking for 2 more. So four total for this year. Any other questions, comments?
Yeah, from Larry.
Larry.
Do you have any recommendations for how you bridge the gap? How you get rid of the deficit?
We're looking at bar wide because it's not just an admissions problem. We have to, be fiscally sound within our general fund, our law assistance program fund. It needs to be fiscally sound. So we're looking at that. Using bar offices is a way to save money. We're looking at other cost cutting strategies. We are actively we did a reduction in force last year, and we are contemplating losing more staff over the next couple of years to get our budget right-sized. But I don't have anything specific at this time. We are working with the admission staff. We're working with other staff to try and identify that. In terms of the impact on the admissions budget, the indirect cost, one of the things that may change as the overall budget is refined and there are more costs cut there. So it will have an indirect impact on admissions, but that's something that we're actively looking at, but I don't have anything necessarily to say right now.
Are there any other questions or comments?
One thing I'd like to point out, and I think it says it in the staff report, but I don't think Justin mentioned this when he was showing the slides. So the slides showed a bar exam cost of 8.6 million, something like that, for bar exam expenses. You all know, I just think it's important to say this because we've heard public comment to the contrary. You all know, and you saw when we did the admissions, when we were looking at the admissions fee item, that those expenses that are identified that total that 8-point-something million for bar exam, those are hard costs, right? Those are the testing sites. That's the cost for the proctors. That's right. It's the electricity. I think Justin mentioned some of those things. When we did the admissions fee exercise, we also said, well, we need to show you how much the true cost for the bar exam is. That true cost is all of the staff expenses. That right, the percentage of the staff time that goes to work on the bar exam needs to be allocated to the bar exam expenditure side of the equation. The amount of money that we spend on consultants for testing accommodations, the money that we spend for psychometricians, all of that goes to bar exam expenditures. And so I just wanted to make that point crystal clear, because I can easily see how you look at this and say, you're getting X amount in revenue for the bar exam and the expenditures are only $8.3 million. The expenditures are significantly more than that when you put all of those other items in. But the way the budget typically works, personnel is budgeted separately than everything else. So I just wanted to make that point crystal clear.
But it is the case that lately we've been buying things at the last minute rather than contracting several years into the future. And that has raised the cost a little bit, correct?
I imagine that is true, right? So as we had to go back in short term with short notice to an in-person exam, right? We were contracting on short notice. I can't confirm for you how much cheaper it would have been had we contracted with those same sites 6 months earlier. But it's certainly a reasonable assumption, and our belief that there was some additional cost because we had to do it on short notice. Staff are already looking at not just contracts for bar sites for July 26, but they're looking out to contracting for 27 as well. So as much as we can do 27, 28, and getting those long-term contracts, we do think that will ultimately save money and will allow us to have some breathing room in that we will have secured those sites.
Thank you. Thank you, everybody. Anything further on this item? Okay, seeing none, just to let everybody know, what I'd like to do is go through the rest of the open agenda up to item 4.4. So what I'd like to finish off these other items. We'll take an extended break, or a brief break, actually, and then pick up 4.4 before lunch. So with that being said.
I'm sorry, can I just,
Yeah.
I just want to make sure that Justin and I have the marching orders from the committee.
2 additional meetings.
Yes.
You'd like to recommend?
Yes. And were there any changes to any of the assumptions? So, Paul, for example, you mentioned the narrative was not clear, but you thought that Justin's analysis, the presentation was clear on
Fee waivers.
how we were sort of the assumption we were making on how many of the fee waivers were being used. But I want to make sure that, are there other assumptions that you all are requesting be changed for the budget that Justin brings back to you in January?
I have I don't know if there's, what's the price difference between doing it this way and a full in-person? What's the cost differential?
So, Justin's back. You can answer so the question was, because you were just coming back, you probably missed it. Larry was asking about the cost differential for an in-person meeting versus the way we structure the meetings now. So basically, how much would we be adding if we're adding 2 additional in-person meetings?
Roughly speaking, it's about $8,000 for an in-person meeting and significantly less for these types of meetings where it's just mileage and there is no air travel or hotels.
Okay. It's a few $1,000s. Right. It won't break the budget to add a couple of more in-person meetings, which I find are infinitely more productive. All right, item 4.1 is action on major change requests to add a part-time program at the University of La Verne College of Law and Public Service. This item is being presented by the Office of Admissions Principal Program Analyst Natalie Leonard. Is Natalie here?
Natalie's been promoted.
Congratulations, Natalie, you've been promoted. Go ahead, please. Whoop, we took it away. See, as quickly as you're promoted, you can be demoted.
I think she realized she wanted to change her background.
There we go. Go ahead, Natalie.
Okay.
Welcome.
Thank you. So I'm here with Paul to discuss several items. The first of these is a request from the University of La Verne. Our Dean Kevin Marshall, is here today. He does not plan to make a public comment, but he is available for questions. This school is an accredited law school located in Ontario, California. They are very focused on in-person education, but they have for some time successfully offered online courses as well for electives to broaden the possibility of electives that are available. All of their programs right now take place during the week. They have a full-time in-person program during the day, and then they have a part-time program that takes place during the evenings on weekdays. They would like to add an additional part-time program that would allow for more access to more students in the Inland Empire area. So that program would, for the first time, offer a Saturday component. So those students would attend a Saturday in-person day, and then during the week attend one additional course synchronously. So it would still be live, much in this format for Zoom. So that keeps their commitment to their preference for an interactive education, but it provides a new avenue for the type of person that cannot commit to during the week schooling. The school was very transparent, very detailed, very careful in constructing this program to ensure that students of the Saturday program would have every opportunity that the people that are studying during the week would also have. The one exception is that the school offers 2 clinics, and those Saturday students, if they would like to take a semester to participate in the clinic, would need to have weekday availability for that. They're not required to participate in the clinic to graduate. The school offers the full complement of 15 hours of competency training through the Saturday envelope. But if they want to do that, that remains available to them. They were very clear in the proposed materials. Students would know up front that that opportunity would require some weekday availability if they want to take advantage of that option. So based on the thorough nature, the similarity to their current programs, which are fully compliant, and the strong performance of the school, the staff recommendation is to grant the request. And Paul, do you have anything else to add?
No, thanks.
Hey, Natalie.
Sure.
The term synchronous training, what is that?
So synchronous is what we're doing right now. It's a live interactive interchange versus a taped program.
Got it. Okay.
And that's one of the distinctions we're trying to build into the new rules is we don't care so much whether you're face-to-face or face-to-face over Zoom. We think the value is just about the same versus asynchronous is where you're reading materials and, on your own speed and you're not interfacing with others live.
Excellent. Okay. Thank you. Is there any discussion?
Chair.
Do I have a motion?
Chair, this
Oh,
is Vince.
go
I'd
ahead.
like to move the motion, please.
I'm sorry, Vince, you're making the motion to approve?
Yes, motion to approve.
And is there a second?
James Bolton, second.
Okay, moved by Member Reyes, seconded by Dr. Bolden. I see the resolution on part of the screen, on Cody's screen. There we go. All right, who's running this show? All right. Is there any further discussion? Devin, call the roll.
Bolton,
Yes.
Burns. Burns.
Yes.
Cow,
Yes.
Gongora,
The record should show that Member Gongora had to step out of the meeting for a brief period of time for a previous commitment.
Kaplan,
Yes.
Kramer,
Yes.
Lawrence,
Yes.
Lee,
Yes.
Masiwala,
Yes.
Montgomery,
Yes.
Peak, not present. Reed,
Yes.
Reyes,
Yes.
Reyna,
Yes.
Silva Guzman,
Yes.
Smith,
Yes.
Yokelson.
Yes,
With 15 yeses and 0 nos, the motion passes.
thank you. Item 4.2.
Thank you. So this item concerns San Francisco Law School, which is part of Alliant University, a larger online program that is based in Southern California, but also has roots in Germany through Bertelsmann. The San Francisco Law School for many years operated as an independent law school in San Francisco. It later became a part of Alliant, took several forms, but more recently, the school is largely focusing on its psychology and education schools. And as a result, shortly after transitioning to approval for a registered unaccredited JD program, it decided to exit the JD market, and it has not enrolled any JD students since the fall of 2023. There are no students currently enrolled there, so they have asked to voluntarily withdraw their registration, and that is encompassed in the motion. There's another element of the motion, which is this. While they do not plan to operate a JD program or offer any programs or courses at all that would work toward bar qualification, they would hope to offer some programs in their school with proper and clear disclosure that they are not bar qualifying that may have overlap with their other programs. So, for example, the psychology school coordinating with the law school to indicate the psychology of a proper deposition, things like that. That's a novel thing we haven't seen before. We've seen them be very upfront in their plan, though we don't have specific plans from them yet. They seem very clear to place a disclosure, but yet this is something that is new to the committee. So there's a suggestion in the motion that that type of a plan should be discouraged, and staff proposed to the school that they would choose the term legal studies. They prefer to maintain the heritage of the school name, San Francisco Law School, and the compromise that staff recommends is the attached motion, encouraging them to reconsider and discouraging the use of that name in the name of consumer protection. Paul, anything to add?
Yeah, the proposed motion also asks staff to explore whether there's statutory or other avenues to ensure that when a school uses the term law school, that it is capable of issuing a degree that would qualify one for the practice of law. I'll just say I looked in a couple dictionaries, and law school always seemed to be about qualifying people to be lawyers, not helping psychologists or talking about forensic practices or any of those other things.
When I saw this, I had considered perhaps denying their request to withdraw their registration so they would remain under our jurisdiction. But it was pointed out to me that then they could still call themselves law school. We'd go through the process of disqualifying them, and we'd be right back to where we are here.
And they might quit paying their fees, in which case then we'd have to go through that long disciplinary process that I talked about.
So this is, from my point of view, this is unfortunate, but I think we're doing the best we can in the interest of consumer protection to let the public know that even though they're retaining the names law school or school of law, this is not a bar qualifying curricula.
So I don't know, does the dean or representative of the school wish to speak, Natalie?
They provided all of their input in writing, so they planned not to appear today.
Okay. Are there any other comments from any other members?
Natalie, I guess I had some questions. One is could a withdrawal be contingent on them doing certain things, such as, changing the name? Like, is, this withdrawal, we say yes if you, meet one or two qualifications? And then two, if a student goes to the school and thinks they are getting a JD or something that would qualify them to take the bar, does that come back under our jurisdiction if that student makes a complaint?
Okay, two great questions. So as to the first, we looked into the possibility of a contingent withdrawal, and recently there was a clarification as to the committee's jurisdiction that was focused around the JD program and schools with a JD program. This particular situation a school with the law school name without a JD program wasn't contemplated. And so there doesn't seem to be a way to be a contingent type of possibility. We certainly can continue to monitor them. They don't have a specific proposal on the table as to which courses they would be offering. But if they were to represent that they were bar qualifying, but they don't offer a JD program, it would be handled much like in the attorney practice area, unauthorized practice of law, where OCTC would work with the appropriate district attorney. Here, it wouldn't be the district attorney, it would likely be the Bureau of Private Post-Secondary Education or WASC or their institutional accreditors. And we have actually already opened a conversation with those agencies, letting them know about this plan. Those are their two current accreditors. They didn't have a specific proposal to look at, but they indicated that they do have a concern to be sure that programs are labeled clearly and accurately. They couldn't say more without something on the table.
You know, we could add this to our legislative wish list as well. That would be the clearest thing, a statute that says law school is this and not that.
Yes, and I think that was the thought behind that resolution that you had mentioned, is we could explore, if it is the committee's will, explore a statutory change that says, in order to call yourself a law school, you have to, it's an ABA accredited law school, a law school accredited by the committee, or a law school registered by the committee. We could propose that kind of legislation. There is, just for the committee's information, there is, for example, a statute which says, in order to call yourself legal aid, you have to meet these criteria. So there are those kinds of statutes. This wouldn't be beyond the pale, I wouldn't think. If you sort of think about other kinds of statutes regulating who calls themselves certain things. And so this could certainly be something that we would put on the legislative priorities list for the board to approve and then start working that proposal up.
Could we just deny them the title of law school? Would that be a problem?
Well, we can't. The problem is once they've withdrawn their registration, they are outside the jurisdiction. This committee has no jurisdiction over them. So no, the answer is no. We can't deny that ability once they're outside our jurisdiction. I know there's a resolution, or a motion and a resolution. Can we post that?
Yes.
Okay, should we add in there Paul's suggestion about a legislative priority?
Well, statutory is
Or
already
statutory? Whoops.
Yeah.
Yeah, so we'll bring up the motion, and I'll direct your attention, of course, to the full motion, but in particular to the final paragraph. And it addresses not only the term law school, but also Julianne's concern about making sure that students and prospective students both understand whether the school's programs will offer them the possibility to qualify to take the bar exam or not.
For the language, could we add that staff will reach out to, I'm sorry, now I forget the agency you mentioned who covers higher education, but that the staff will make some kind of statement to that agency as well about our concerns, just so it's kind of flagged for the future because I assume once they're not under our jurisdiction, they'll come under that agency's jurisdiction as just a higher level education.
Yes. That would be the Bureau of Private Post-Secondary Education, BPPE, identified in the memo, and then also the WASC, Senior College and University Commission. And we can forward this communication and continue to keep conversations open with them.
Yeah, and if I could add, certainly it's the committee's will as far as what language we include here. I think the intention of the third part of the resolution saying exploring legal, regulatory, and statutory, it was meant to capture kind of all of these opportunities. So whether it's pursuing statutory amendment or I think regulatory kind of addressed our ongoing engagement with the regulatory entities that kind of have jurisdiction over this school. So that would include the Bureau of Post-Secondary Education and as Natalie mentioned, the accreditor. So I offer that to say I'm not sure if we need to add that kind of level of specificity, and I just want to share kind of the intent of that language here in the resolution.
Okay, Julie, is that satisfactory?
That's fine with me. Yeah, I just wanted to make sure that, we're kind of, looking at this in a forward-facing way, before issues come up, I guess, and if that's, something the other agencies should be aware of.
I think we made a pretty good record here, and I know staff's going to follow up.
Of course.
All right. If there's nothing further, is there a motion to approve the resolution?
This is Judge Reyna. I'll move.
I'm sorry, who was that?
Judge Reyna, I'll move.
Judge Reyna moved.
Second.
Member Lawrence seconds. No further discussion. Devin, please call the roll.
Bolton?
Yes.
Burns?
Yes.
Cow?
Yes.
Gongora? Kaplan?
Yes.
Kramer?
Yes.
Yes.
Lawrence? Lee?
Yes.
Misiwala?
Yes.
Montgomery? Peak? Not present. Reed?
Yes.
Reyes?
Yes.
Reyna?
Yes.
Silva Guzman?
Yes.
Smith?
Yes.
Yokelson?
Yes.
With 14 yeses and 0 nos, the motion passes.
Thank you. Next on the agenda is action on the inspection report, item 4.3, Taft Law School. This item is again being presented by Natalie Leonard. Natalie?
Thanks, Alan. So Taft Law School is a registered unaccredited school that's located in Santa Ana, California. It's a correspondence school. You don't see as many of those. They're not required to have any live component to their study. So before we talked about synchronous interactive like this, they've chosen a correspondence format. They have 2 tracks in their school, a directed program in which there are specific due dates throughout the semester, and then an on-demand program where the student suggests the schedule that will be appropriate for them, and then the school follows up. The first of these is eligible for student loans under the Title IV program through their accreditation as an institution with the Distance Education Accrediting Commission. The second is not eligible, and generally unaccredited programs are not eligible for Title IV student loans. The school was inspected in the summer of 2024. This is a longer time, gap time between the inspection and the time that we bring this to you here. And just so you understand the reason for that, the school was under further investigation and deferral by their Distance Education and Accrediting Commission. We collaborated with them, each operating independently under our own rules, to be able to fully complete our investigation. And then the State Bar followed up with additional staff questions after the completion of that. The school was last inspected 5 years ago. There were 11 recommendations which they did handle, but this time there were 15 additional. And so it is the team's it's the team's recommendation and also staff's recommendation that this is a school that benefits from clear and consistent oversight from the committee and frequent progress reports. Therefore, rather than a 5-year renewal, the inspection team and staff recommend a 3-year renewal through October 2028, as well as not only annual progress reports, but because the annual reports were just submitted now, a 6-month progress report. The school accepted the report in full and provided a response demonstrating the steps that they have taken so far. We do believe that the scaffolding needs to remain in place. Evidence of this for me recently would be that when the disclosure was provided in November for this year, we found several omissions and several incorrect data cells, and we worked with them to correct those. They were very responsive. They handled it quickly. They reposted quickly, but they did need that additional scaffolding. So we believe with the 6-month and then annual reporting schedule, and then returning in 2028, just after DIAC, that this will provide a strong framework for continued improvement. I'd like to turn it over to Paul to talk about some of the observations that he and Vince had in helping to prepare this item for you today.
Yes, could somebody put up the proposed motion with the revisions we talked about?
Yeah, so Paul, we've added the text that you have requested, and you can see it in a red line format. So the committee has the original staff recommendation motion that's posted on the agenda, and you can see the revised motion here.
Okay, so this, yeah, it's in this Cody's case, it's purple. Anyway, when Vince and I looked at this, again, discussed it with staff to prepare it for presentation to the committee, we thought that it's really important to highlight some aspects of the need for improvement. And thus this paragraph, can you scroll up enough so we can see it on our screen here? Which highlights basically attrition, concerns about high attrition before graduation, and also not very healthy results on the first-year law students exam. Interestingly, if the students who do graduate do pass the bar exam at reasonable rates, not ABA levels, but they would satisfy our minimum performance requirement, our NPR. So the problem is that a lot of people are just not, making it through all the way out the door to be able to take the bar exam. And so we want to call this out specifically to make sure that the school understands that when we next look at them in 2028, we are going to be wanting to see improvement in those two measures and also other aspects that relate to the quality of their educational program. In our rules have a general requirement that they have a sound program of legal education, and the guidelines flesh that out. And they refer to student performance, and elements of student performance are, of course, whether they're able to or choose to make it through the program. And because this is a registered school, they have to pass the first-year law students exam. So this effort is simply to call that out, put it front and center, so they know, we remember next time that we're really going to be looking at this for improvement in this area, and then we'll see where we go from there.
Yeah, Paul, I just wanted to add part of our discussion in the committee is I agree with you calling this out so that it's very specific and the school understands our concern. But the thing is, we're not putting a specific deadline on anything. What we would like to see is an upward trend that attrition and some of the other items are moving forward with good trajectory. And that's why it's also a lesser amount of time, 3 years rather than 5 years for the next inspection.
Any questions, comments?
May I ask a question? It's more, I think, for both staff and the law school's clarity. What I hear, and I just want to repeat it, is that this resolution doesn't add any requirement of the school or the progress report, but that you are kind of spotlighting an element of its progress report and calling it out explicitly. Because I just want to point out that the inspection report calls out the attrition rate and first-year law students exam passage rates, and then the resolution requires that they provide a progress report on all of the recommendations within the inspection report. So this isn't an additional requirement. This is just calling out among the they already included recommendations to include in future progress reports. You're just pulling this out to kind of shine light on these two elements.
Yeah, it's in this case a purple highlight.
Yes.
And I'll point out that the previous inspection identified the same issues. Correct, Natalie?
Yes, it did so in a more informal manner. It was not a formal recommendation, but they were urged in the text of the report to look at the retention. Since then, there's been a retirement of a longstanding dean. Another dean has come in, significant change, and there's a more formal and specific recommendation in this report.
Okay, so it's a concern that as we've held for longer than just this most recent inspection interval, and so we want to.
Yeah, I just wanted to add that I appreciate all the work that went into the inspection and the transparency of the school to try to address all of the items. But yet, again, to reiterate, we want to see upward trends in improvement, particularly on attrition.
Thank you. And I don't believe that Dean Jolly prepared a statement, but I know that she is here and present. Devin, I cannot see the audience, but can you advise whether or not she is raising her hand to make a comment? If not, she advised that she simply is here for any questions that the committee may have. She'll be under Taft Conference Room. It should be Taft University.
I see them present, but we do not have any raised hands.
Okay, thank you.
All right. Is there any further discussion on the resolution? Do I have a motion? Anybody?
Accept the motion, this is Vince.
I'll second the motion. This is Justice Maciwala.
All right, Vince Reyes moves, Justice Maciwala seconds the resolution. To be clear, this is as amended. Devin, please call the roll.
Bolton,
Yes.
Burns,
Yes.
Cow,
Yes.
Gongora, Kaplan,
Yes.
Kramer,
Yes.
Lawrence,
Yes.
Lee,
Yes.
Maciwala,
Yes.
Montgomery,
Yes.
Peak, not present, Reed,
Yes.
Reyes,
Yes.
Reyna,
Yes.
Silva Guzman,
Yes.
Smith,
Yes.
Yokelson.
Yes.
With 15 yeses and 0 nos, the motion passes.
Thank you. Let's skip over to item 5.1, oral staff report. Donna?
Thank you very much. Can someone share the presentation that Tara and Cody and I are going to give? So we're just, the plan today was just to give you a few updates on information since the last Committee of Bar Examiners meeting. So we are going to start with an update on the July 2025 bar exam results. Obviously, you all received the results when they went out, and the State Bar published a press release on the results. We wanted to highlight just a few things here. Next slide. Overall, between the general bar exam and the attorney exam, there were 7,740 exam takers. For the general bar exam, which is the 2-day exam, the non-attorney exam, 74% of the exam takers were first-time takers, 26% were repeaters. Typically, for a July exam, it's about 2/3, 1/3 first-time takers and repeaters. The pass rate for the general bar exam, as you can see on this slide, was 1 percentage point higher than the pass rate same time in 2024, so 54.8% pass rate. We have a bar graph on the bottom of the slide that looks at that pass rate, the total pass rate, By total exam takers at 54.8%. For first timers, that pass rate was 69.7%. And for repeat takers, it was 12.4%. That 12.4% represents a marked decline from the prior July exams. In July 2024 and July 2023, the pass rate for repeaters was roughly double that at about 24%. So that was a significant decline there. One of the things that we looked at to provide some explanation for this, we know sort of generally, right, there was a much higher pass rate for in the February 2025 exam, and so potentially people who passed that exam who maybe would have been in the cohort who passed the most current exam. And so we looked at were the people who were repeaters for the July 25 exam, had they taken more bar exams? Because we do know the statistics tell us that as the number of bar exams creeps up over 3 and then keeps creeping up, the more exams you take, the smaller likelihood that you have of passing. And so when we looked at the pool of repeat takers for the July 2025 bar exam, we found that on average the repeat takers they had taken 5.1 exams on average, which is an increase from July 2024 where the repeat takers had taken 4.8 exams. So that could help explain the significantly lower pass rate that we did have people who were retaking more times. So that's just sort of some overall information about the pass rate. And then on the next slides, we have some breakdown of information. This was preliminary information based on the law school type for the non-attorney takers. And I say it's preliminary because once as we were releasing the bar exam results, we also send the lists to the law schools and have them confirm that we have allocated the bar takers correctly to their law school. So there could be some minor changes to this data as we finalize it, but this was the preliminary data showing the different pass rates by exam taker type and the law school type. ABA California, out-of-state ABA law schools, the California accredited law schools, and the unaccredited law schools largely. The next slide looks at the bar exam pass rates by race and ethnicity, again breaking it down by total exam takers and first-time takers. And then the final slide looks at it by gender. When we presented these slides to the Board of Trustees, they asked us to do some crosstabs to see if the because they were particularly troubled by the differing pass rates by race and ethnicity, and wanted to see if that was more potentially attributable to the law school type. And so we are running that data. My memory is that we've run that data in the past, and it did not. Even accounting for law school type, there was a lower pass rate by people of color. And so that is something that we'll look at and we'll bring back to the committee at a future meeting, and use that as a sort of discussion point to figure out if there are next steps that we should be taking to help improve, that we could be taking to help improve those pass rates. Tara.
I'm sorry to interrupt, but I have a quick question. I suppose a question followed by a suggestion about pass rates, if you don't mind.
Of course.
Okay, so I apologize for bringing this up again, but I'm hoping to touch on the testing accommodations point that we made before and not moving it up in the schedule. I don't necessarily oppose leaving it where it is in the schedule, no problem, but my understanding is that there were 4 exam cycles with relevant data for this determination collected, and that you, Donna, said that at multiple meetings that the relevant parts were implemented to assess the fall 24 administration. So uh, my question, I guess, is could you provide a little bit of clarification on how much of the new rules for testing accommodations you have started implementing after the prior revision was approved by the board in November 2023 and after and and I have a follow-up question after that, unless I am interrupting the meeting and as a point of order you'd like me to move on, in which case no sweat.
So this does largely relate to the work plan item, but I certainly don't want to ignore the question. Christina Dole, if she is in the audience, is prepared to answer this question. I expected it to come up during the work plan, and so I asked Christina to be ready. I don't know if she's still.
I can speak to it a bit, Donna, while Devin sees if Christina's available or not. But so this has been an iterative process, Josh. For example, we did implement the automatic approval for other high stakes exam. However, when we initially started, the threshold was lower. I believe it was at up to time and a half. However, now it's up to double time as well as up to a semi-private room. We did not implement the different timelines for the appeal processes, as well as there were a couple procedural things in the rules, such as not sending the second appeal to this person who reviewed the first, who did the first review. Just under the current rules, it was permissible, and for timing's sake, part of the reason that we're waiting is because we're fully implementing all of the rules going forward starting in December. So although the process, we started implementing it back after the board approved the rules, we haven't had the benefit of the full process being in place for the full exam cycles. Hence why we put it at the end of next year. So that way we'd have both February and July data to look at.
Okay, that makes a lot of sense. I appreciate it.
Justin, you said you had a follow-up?
Well, yeah. My follow-up question, I think Tara addressed it, was essentially that the board, or I guess the committee and the staff members in particular, previously noted that only two cycles of exam data were likely to be necessary to determine whether or not the rules implementations were effective, and now we're looking at four. But if there was a ramp up period for implementing all of the new rules, and then I understand why that timeline would have been stretched out a little bit. So no sweat. Thank you.
Okay, thank you. Donna, you want to
Sorry, Alan. Hi, I just got promoted as a panelist. Can I just also just throw in there as well? We are currently educating not only our applicants on our new process, but the law school. So we've been meeting with some of our law school deans and registrars also just to get them educated on our new process. So there's less back and forth with the applicant missing the required documentation and things like that. So that is part of our education and gearing up towards our new rules, and we should be ready to go, as Tara mentioned, in the 2026 with some metrics and some data on the timelines required.
Excellent, thank you. Donna, you want to continue with the first year exam?
Tara, I think, was going to take it from here.
Yes, thank you, Alan. See. Okay, so as you know, we also put on the first year law students exam. And just as a quick reminder, so that is a much smaller exam than the bar exam. It's held twice a year. It consists only of multiple choice questions right now that are split into sections. The group that takes this exam are those who attend an unaccredited registered school, study through the law office study program, or they do not have the 2 years of undergrad college work, and they attend a Cal or an ABA. And currently we are administering the exam through Prometric. However, as the exam administration subcommittee is aware, our contract with them ends after the June administration of last year, and hence why we're seeking another vendor. They could also apply, of course. So here are the numbers for our most recent exam, which was in October. So for the first year law students exam, the default testing method is in person, just based on the population that we have. However, we do allow applicants either out of state or for other handful of reasons to be able to test remotely. So we had 74% testing in person and 26% testing remotely. Only about 2% of the applicants experienced scheduling or technical issues that required staff support. It's a very small number, so I won't get into specifics, but generally either issues with thinking that they scheduled a session or the session not starting maybe exactly on time where staff had to get involved. The results will be released next week. And then we have some preliminary data from the survey from these applicants. So a couple highlights, about 70% of the applicants were satisfied or very satisfied with the Prometric software. 88% of them said they had no proctor issues. For the 12% who did, it was generally the same. It was either unclear instructions from the proctor, delayed response time from them, or the proctor appearing uninformed about a matter. However, 72% of the applicants who responded said they were either satisfied or very satisfied with the exam experience overall. And then finally, I just wanted to note this for the committee. They might find it interesting when asked for their preference on how they would like to take a future administration of the first year. 47% said they would prefer to take it in person at a Prometric test center, whereas only 39% said they wanted to take it remotely. And any questions on that before I move on?
All right, seeing that.
Judge Reyna
Chair,
has
I have a
I'm
question.
sorry. I'm sorry, Judge Reyna.
That's okay. I just have a question because I don't know if it was a couple years ago now that we went to the all multiple choice. And now I know we're talking later on today about, changing the bar exam or how we're going to go forward with that. I just can't recall in terms of who's writing or how we're procuring these multiple choice questions. How are they? Are we still doing it the way we used to through, I can't remember if we did it through law professors or how we did that, or is Kaplan involved? I'm not sure that we talked about that. And so I was curious on.
So where are the questions coming from?
Right.
Is that the question?
That's the question. Thanks, Chair.
I can speak to that. For the questions for the first year law students examination, we have a pretty extensive bank of multiple choice questions. So there hasn't been like a new question development effort since I believe 2022 or 2023. However, questions have been reviewed and kind of refreshed at that time by subject matter experts, some of them being our exam development and grading team, our EDGE team members. So essentially those continue to be kind of maintained internally using our kind of host of kind of our subject matter experts and consultants. There's no outside vendor for that.
Okay. And that's like the course we're planning to stay, it's not on the table, for example, with this discussion of the bar exam or how we're going to develop that. Is that a correct understanding?
If I understand the question, there's not a discussion right now about changing the way that the first year law students exam questions are developed, nor is there a discussion to hire a vendor to produce new questions.
Okay, great. Someone had asked me about that and that's why I'm raising it now. So thank you.
No problem.
Donna?
So I think we can then move on to the next slide.
Great. So I wanted to share some data and some insights from the legal specialist examination. Our chair mentioned earlier that CBLS is not going to be sunset, so the legal specialist exam, because it's not under the purview of the committee, we typically wouldn't bring this information to you. However, the 2025 legal specialist exam was the first where we administered it using the Prometric live remote exam platform. And so some of the findings from this administration, I think, are relevant to the committee as it considers the future of the bar exam. So first, I want to share some data just about the administration of the exam. We had 398 applicants sit for the exam. 79% of those tested remotely using their own laptop. 21% tested in person, primarily through a Prometric test center in California. 18 individuals experienced some sort of technical issue that required staff support where they were kind of initially unable to complete the exam. Of those, 17 of them were able to re-enter the exam or reschedule. We had about one that withdrew. I think at face that number is quite small, and that's good from an administration standpoint. But one thing that Donna mentioned at the Board of Trustees meeting that I think is relevant for the committee to consider, managing and kind of assisting those 18 applicants was a pretty monumental task. It required several staff members for that entire day to help kind of facilitate what they needed to get back into that exam. That's relevant, of course, because at kind of a larger scale with the bar exam, even at kind of a small percentage of test takers facing technical issues, the number of individuals that need support and the time it takes to support them may be a consideration for the committee in their future discussions. We will have results released March 13th, 2026. Both the first-year law students exam and the legal specialist exam were administered at the end of October. However, the legal specialist exam includes, it's comprised of 13 different exams with 8 essay questions each, along with multiple choice questions. So the grading process takes more time. It's a bit more extensive. What I did not get to include in kind of a visual form is that we also received some preliminary post-exam survey results. And I came with a number of statistics, but I should say generally they align with the findings that Tara shared. So we found that 51% of respondents who took the remote option were generally satisfied with the remote exam software. However, 30% of them reported some technology issue when writing their essay questions. Those kind of issues were typing delays and copy and paste kind of functionality issues. There was about a third of individuals who had a proctoring issue, and Tara covered these, but the same common issues arose in this survey, kind of difficulty communicating with the proctor or a delay in their ability to communicate with the proctor. And we found the same finding that when asked about a future exam, more test takers indicated that they would prefer to test in person as opposed to remote testing option. With that, I just will underline that this survey had about 150 individuals take it. It's a small number, and this population is somewhat different than our other test-taking populations. These are, licensed attorneys, generally older, perhaps maybe less familiar with kind of online testing compared to a current student. So there may be some limitations to these findings, but nonetheless, I think it's relevant and interesting to the committee. And that's it for me.
I just ask a quick question about the 18
Sure.
excuse me, the 18 candidates that you needed that needed additional tech support. Do we have any information about sort of the nature of those issues? Were they our issues, the state bar issues? Were they platform issues? And what can we learn anything from that with respect to how we approach online exams in the future?
Yeah, those 18 all had what we would kind of categorize as technical issues. I don't have the data kind of disaggregated, but I can just tell you from the kind of types of experience. There were some number who maybe just experienced a computer equipment failure and internet connectivity issue. So that, generally is kind of a user side issue. There were a number of individuals that were impacted by kind of a platform issue. So we had configured the examination in a way that when a test taker returned from a break, that they would perform their security check with the timer paused because their timer obviously shouldn't continue. There was some number of individuals where the proctor had difficulty restarting their timer, and so we had to get them kind of back into the exam in a new appointment where that timer could be turned back on. So that is kind of a platform issue.
Okay, thank you.
Michael?
Yes, I just think I missed hearing it. What was the ratio of the test takers that preferred the remote versus preferred the in-person? I know you said it, but I think I misheard it.
I didn't give you percentages, so that's a good question. I said that majority. I believe the numbers were 48% said that they would prefer to test in person. 43% said that they would prefer to test remotely, and then there was another group that said that they had no preference.
Oh, great. Thank you.
Anything else? Okay, Donna?
We have a few more slides for you here.
And I'm just going to give you a quick update on the February 2026 bar exam. It is upcoming quickly. So I have some numbers on the slides, but I have updated numbers for you as of last night. So as of last night, we were up to 4,672 submitted applications. Of those, 637 folks are using the waivers. So we do have quite a few applicants, more than we anticipated for this exam so far, and applicants have until January 2nd to apply. We have secured all of the test centers. I know you've seen along the way, we've been adding them as we go. So we do have more test centers for this February exam because we have a couple of smaller locations. For example, the Sunrise Banquet Hall in Vacaville is only a 200-person venue, and our USC Gallon Center is about 400. However, we felt it was important to have some location in those areas for applicants. So I don't know if there's any questions on this. That was just a quick update there. Not hearing any, and I'm going to give one more on our February 2025 applicants. And so as of last night, we had one more application submitted. So 56 applications submitted, 55 of them approved. And as a reminder, so these applicants are those who qualify for the program because they either were unsuccessful on or withdrew from the February 2025 California bar exam. They have until the end of this year to apply for the program, as well as have a passing MPRE score and a positive moral character determination on file. So again, this is one that the timeline was a bit truncated based on the order from the court. And if you do have anybody who is interested in the program who qualifies, the State Bar is actually recruiting 3 provisionally licensed lawyers, not in the Office of Admissions, but in some of our other offices.
Okay. Update from the Board of Trustees?
We'll start with Cody, and then I'll take over.
Thank you. Yeah. Well, the chair covered this, so I'll be brief. As mentioned, the board took action to retain CBLS, and so CBLS will be retained till at least 2028. At that time, a sunset review will occur. That's a 3-year window as opposed to the typical 5-year. Next steps, and I apologize, it says establish work plan today. That's not for CBLS. CBLS will establish its 2026 work plan at its meeting next Friday, December 12th. There'll be a focus on its mission to support access to justice as directed by the board. There's a number of interesting initiatives, and immediate next step will also be to fill a vacancy on CBLS at the upcoming board meeting.
Next slide. So statutorily, the State Bar is required to conduct 2 public hearings each year, one in Los Angeles and one in San Francisco, to invite proposals from members of the public on admissions, the admissions process, the attorney discipline system, and our professional competence, our regulation of attorneys. So the first hearing, our San Francisco-based hearing, was conducted on December 3rd. In Los Angeles, the hearing will be held on December 10. There were two members of the Board of Trustees present. The chair and vice chair were physically present, along with key staff in the San Francisco office for the hearing. There were a total of 2 public commenters, one in person and one virtually. Of those 2, one of the public comments was about the admissions processes. And so when I created the slide, I didn't know if there was going to be any admissions commenters or not, and what the subject would be, but there was one, and specifically it was the question. The comment from Mr. Cohn, who we heard from today, was about advancing the review of the testing accommodations rules to 2026, and not putting that off till 2027. He was strongly advocating for moving that review forward. And that was the only comment, admissions-related comment at the December 3rd hearing. We will certainly keep you updated if there are proposals related to admissions that happen at the December 10 public hearing. And then finally, last slide, I just wanted to provide you some updates. At the last meeting, there was a request that staff look at federal grants that are offered by the federal government to see if there are any grants available to states that would fund some of the admissions work. And we have done some preliminary review of the federal grants website, looking at open grants, looking at forecasted. They have a section of ones that they forecast that will be open, as well as looking at some of the closed proposals. And we will continue to do this research, obviously, and look at as new things come open. But there was nothing that is currently open, that is forecast to be open, or that showed up in the closed. We were looking under bar exam, licensure, character and fitness, a variety of key search words that revolve around the admission space to see if there were federal grants that were available to states that would assist us in our budget difficulties. I wasn't surprised by that result. Frankly, and one of the things that we have a couple of board members who have suggested, as has one of our committee of bar examiners members, that looking to private philanthropy may be a sort of a better approach. And I know I've got some board members who are interested in helping on that front, and a committee of bar examiners member who's indicated some interest in supporting us in any of those efforts. So that will, of course, be something that we continue to do. And I just wanted to make sure to update you and let you know that we had done that follow-up since the last meeting.
Okay.
Donna, just a question, in that vein of private philanthropy, does that include, like, say, foundations or any of that?
Yes.
Awesome.
Any other thoughts? Discussion? All right. That's pretty much the routine business, if we can call it that. We're going to get to the meat of the meeting next, which is discussion and action, if appropriate, on the roadmap to the future California bar exam. And this is going to be a very robust discussion. So we're going to take a break now and come back for that. It's about 25 to 11, or to 12, excuse me. We'll be back at 11:55, 5 minutes to 12, to resume the meeting. So let's all take a break. Thank you very much, everybody. Devin?
Hi, Alan.
Hi, okay. I think we're ready.
Are you enjoying yourself still?
Yep.
That's right.
Guys, we're going back. All right, thank you, everybody. We're back live. Item 4.4 is the discussion and action, if appropriate, on the roadmap to the future California bar exam. I'm going to turn it over to Donna now for some introductory remarks, and then we will hear from the folks from Nevada.
Thank you. So if we can, Devin, promote Richard Trachuk, Joan Howarth, Deborah Merritt, and also Danette McKinley and Louise Bari. And I'm going to do just some introductory remarks, and then I'll turn it over to Rick Trachuk and his team from Nevada. So we've set aside 3 hours today for the committee's continuing discussions about options for the California bar exam for the future. As the committee is well aware, the challenges that were faced during the February exam, which included serious technological issues as well as criticisms of the content of the newly adopted multiple choice questions, have led us to reevaluate whether we should recommend to the Supreme Court a different future path than the one we've been on, or whether to stay the course. In October 2024, the Supreme Court directed that we adopt a California-specific exam and identified the 12 content areas and 7 skill areas to be tested. The Board of Trustees and the committee have since begun the process of identifying whether any of the lessons learned from the challenges and criticisms of the February exam should lead us to recommend a different direction. For July 2025, for that bar exam, we returned to delivering the exam as we had been for the years previous, the MBE for the multiple choice sections, and our California essays and performance tests. Layered on top of the reevaluation that you are undertaking as a result of lessons learned from the February exam is the fact that we cannot, and I apologize for being a broken record on this, but I just feel the need to say it over and over and over again, we cannot continue in administering the exam that we are currently administering. The MBE ceases to exist as a standalone product after the February 2028 administration. In addition to that fact, we have a statutory requirement to provide 2 years' notice if changes to the bar exam are made that require the substantial modification of the training or preparation required for passage of the exam, and also an 18-month notice requirement if we change the vendor for the multiple choice questions, but without otherwise making a substantial modification. This means that we must change our current exam, and we must provide notice of that change no later than July of 2026. And that's why we have been on and continue to be on a course to develop a recommendation for the Board of Trustees and the court. We started this process by identifying 3 very high-level options. The first one essentially was to stay the course, which would be announcing our return to the Kaplan-developed multiple choice questions as early as February 2028, and deliver those along with the California essays and performance tests until such time as a new California exam covering the 12 content areas and 7 skill areas is developed, giving, of course, the required 2 years' notice about the composition of whatever that new exam would look like at that appropriate time. The second high-level option was adopting the next-gen UBE, and the third, adopting a streamlined California exam based on the Nevada model. We've since broken down those options much more granularly, as discussed in the staff report for today's discussion, and as also discussed in the survey that we conducted with the California Law School deans and the presentation to the Board of Trustees that was done a few weeks ago. And we'll discuss that granular breakdown of the options in a bit. But first, we're going to have a presentation from representatives of the Nevada Bar. We have set aside an hour for this presentation, just to give folks a roadmap here. After that, we will take a half-hour break for lunch. Then we'll come back and we'll have representatives from NCBE, who we have set aside an hour to have a discussion and presentation, just presentation from them and discussion with them on the next gen uniform bar exam. And then we have set aside a final hour for discussion with the committee, discussion of additional elements from the cost benefit analysis, and really focusing on and generating some real discussion on some of the key decision points that you all need to make. With that, I am going to introduce Rich Trachuk, who is I'm going to get the title wrong now, president of the Nevada Bar, and I'll let you announce those who are here with you today, Rich.
Thank you, Donna. Thank you, members of the committee. My name is Rick Trachuk. I'm the chair of the Nevada Board of Bar Examiners. I've served in this role since 2000. And with me today, I have Joan Howarth and Deborah Merritt. Joan is a professor emerita of Boyd School of Law, UNLV, the dean emerita of the Michigan State University Law, and she's been a member of our Board of Bar Examiners since 2020. Deborah Merritt is the Distinguished University Professor and John Deaver Drinko Baker Hostetler Chair in Law Emerita, the Ohio State University Moritz College of Law. Both Deborah and Joan have written extensively over the last decade or more on licensure for attorneys. And since 2022, the three of us have been working to put together the Nevada Plan for Licensure in Nevada, which our Supreme Court approved in May of this year. So without further ado, I would like to turn this over to Joan and Deborah.
Thanks, Rick. And thanks, everyone, for the invitation. So as you know, and just to give you a sense, we're trying to kind of go through our presentation in about 20 minutes and then have plenty of time for questions and discussion after that. So as you know, the Nevada Plan has three parts. First, a multiple choice test on the 7 MBE subjects, also a post-graduation exam consisting of performance tests and a modest supervised practice requirement. Knowing that change was inevitable, Nevada started its formal process in 2022 with a commission, then had 2 years of task force work and detailed reports, including work on the content scope outline for the foundational law exam, followed by our court's approval in May of this year. We then dove into FLE test development and administrative readiness for supervised practice. So we're at the end of year 4, with implementation beginning in year 5 and full transition in year 6 for the graduating class of 2027. By your target date of July 2028, we will have been licensing based on this plan for over a year. The key point of this timeline is that we are integrating legal education in preparation for licensure, a sensible notion. One of the reasons our plan is less expensive for candidates is that 2 of the 3 components can be completed during law school. The foundational law exam, the FLE, consists of 100 multiple choice questions on the 7 MBE subjects, testing 20 foundational concepts in each subject. This exam can be taken as soon as after 3 semesters of law school. Bar examiners have traditionally overemphasized memorization of countless rules, thousands of trees, many branches on the tree limbs, and even some of the twigs, without enough about the forest or the landscape or the paths through the forest. To follow cognitive science, we are reducing the memorization required and testing the number of concepts and rules that a thorough, well-prepared practicing lawyer must remember at any one time. Minimum competence requires knowledge of threshold concepts, recall of a number of rules, and the ability to apply those rules to new fact scenarios. This exam tests those skills. Testing during law school reinforces knowledge more securely. People who do not succeed on the FLE can get the academic help they need while they are in law school. The post-graduation exam will consist of 3 2-hour performance tests, the most authentic component of current bar exams. Nevada and California both have expertise in writing and scoring performance tests. The big and serious potential problem with performance tests is not giving enough time, turning them into another racehorse exam. Demonstrating competence in actual lawyering requires time for thoughtfulness and care. If California didn't want to keep writing your own performance tests, you could adapt Nevada's. The fact that jurisdictions do not already require any supervised practice before licensure is impossible to justify other than by tradition and implementation fears. The Nevada requirement is feasible because most candidates will do it in law school through externships or clinics, and pro bono opportunities exist for the others. This may not be the most urgent piece on your agenda, but I hope you will keep it on the table for investigation. When we're serious about our public protection mission, supervised practice prior to licensure is a no-brainer. Nevada's primary goal is to protect the public from incompetent lawyers. To protect the public, we needed to use the best research on attorney competence, some of which is from California. We met early resistance to supervised practice, but we determined that addressing that resistance with a modest, feasible proposal served our public protection goals much better than trying to adequately assess client skills through a paper and pencil test. Staged licensing recognizes the learning curve that every novice needs to become competent and eventually expert. By giving adequate time to performance tests, we can assess more sophisticated lawyering work that more closely approximates the messiness of actual practice. As bar examiners, we know there are plenty of multiple choice superstars who cannot handle messy facts, legal ambiguity, or legal writing. Let's face it, the current MBE is mainly a test of academic knowledge and skills learned early in law school. Being able to analyze sanitized stick figure problems is a necessary skill, but it is certainly not sufficient. Actual practice is filled with complexity. By graduation, candidates should be ready for lawyering work. Solid national research shows what we all could guess: people with caretaking responsibilities, people with fewer resources, people who have to work for paychecks are substantially less likely to pass the bar exam than people who have the financial resources and lack of responsibilities to devote themselves to 2 months of nonstop studying. Even, and this is the most important part, even when controlling for LSAT and law school grades. Thus, the Nevada plan's streamlined features are highly relevant to California's concerns about validity, fairness, and minimizing disparate impact. Both the NextGen and the Nevada plan are psychometrically sound. They're both based on research about competence, and both have taken years of planning. In terms of testing, they're similar, although the two Nevada exams together provide an additional hour of testing. As to performance tests, in a sense, the NextGen is going backwards, finding only 1 hour for each performance test, necessitating less complexity in the questions and less written work to be assessed. But nobody thinks that new lawyers today need less focus on their writing. The most innovative aspect of NextGen is the integrated question sets. We're familiar with these problem sets. Debbie actually wrote several of the first models for NextGen. We have 4 reasons for not using similar problem sets in Nevada. First, no matter how well drafted, a paper and pencil problem set about, say, client relationships is not as good as assessing how a candidate actually deals with a live client. Second, and relatedly, nothing in the problem sets requires a candidate to place someone else's interests ahead of his or her own, possibly the most crucial aspect of lawyer competence. Third, Due to AI and other pressures, this era requires a certain amount of nimbleness. NextGen is an integrated product with complex scoring requirements. The problem sets as part of this integrated exam lock NextGen into a particular design formula that rises or falls together. The Nevada plan gives you more control and flexibility to evolve with the profession. NextGen is not as nimble as to either form or substance. Fourth, we can accomplish very similar goals with performance tests by varying the tasks and the documents to be produced and including multiple documents of varying lengths. And Debbie is going to walk through the next few slides.
I am. I just had to find my unmute button. Thank you, Joan. So as Joan explained, and I think you know from the materials, there are three parts to the comprehensive licensing exam in Nevada. The multiple choice test taken during law school or after law school if one wants to wait, the performance test that she was just talking about, and the supervised practice component. What I'm going to do is to tell you a little bit about the FLE, the multiple choice exam in law school, because I know that's of particular curiosity to you, how we did that. So here's a quick overview. We started with an exam blueprint that was approved by the Nevada Supreme Court. And this blueprint laid out the basic features that Joan has already discussed. It's 100 multiple choice questions administered in 4 hours. It will cover the seven subjects that are currently tested on the MBE. It will test almost exclusively federal law and majority rules rather than Nevada law. That was the Nevada Supreme Court's expressed desire. The question formats parallel those of the MBE and other bar exams. So there's a fact pattern that requires test takers to recall an applicable legal rule and apply that to the fact pattern. And the exam will be equated over time in the same way as the MBE. Our next step was to create a content scope outline. You have a copy of that outline in your materials. For this task, Nevada used law professors, including the two who joined me here today, Joan and Rick, but all of the law professors who worked on our plan combine expertise not just in legal subjects, but with some hands-on law practice and experience with assessment. And two of our members were also bar examiners, Rick and Joan, and we had experts from across the country working with us as well. There are three key points about the outline that we put together that distinguish it from other exam outlines and that we think make it especially effective. First, before we decided any rule that we would test on the exam, we decided how much recall would be reasonable for this exam. There's been a lot of criticism of the bar exam for requiring too much memorization. The cognitive science literature agrees with that. So we looked deeply into the cognitive science literature, along with the studies of lawyer incompetence, to decide what would be reasonable. And we decided that it would be reasonable to require new lawyers to recall 20 concepts in each of these 7 areas with the rules associated with those concepts, which makes it much more than 140 concepts when you put together the rules. If you look at the outline in the materials, which is 83 pages long, you'll see that it does cover a lot of material, but it's a manageable amount for new lawyers to understand and recall, and it's comparable to the amount of material that any practicing lawyer keeps live in their memory at any one time. If you try to test more than what we have on this outline, it's really not constructive. In fact, it can be counterproductive. If test takers try to memorize more than what we have here, they are less likely to remember any of the material once they have finished the test. Second feature is that our outline spells out the specific rules that will be tested on the exam, not just the concepts, but the rules. So before we began drafting any questions for the exam, our subject matter experts agreed on the specific rules we would test. We didn't just agree to test the concept of third-party beneficiaries, which Rick told us was particularly important to keep on the exam. We relied upon him and other experts to lay out what exactly are the rules. What do you need to know about third-party beneficiaries? And then we did that for all 140 concepts in the outline, as you'll see in the materials. Third, and very important, we made this outline public. It's already on the Nevada website, and we're sharing it with others. That transparency is important for several reasons. First, it provides notice to test takers, and we hope reduces their need to rely on commercial bar prep companies. They don't have to take a bar prep course to find out what will be on the Nevada FLE and what the rules are that they need to apply. Publishing the outline also provides a check on the knowledge of our subject matter experts. If we're wrong about the rules governing any subject, smart lawyers, judges, and law professors are going to tell us, and we will update the outline. Of course, we've been very careful in putting together the outline because we don't like to be called out, but the outline is public to hold us accountable. Now a few details on how we've gone about drafting the questions to match this outline. We again chose team members with expertise in both content and question drafting. We think that this combination of expertise is essential. There are lots and lots of lawyers and professors who are experts in a subject, but most of them have little expertise in drafting questions that are suitable for a licensing exam, which is different than drafting questions for your own course in law school. Now, you can try to compensate for that by having testing experts who review questions drafted by subject matter experts, but that's cumbersome, and it actually sometimes leads to mistakes because of the communication breakdown or misunderstandings between testing experts and the content experts. Now, we do use pure testing experts with the FLE in the final review of our questions, but we start with subject matter experts who are also well educated on how to write questions for a licensing exam. So we're trying to get it right from the beginning so that it will be even more perfect by the end. Combining these skills also allows us to keep our question drafting team small. We're using 2 to 3 experts in each subject for a total of about 15 subject matter experts. The research in cognitive science and management science to suggest that this is the ideal size for a project like this. Sometimes people think more the better, but having more people on a team leads to what we call social loafing, that nobody takes their role too seriously. We have a team that's closely integrated and small enough to work effectively together. Finally, we trained our drafting team with a style guide based on best practices drawn from the assessment literature. We've also provided that to you in the material so you can get a sense of the care we've taken to drafting these questions. This is an outline of the steps of our drafting process, and I'm not going to walk through it all. You see it involves multiple layers of review. I just want to note 2 of the steps. You'll see first that we do allow our drafters to use artificial intelligence, but only if they use it, what we say, lightly and wisely. In order to do that, we developed for them a proprietary AI program that the company Prometric develops and maintains for us. And that program is trained on our outline, not on the web generally, on our style guide, and on our sample questions. And the program does not generate fully formed exam questions. Instead, it gives the drafters new ideas to work with. Here's 10 different stems, here's 8 different possible options. So these questions are all written and reviewed by humans. The AI is used only at the very beginning. If a drafter wants it, they don't all use it in order to generate some ideas. And then I also want to highlight the 5th step on this slide, which is that we had each question reviewed not only by other subject matter experts in that field, like my evidence questions being reviewed by another evidence professor, but by 4 to 5 team members in other subject areas. We found that's a really good way to pick up ambiguities in questions. The other team members are also very good at making sure that we have stuck to the outline, or if we need to add something to clarify the outline, that we're able to do that. We're now actually in the pre-testing stage for our first set of FLE questions. The pre-test itself will occur in January. We've just finalized the forms to get that ready. After the pre-test, where we will have 450 subjects, both current students and practicing lawyers, taking the exam, a psychometrician, of course, will do a full set of analyses and advise us on problematic questions. We'll either revise those questions or discard them. We'll also use data from the pre-test to aid bias review. We've done work on bias already, but we'll be able to do more after the pre-test. We are gathering data on race, ethnicity, gender, first language, disability, and several other characteristics from our pretesters. So data from the pretest will allow us to pinpoint questions with a disparate impact in any of those areas, and then go back and review those questions closely to see if there are sources of bias we can eliminate. We also have a tentative commitment from one of NCBE's very best multiple choice question editors, someone I worked with and I did some consulting with NCBE. She will perform, she's left NCBE, and she will be performing a second technical edit on our first set of questions and then continuing to work with us as we build our question bank. Now, before I hand this back to Joan, I want to highlight 4 features that we have found essential to draft the highest quality multiple choice questions. This may be helpful for you, whatever of your 3 options or 9 options you decide to go with. First, I can't stress enough starting with a detailed outline rather than just a list of topics. Without an outline, the subject matter experts will simply drift to more and more esoteric rules. We like to think of innovative things. We don't like saying the same thing over and over again. An outline is what keeps a focus, a detailed outline, on the knowledge that new lawyers need for entry-level practice, rather than whatever ideas the subject matter expert happens to be thinking of that day. Second, it's essential to, or at least important, to choose question drafters who have expertise in both legal concepts and assessment. There are people out there with those dual expertises. Third, choose subject matter experts who are collaborative. You can't draft high-quality questions if you're thin-skinned and defensive. Our team members take a very collaborative approach. They welcome input from other team members, knowing that it will improve our overall product. And finally, I do recommend using a proprietary AI program to kickstart drafting. If it's used properly, AI will expand your expertise rather than undermining it in any way. Now, in our last few minutes, we're going to lay out 3 different ways in which California might benefit from the things we've just told you, and Joan will get us started.
Great. Thanks, Debbie. The Nevada plan process is streamlined for candidates and for California potential adoption. We've already got a public outline in the first 210 questions for our bank ready for pre-testing in January. The only 2 areas of the outline that are Nevada specific are statutory, Nevada's comparative fault statute, and Nevada crimes. It would be easy to swap in California's comparative fault rule and the equivalent California crimes. You already write performance tests. As to the rigor required of candidates, though, streamlined is really a misnomer. The 2 exam components of the Nevada plan require more depth, more writing, and even more hours being examined. You and your court are seeking transparency, fairness, and you want to minimize disparate impacts. Performance tests could concentrate on the non-MBE subjects identified by the court. In fact, a subject like employment law has so many state and federal components, statutes, regs, that performance tests are the obvious way to test it. Separating components allows candidates to retake components that they fail. On the other hand, the Nevada plan is challenging because it does require competence in each component without compensatory grading. People are embracing Nevada's design not because it's easier, but because it's more fair to candidates, more focused on lawyer competence, simple, smart, really actually sensible. Efficiency for the state bar and cost saving for candidates cannot be the driving forces, but they also cannot be ignored. Public protection is always the driving force, but sustainability and continuity require efficiency and cost control for the state bar, and fairness requires licensing that is much less expensive for candidates. Debbie?
Yes. So another option, apart from adopting the Nevada plan, pretty much as we have laid it out in Nevada, would be to borrow from Nevada's staged approach and adapt it to meet California's needs. Research has suggests that the type of staged exam we've designed is much more effective in assessing and maintaining competence than a one-shot exam. You're not studying everything all at once, spewing it out, and then going away and forgetting. We're actually reinforcing the basic concepts shortly after students first learn them in law school, since they could start taking the foundational law exam within halfway through law school. So similarly, if you did a different type of staged exam, you could benefit from that type of setup. A staged exam also eliminates some of the barriers that reduce access to the profession. As Jonas said, candidates with disabilities and caretaking responsibilities, they will have more options for when to take parts of the exam. We're offering the foundational law exam 4 times a year, the performance test twice a year, but these will be at different times and it will be easier for people to mix and match their licensing. We also believe this approach will reduce reliance on expensive bar prep courses. And we think that a staged exam may also be cheaper for California to administer than a one-shot exam. This is something obviously you will be better able to look into than us, but if you spread out your testing and so that you're not testing everybody on everything on the same 2 days, you might be able to succeed with using testing centers rather than rented sites or remote testing, which causes so many difficulties, or did for you in February. Maybe things will start to get better for that. If you create a staged exam, you can also design components that meet your own assessment goals. One component, for example, might be a multiple choice exam available during law school, like Nevada's FLE, but testing a somewhat different mix of subjects based on what your Supreme Court has outlined. Another component could be performance tests based on California law or on some of those other subjects. As Joan suggested, a performance test on employment law makes a lot of sense. You could have 2 different modules that are both performance tests doing somewhat different things. One module, so you could have a 4-hour multiple choice exam administered at one time, a 4-hour performance test with 2 performance tests, and a third module that could be 2 performance tests that would focus on some of the things that NCBE is doing with the itemized item set. So doing drafting, doing client counseling, critiquing a negotiation script, critiquing a client interview script, things like that. Adopting a staged approach also allows you to do things in steps rather than all at once. You don't have to have the exam ready all at once. You can work on different parts of it. In particular, if supervised practice seems difficult to get in place, you could wait and implement that later under a staged approach. Although, do talk to us because we have found it much easier to implement in Nevada than anybody thought would be possible. Finally, something you might borrow from us is that we've offered you some suggestions, and we're happy to offer more based on our experience drafting a high-quality licensing exam. You might find these tips helpful if you decide to take on drafting your own multiple choice questions. These are also processes, I think, to look for when you're evaluating exams offered by other test makers. And as a reminder, these are the 3 processes that we have found particularly important, but there are others, of course, that we could discuss. And in fact, now we're eager to take your questions and hear your comments. So I will stop. Oh, I'm sorry, before I stop sharing, in the packet, since the slides are in the packet, and the slides I showed today are slightly updated. Donna will post the updated slides, but all the material is the same. We have some resources for you that you can check into.
Thank you so much. This has been very enlightening. We've heard so much about the Nevada plan, but we've never heard the specifics, so this was very enlightening. I want to start off, I have 2 questions. First of all, how many applicants do you generally have in Nevada?
A fraction of yours in California. Where are we now? It's 500 to 600 a year, I think.
Okay. Regarding the supervised practice, 40 to 60 hours is pretty minimal. What kind of practice would qualify for this? And the reason I ask is a couple of years ago, there were some proposals in California for supervised law practice. The proposed requirements were much greater. The hours were much greater. And frankly, it was found it was impractical to find programs for everybody. So what kind of hours or what kind of practice would qualify.
Right. The California proposal, I think you all called it TFAR. It was
Yep.
really for a full semester or 15
Yep.
credits. And
No, I think-
which is much broader than what we're talking about
Right.
here. The supervised practice, the key issue isn't the number of hours, it's that we have a list in the materials that we've provided for you in the reports, basically, that you can get off the main website. The key is to have to fulfill a number of particular activities that have to do with client responsibility. The only one that is absolutely mandatory for everyone is to counsel or interview a client. And then there's a menu of other things that include appearing in administrative or judicial proceedings and negotiation and other kinds of lawyering tasks. We found that when we looked at the law, we only have one law school in Nevada too, which obviously
Right.
helps us. But the 80% of the students who are already graduating would be able to have done it in law school based on what they were doing already in law school, because it could be either through a clinic or an externship. Not any externship, not any clinic, because it isn't really just about counting up hours, it's about having had that client responsibility.
I was thinking, for example, in working in a local prosecutor's office, you could get significant experience presenting preliminary hearings, making court appearances, and speaking with victims, interviewing victims. But that's not the same as interviewing a client. So,
Right, and our rules actually say that for a prosecutor's office, or the rules that I think the Supreme Court is poised to adopt, say prosecutor's office interviewing witnesses can substitute. In other words, we want to make sure that working as a student lawyer in a prosecutor's office, or I guess in California it would be a certified student. We want to include working in a prosecutor's office, and the prosecutors have been very supportive of this plan.
Interesting.
I'd add just a little bit more about that because I'm familiar. I think you were also referring to the supervised practice provisional licensees in California. And this is very different from that program because those are people who are being supervised after graduating from law school and only in that context. The supervised practice in Nevada can be done in any type of practice area, although Nevada did choose to limit it to pro bono or, working for clients who are not paying in some way, but you could choose to do that differently. But you could have a pro bono trust and estates client, for example, as long as you're interacting with the client, either in a law school clinic or in an externship or in a summer placement in a firm. It's not limited by practice area. And I was actually, I directed a prosecutor's clinic in the law school that I taught at. So I have always been there with the rules about how talking with a complainant is very much like it's different than talking to a client, but it shows the same kinds of skills and ethical constraints that we want to consider.
Yeah, I just remember from serving on TFAR, it seemed to be, it was very difficult to find pro bono placements but then again, we were talking about a much more significant commitment. Anyway.
It was a much more significant commitment, and I guess I'd also say that law schools have invested more in experiential learning in the last decade.
That's true.
And that also is relevant. And we're really talking here about something that could be done in an externship for credit. It could be done in a clinic for credit. It can also be done in a private law firm when you're a summer clerk. We can't be certified in our Nevada rules as student lawyers if we are working for a paying client, but any law firm can take on pro bono cases and work with their student attorneys under our rules on pro bono cases, and that also is another way to certify. So there's a broad range.
I don't want to monopolize. Yeah, I think some of the other committee members might have questions. Anybody? Or not? Okay, Paul. And then I'll ask Michael.
Okay, so your old test, what was that? Was that the UBE?
No, the old test was this Rick Trachok. Like California, we've always written our essay questions, and since 2020, we've written and prepared our performance tests. We've used the MBE up until the pandemic, and when we immediately switched to remote testing, we didn't offer the MBE for, I think, 5 or 6 offerings of the exam. But other than that, the only component we've used from the NCBE was the MBE, and up until 2020, we used one of their performance tests.
And we've been using 2 performance tests, 2 Nevada performance tests, along with 6 essays, 6 one-hour essays, and the MBE. That's what is currently in place in Nevada.
So, okay, thanks. I'm tempted to ask you why you didn't go to Next Gen, but I think that's unfair to Next Gen because we haven't heard it from them yet, and so I'm not going to do that. But in your presentation, there was talk about calibrating the performance test results. How can you calibrate if you don't have a contemporary additional test like a multiple choice test?
The psychometricians are obviously the people who we rely on for this. And the answer is that you cannot have a reliable performance test exam if you're relying on the kind of scoring that has been relatively loose historically in performance tests. What you need is a much more standardized rubric. You need more training related to the use of that rubric. You need standard setting as to the grading of the performance tests, and none of that has been done in most jurisdictions historically because of all the scaling to the MBE and even the standard. I'm not familiar with what the California process has been related to the rubrics for performance tests, but what we are in the process of doing in Nevada is, in a sense, regularizing, systematizing, and in a way, further professionalizing the grading of the performance test so that we'll have enough data points and secure enough processes, careful enough processes to be able to have a standalone performance test exam. It's quite possible. It's just a very different set of reliability procedures than the scaling to the MBE.
And Paul,
And
if I might, we haven't scaled to the MBE since 2020. Even though we're using the MBE, it's a 1/3 weight on our exam, and we do not scale to the MBE. We work together with our psychometricians, which I believe you also use, the same psychometricians, to do the ensuring that we have both reliability within the exam and from exam to exam.
It sounds like you work harder to level up the difficulty of each individual question as you create them rather than adjust for difficulty variations when you're scoring.
Exactly.
That's part of it.
And the members of our committee, many of whom have done this for over 20 years on our committee, and so we have this history, and we have the recollection of what we've been doing in the past, taking a look at the data from our previous exams, and so that's been helpful for us, that so many of us have served for such a long time.
And I think you can ask them when they come after lunch, but I don't think that NCBE will be scaling performance tests to other parts of NextGen. I think that it's because scoring has advanced so much in the last 20 years. So rather than having to scale an open response like a essay or a performance test to something else, you use very carefully constructed rubrics. That's what Nevada does now, and what NCBE will be doing. They've been moving towards that, I'm pretty sure, but what they certainly will be doing under Next Gen. And then you train the graders, you have them score sample exams using the rubric, and then you give them feedback, and then you actually track on a platform. I can't say for sure that NCBE is doing this, but this is what I think what we will be doing in Nevada. You track what as somebody is grading, and you can send them a signal saying, hey, you're getting off. You're starting, we're comparing you, and you weave into the exams that they're grading samples again that they're going to grade. So there's very good ways of tracking people in their grading of performance tests that none of us thought of, 30 or 40 years ago. And then after the exam, you can also account for the fact that if all the scores on one question are much lower than on another question, suggesting that that question was too hard, there's ways to adjust for that psychometrically that don't involve scaling to multiple choice questions.
Okay, my biggest concern is how we could possibly scale the supervised practice aspect to the volume we have in California, which is probably 20 times what you have, somewhere in that range. And I noted that I reviewed Donna's presentation, our Donna's presentation to the Board of Trustees meeting in November. And Donna, do I have it right? You seem to be dismissing the supervised practice aspect as an option because of that concern?
So I had the same sort of reaction that you did, that it sounds overwhelming to be able to think that we would be able to implement it in the same way. And so what I was suggesting was perhaps an online module if we wanted to do some other way to test client counseling or other skills like that. But I believe that Debbie and Joan do feel like that California could implement a supervised practice component similar to the one that they're doing in Nevada. And so certainly hearing from them why they think that that's viable is more valuable than hearing my fear that we can't.
So yeah, let me address that if I can. And then Joan and Rick may have ideas too. You have more than 20 times more law schools than we have in Nevada. It's not the question of how many applicants you have, it's a question of how many opportunities to do supervised practice. And for people people in schools from other states will do their supervised practice in the clinics and externships in their state. So it doesn't all rest on California schools. The other, and you also have, for the people who don't do it during law school, I'm sure you have more than 20 times more lawyers and legal aid and public defenders and prosecutors than in Nevada. One thing to focus on is that the supervised practice in Nevada is not actually graded in any point sort of way. It's really a proof of experience that somebody has done certain tasks. And so there's somebody who is filling out a form certifying that somebody has done these tasks. And there will be graders, there is a part of it, who will be reviewing the journals that people write. But that is actually that's much more enjoyable than grading bar exam essays. I think that Nevada won't have trouble finding people to do that, and I suspect you wouldn't either. So it may not be quite as big a lift as you're imagining for supervised practice. It's not portfolio grading the way that the current, that supervised practice that we have in Oregon and in some other states are. It's very different from that.
What I would say also about the grading is that it's really is essentially a kind of a pass-fail with a very strong focus on diligence. So what we can tell, what's really important about this is we can absolutely tell if somebody isn't taking seriously their obligations as a certified student lawyer. And that's exactly the time that we want to get that information, right? And say no. So the supervisor needs to be able to certify that they don't, has to attest that they don't have any problems about their, nothing was raised that caused a problem with professional responsibility and ethics. And the other piece of it is that, at least in Nevada, it was crucial for us to overcome the early resistance by having a lot of conversations with bar leaders and with particularly with public interest communities, because the pro bono focus of this is putting weight on, in some ways, into the public interest world. And what we were able to accomplish is to listen, make a really very modest requirement, and then get the enthusiastic collaboration from legal aid leaders. And so one reason that we're confident about what we're doing here is that we have legal services providers across the state who are already excited about offering certain modules in their offices of currently unmet needs, so that those opportunities will also be available for anyone who didn't think about doing this while they were in law school. So instead of sitting in, say, Barbary for 2 months, they can go to a legal aid office and work under the supervision of an experienced lawyer handling a temporary restraining order matter. Or the other thing that has been identified as a urgent need that's also a small matter is eviction defense. Small matter, urgent, and it happens quickly, perhaps too quickly. So I think that if instead of thinking of it as something that needs to be figured out by 2028, I would think about supervised practice in California as almost independent project, because no matter what you do, I think, no matter what you're doing in terms of paper and pencil testing, I believe it's hard to argue that public protection would not be served by having some sort of a supervised practice before people are unleashed with a license to do anything without any supervision. So it's a longer term with a lot of collaboration and discussion.
Thank you. Paul, before you continue, Michael's been waiting for a while.
Yeah, go
and
ahead.
we're running a little short on time. So Michael, why don't you go ahead with your next?
Oh, great. Thank you all. Welcome to California. I'm very glad to hear about this. I'm also actually a Nevada licensee, so I'm also a member of your bar. So a great privilege to have you here. I just have a concern, though, a little bit about scale for California. It's my understanding in Nevada, and this changed in April, is that you generally only permit ABA law school graduates to take your exam, except for a few very narrow pathways. We're the opposite. We have many law schools. There's 21 ABA, plus we have the California accredited schools, plus we have unaccredited schools, plus we have many avenues alternatively. I think our makeup of test takers is different. Does that, in your mind, affect the Nevada plan or the implementation of the Nevada plan, or how it would be appropriate for us?
Are you thinking especially about the performance test exam or the foundational law exam, multiple choice, or the supervised practice?
Well, I think really the first two is in our experience on our general bar exam, the ABA pass rate is in the 80s. The other level is in the 30s, and it's consistent over years and years and years. So that's a concern, I think, for our committee. And I'm wondering, how does this, if it addresses this or concerns that this poses?
I think you could find out if you wanted to. I mean, the purpose of the bar exam is to protect the public by imposing certain standards that people need to meet. We believe that the current bar exam is imposing a standard that is really not, doesn't fit anymore with law practice. And so we've designed these tests to be somewhat different. If we're right about law practice and our tests, and if the California accredited and unaccredited law schools are in fact effectively training people for practice as it is today, then their pass rate should go up. But we won't know on our pretest. We did limit the pretest to people who will be graduating from ABA accredited law schools. If California is interested in doing something like the Nevada plan, or even using, if you wanted to use our Nevada FLE, you could do a pretest on your tab, not ours, but it's a lot cheaper than, I can assure you that it's cheaper than buying questions from NCBE, questions from Nevada. So you could do a pretest in California that would have both people from all of your different pathways, your different educational streams, and see whether you see any differences, and then decide whether you think the differences are problematic or the differences, in fact, reflecting some kind of difference in practice.
Well, the other thing I would say is just in terms of the experience we have on the performance tests. As you note, in Nevada, we only have, or with a very few exceptions, we have ABA accredited law school graduates. We have plenty of, I'm always distressed at how many of those ABA law school graduates are not able to pass our performance tests. So it's not as if performance tests are somehow a walk in the park.
In fact, you might find, we may find, that pass rates go down because the current bar exam is compensatory. If you're a really good multiple choice taker, you can be a really bad writer, and you could still pass the current UBE, the current Nevada bar exam, and probably next gen. We'll have to see what happens. That's not our aim. Our aim is to make it better tailored to both, to bring together, just put together in one stream, legal education, the bar exam, and practice, and to really protect clients. But there is that possibility. It's possible that the pass rates for ABA schools accredited law schools will go down if they happen to have a lot of people who are really good at multiple choice tests. I see some hands in the air, but I don't know who's calling on them.
I see San Francisco. Is that Julia? Or
Hi, this is Julie. Thanks again for presenting for us. Appreciate that. I just had a few quick questions. As far as, does the FLE need to be taken before the practical? I'm just imagining someone from out of state. I see.
Any order of timing. It's just that we think that people who know they want to come to Nevada will want to get it out of the way, but you can take it after the performance test exam.
And for someone who's already barred and practicing in another state, how does that work as far as the practical? Do they self-certify, or they still need to do certified practice?
We have rules for those practitioners who are now coming into Nevada. And if they've practiced for a certain period of time, then that would satisfy the supervised practice component. And then they would be required to take the multiple choice and the performance test.
I think it's only 6 months, and then they're excused from supervised practice. It's not 4 or 5 years like waiver is in other states.
And then for the FLE, I think it's in the materials, it's saying that some of the code sections will be provided. Is there like a packet with all the code sections in one place, or are those codes provided only in the relevant question that relates to those codes?
So the codes are provided for the criminal law, substantive criminal law questions. That actually tracks what NextGen will do. I was a member of the content scope committee for NextGen, and I and the other people who had taught and worked in criminal law urged that we shouldn't be testing people anymore on common law crimes or on the model penal code because we actually prosecute people with statutes in the United States rather than under the common law by and large. And so on Next Gen, there will always be code sections provided for criminal law, substantive criminal law questions. So we decided to adopt the same approach in Nevada. On the Next Gen exam, they will be, from the state of Columbia, some statute. What we're doing instead is, yes, the statutes are actually on the website now as part of the outline. And when people take the exam, our exams will be administered through Prometric, which has a platform very nice, similar to the ones that are in the NCBE slides. We didn't have any slides to share from Prometric yet. The statutes will be there available for you to open up if you want on any criminal law question. They won't open up on other questions so they don't distract you.
And then for the practical, apologies if it was in the materials, is that just essay format or is there going to be a series of short answers? How are students answering the performance part?
That will be, you'll be given a series of tasks. So it won't be short answer. It's very similar to what California is doing now. Well, asked to draft a complaint or asked to draft a bench memo, or there's some task that is called out for in the instructions, and then part of the evaluation of the exam answers will be the writing ability, writing clarity, and things like that.
Okay.
Sorry.
Go ahead, Julie. Was there one more question?
Just so that for AI, you're only using that on the multiple choice, not using that to draft any of the performance questions?
Yeah, but I wouldn't say AI. We're using AI tools. We provide the universe which is our 85 pages of the rules and these 140 principles, foundational principles of the 7 subjects.
But we have not been using AI in our drafting of performance tests. But I would be silly of me to try to predict what might be done in 5 years.
Sure.
And then one more question. For the supervised practice, do the applicants need to state who they're going to be practicing under first, and then you approve, and then they do it?
Exactly, and that system is already, the structure is being put up because since the supervised practice can be done during law school and will be for most people, for the class of 27, currently 2 Ls, but mainly, we already are setting up the processes for them to be able to obtain the supervised practice experience through the state bar for spring 2026.
And that's all I had. Thank you.
Okay, thank you, Julia. I think Judge Reyes?
Hi, thank you for your...
Judge Reyna, I'm sorry.
That's okay.
I'm looking at 3 different things here. Judge Reyna, yeah.
No, thank you folks for your great presentation. Just a quick question about scoring on the multiple choice. So essentially, well, first of all, essentially, as I understand it, someone just can take it as many times as they want after the 3 semesters until they pass that component.
Yes.
Correct. Okay. And then just wondering, because I know you talked about kind of the psychology of a little bit of the efficacy of multiple choice questions, or just the bar in general all at once at the end of law school. I'm just curious about the scoring. Have you planned to adjust what the passing score, so to speak, of the multiple choice is going to be in light of that thought process, and what is it?
We'll have a standard setting. We have standard setting sessions on the calendar for early 2026 to, again, try and use the same kind of best practices that NCBE uses related to scoring on having panels of people figure out what minimum competence looks like on the exam.
Okay. So at this time, you don't know if it's going to be, for example, higher, than what it
No,
would be.
we don't have goals of higher or lower. We have goals of better.
Okay. And then just a couple more, just so that I understand, maybe I missed it. Is the components of the PTs and the multiple choice going to have both a remote and an in-person testing option? I didn't know if I caught that.
Currently, we have the only way to take the multiple choice will be in testing centers with that exam offered 4 times a year, very similarly to how the MPRE, the multi-state professional responsibility exam, is offered. Currently, we will continue with twice a year in person on the post-graduation exam. But again, it would be foolish to predict where we'll be 5 years from now.
Okay. And then lastly, just with respect to the supervised practice, I guess, it seems if you only have one law school and you're doing, it seems, if I'm hearing correctly, a lot with the clinics through the law schools, could you just make it a requirement of the law schools to do that in order to graduate to satisfy that component? Or do you find the grading process of what the bar exam's going to do to be much different from what, if you could control the law school's requirement?
Well, first of all, I think one of my themes in my work related to licensing is that bar examiners should be asking more of law schools. And on the other hand, we can't give up all authority, right, and control. So, for example, there are the vast majority of clinics across the country in law schools the work that's done would count. But there's some so-called clinics in law schools, including certainly ABA accredited law schools. I'm really thinking about ABA accredited law schools, where the clinics are really just a different word for people working for a professor on whatever the professor's doing. And that's not going to qualify, right? So we can't just trust that the law schools we're not saying the fact that you call this a clinic and that a student put in 3 credit hours, that's not enough for us. What we need is an attestation of this student in this clinic did these 4 out of these 8 required things. And so that's the balance. On the other hand, it's not a lot of record keeping for the school, but it is a responsibility for the professor to sign off on the supervision of the student in the same way that an externship supervisor has to sign off, in the same way, really, that your supervisors of certified students now have to sign off.
All right. Thank you. Those are all my questions. Appreciate it.
Thank you. Ashley?
Hi, I have maybe 3 questions, but first, thank you obviously for all of the information. The first question, I know you mentioned that this process could reduce cost of testing, but has it reduced the pricing of your bar exam? Do you anticipate a reduction in whatever you're charging to the students as well?
No. In fact, it goes before our court next Wednesday, but the cost to register for the exam, we've designed it so that it's the same as the cost that we're charging today for an examinee.
Okay, understood. And
the savings is really, we expect the savings for students to come in terms of the amount of time and also the not having to pay commercial bar providers.
Sure, understood. And then have you had any or done any consideration into what disability accommodations would look like for the supervised practice and whether the bar would have, what role they would have in enforcing those kinds of accommodations for the supervised practice?
I think the accommodations would be actually better than for paper and pencil types of tests, because the accommodations would be ones that the law school clinics and the employers already need to provide under federal and state law. I also work with Oregon, which has a postgraduate supervised practice, much more extensive program. And we have not had any problems with accommodation requests because employers already have that obligation. But we do have an ombudsperson who can help if there is a problem, but it hasn't been an issue so far in Oregon. Good question, though. And it's one of the reasons why supervised practice, it's a real problem with these standardized, come and take this test at this time and place. We're providing, by the way, full accommodations for anybody who needs them for the pretest. So we definitely wanted to try that out and make sure that worked at the Prometric centers.
Definitely. Thank you. Yeah, and I think we had discussed an ombudsperson when we were considering, this during the Blue Ribbon Commission as well. So, yeah, that makes sense. Okay, those are my questions. Thank you.
Hey, thank you. And I want to thank everybody. Thank you for your presentations. It gives us a lot of food for thought. Thank you very much. And at this time, I'm going to adjourn us for a break. We'll be back in session at 1:25. Thank you very much, everybody.
Thank you very much.
Thank you.
Thank you.
Okay, everybody. Hi, Devin. I think we're ready to go.
Yes, we're live.
All right. Welcome back, everybody. Our next presenter, I think we're going to hear from NextGen. So, Donna?
Yes, if you could please promote Judy Gunderson and Kara Smith.
Donna, they've been promoted.
Thank you. I see Kara. I don't see Judy yet. There we go. Okay, so we want to welcome to the Committee of Bar Examiners Judy Gunderson and Kara Smith from the National Conference of Bar Examiners. They are here to present to us on NCBE's Next Gen Uniform Bar Exam. As we did with Nevada, we've set aside an hour for this presentation, for the discussion. We anticipate about roughly a 20-minute presentation and leaving the rest for Q&A with Judy and Kara. And so with that, I'd like to ask Judy and Kara to introduce yourselves and get us started.
Thank you so much, Donna, and thank you, Committee of Bar Examiners members. We very much appreciate the opportunity to speak to you about the changes coming up to the bar exam, Next Gen exam. My name is Judy Gunderson. I'm the president and CEO of NCBE. I've been there for 25 years. I've been in the role as president for 8 years, and before that, I worked extensively with our MEE and MPT drafting committees, as well as one of the MBE committees. Kara?
Hi, everyone. As Judy said, thank you so much for having us. We're so excited to be here to talk with you about NextGen. My name is Kara Smith. I am the Chief Product Officer at NCBE. I have been with NCBE about 1.5 years now. My technical training, my PhD is in psychometrics and statistics, but I've been in the assessment industry for a couple of decades, launching high stakes assessments in a number of industries, TOEFL, GRE, SAT I've worked in. So I'm excited to be here with NCBE working on NextGen. And I think, Judy, we were going to share a deck with the group.
Yes, we have a slide deck to share, and you have a lot of materials that we gave you, and our deck is actually pretty long, but we have culled the deck to stay within the strict 20-minute time limit. So the rest of the slides, if you want to ask questions about them, we have access to them, but we've made a shorter deck, and Kara's going to start sharing the screen. And so we'll tell you a little bit about the Next Gen exam, how we got here, what it is, what you can look forward to in this presentation, talking as well about what our delivery platform looks like and what sort of data you can use to drive decision making. Kara, do you want to advance the slides, please? So this is what we just talked about. This is a quick overview of it. So this is an exam built for modern competency. And this exam, I almost can't believe it, but we are going into year 9 for working on this exam. We started in January of 2018. The efforts to revamp the bar exam were started by the former Chief Justice of the Arizona Supreme Court, Rebecca Birch. She was our board chair at the time. So we're now going to enter year 9. We started with listening sessions in 2018, and we did a practice analysis, which we started in 2018 and completed in 19, right around the same time that California did its practice analysis. And our results actually were pretty similar. For our practice analysis, we had about 15,000 people. About almost 15% of those people were from California. They were California newly licensed lawyers or people who supervise newly licensed lawyers. We started with 179 tasks, 77 knowledge areas, 36 skills, and 24 technology competencies. Of those knowledge areas, 25 were sent on to the test blueprint committee, and 7 top priority competencies emerged after the test blueprint committee looked at all of the evidence and decided what to recommend to our board to put in the Next Gen exam. So it's been a long process. We've been working in test development now since about 2022. Next slide, please.
And so from both the practice analysis and all of the other work that's been going on with NextGen, we have worked really closely with the jurisdictions to understand the needs of the jurisdictions to ensure that NextGen is meeting those needs. So we have a number of guiding principles when we think about the development of NextGen. Certainly to increase the emphasis on lawyering skills. NCBE has always tested skills, but with NextGen, we're placing even greater emphasis on the measurement of skills. So we're doing an integrated foundational knowledge and skills blueprint, as you may have seen in the materials that we shared. We also think it's really important to maintain score portability. We think that there's equity in enabling examinees to move from jurisdiction to jurisdiction. So that's a core part of NextGen. We want to keep the exam affordable, of course. We also want to establish efficiencies for the jurisdictions. Today, we're focused on the exam itself, but we're also launching 2 new platforms, a jurisdiction portal and a candidate portal that will really create efficiencies in the administration of the exam. And then lastly, it's important that we build confidence in candidates. We know that exam day brings great anxiety. And so anything we can do to reduce exam day anxiety, even if it's just having all of the materials available for them to know what to expect on exam day, or to giving them enough practice or sample questions, time in the platform, all of that's really important. So these are sort of our guiding principles for the exam. As Judy said, we have been conducting research and development on NextGen for quite some time. This is just a very high-level overview of all of the work that has gone into this program. As Judy mentioned, in October of 2018, the practice analysis was conducted. We began pilot testing our questions in August of 2022. And so you can imagine between 2018 and 2022, a lot of work was done in the development of these questions. In October of 2024, as you may know, we hosted a large-scale prototype assessment where we recruited 2,500 examinees to sit across many jurisdictions to test both the delivery platform, the content, our capabilities, the administration of the exam, and it was a really valuable experience because the data that was collected from that prototype allowed us to then, in May of 2025, have information we needed to conduct a very large-scale standard-setting study, also conduct a concordance study, so that we could bring all of that evidence together and provide a recommended range for passing scores that we have been working closely with jurisdictions to help them think about what their passing standards will look like. And then coming up here soon in January, we are going to be hosting a beta exam where we are going to have about 1,800 examinees sit again. The reason we're conducting a beta exam, even though we already conducted a prototype, is that the prototype was conducted early stage development. We have since improved the delivery platform that we're delivering the test on. We have finalized our content scope. We have finalized our blueprint. And we've built those 2 platforms I mentioned. So everything that we're testing in January is going to be what we're calling a dress rehearsal of the actual exam, because we expect it to really mirror what happens in July. In fact, we already have candidates in the candidate portal doing all of their what we call ready to sit steps. So they're getting in there, they're accepting the candidate agreement, they're getting their information about the beta, they're downloading the secure browser, they're taking the exam tutorial. So we're really doing a full end-to-end integration test of all of our systems and our components, and everything's been working really well. And just to call out California's participation in beta, we have 63 examinees that reside in California. The beta is being hosted in Texas, Florida, Massachusetts, and New York. And even though we're only testing in 4 jurisdictions, we have 43 jurisdictions represented in the examinees that are traveling to those jurisdictions to participate in the beta test. And so 63 reside in California. And 57 of those 63 sat for the July administration in California. Everyone in the beta was required to sit for the July administration. You may also know that we have a brand new, really robust, really impressive scoring platform. So in addition to beta testing the jurisdiction portal, the candidate portal, the exam itself, we're also beta testing the scoring platform. We have looked to all of the jurisdictions to nominate graders that they would like to participate in the beta grading to get a sense of how the scoring platform feels, what double grading and adjudication looks like, if that's not a practice typical in that jurisdiction. And we have 15 graders participating from California in that grading process. After both the exam and the grading process, we're going to be conducting a lot of user experience research where we will be having surveys, interviews, focus groups with both examinees and graders to get feedback on how the beta program was for them. The reason we're running beta in January before operational launch in July is while we don't expect there to be any issues in the beta, we wanted to give ourselves enough time to improve anything that needed improvement based on feedback from examinees and from graders and administrators. We also, I should note, have about a little over 50 administrators from a number of jurisdictions coming to observe or help out at the beta so that they can provide feedback on the administration. So to Judy's point, a lot of research and development has gone into NextGen. And Judy, maybe you want to talk a little bit about the content?
Yeah, thank you, Kara. Yeah, so this exam is an integrated exam. It is a practice-oriented skills exam set in these 8, soon to be 9 foundational doctrinal areas. All of the doctrinal areas are currently tested on the NextGen bar exam. From civil procedure down through torts, those are the topics that are currently tested on the MBE. So they're tested in California on the MBE. Business associations currently is tested on the MEE, and business associations is corporations and limited liability companies and agency and partnership. And then family law is being added to the exam, and that will debut in July of 2028. Now, even though the topics are the same as what is tested on the current exam, the depth and the breadth of the content tested, which within each of those foundational areas is different. And on our website, we've had posted for quite some time the very detailed content scope outline, which goes over for each one of these foundational areas, what will be tested and how. And when I say the how, if something has a star after it, that means a candidate has to have recalled knowledge of that particular sub area within that topic. If there isn't a star, that means that a candidate will need to be able to work with the resources that we provide. That might be an excerpt from a statute or a case, part of a court opinion, something like that. So there will be some resources provided during this exam, and examinees are put on notice of what those topics will be. On the right side, these are the foundational skills that will be tested on the NextGen exam. Some of these right now, of course, are tested on the current bar exam: issue spotting and analysis, investigation and evaluation, and clearly legal writing. The other skills are skills that really are not tested on the current bar exam. And so these are the skills that will be added with the new components of the exam. Next slide.
And so to just share a little bit about what the exam looks like in terms of structure. The exam is a 9-hour exam. We have reduced the amount of time that the exam will take. We haven't done so at the sake of psychometric properties. However, the way that we're collecting information from examinees on the exam has just become more efficient. So for example, having 2 out of 6 multiple choice questions, we have measured the time it takes to conduct that multiple choice question, and it's the same, but we get more information about the examinee. So we were able to reduce the overall structure to 9 hours. And the way that we've set it up is for us all.
Oh, Kara, looks like Kara froze.
Am I frozen still?
Yes, you were. No, now you're good.
Okay, sorry about that. So as I said, I'm sorry if you missed this, but there are 3 sections: 3-hour section in the morning of day 1, 3-hour morning section in the afternoon of day 1, and then 3-hour section in the morning of day 2. Importantly, all of those sections are the same. So as Judy noted, it is an integrated assessment. Every section has 40 standalone multiple choice questions, 2 integrated question sets that include multiple choice and constructed response, and then 1 performance task, which depending on the section might be what we call a standard performance task or a legal research performance task. Candidates are able to navigate freely between all of those questions in each section. However, so for example, if an examinee thinks that for their time management, it's better to start with a performance task, they can start with a performance task and then move to the multiple choice questions. When that 3-hour section is up, though, they cannot return to that 3-hour section. They can move freely between that 3-hour section, and then once the section is closed, they move on. So now we're going to talk a little bit about the content development and review process.
Thanks, Kara. So we have had to add quite a few outside subject matter experts as well as internal lawyer editors to help us launch this exam. So with the integrated question sets, we have 31 subject matter experts. Now those people are divided between the folks who write the questions, write the item sets, and then the people who do completely independent of them external review for those to make sure that in fact they are properly vetted. Of course, all of our questions are pre-tested before they will ever appear on a bar exam where they count to any one score. Performance task and the legal research performance task, there are 18 subject matter experts, again, divided between the people who are writing the content and the external reviewers. All of our drafting committee members and our reviewers go through a substantial training period with anti-bias review and learning how to draft questions, how to write grading materials. So there's an extensive training period for this. The questions that you see with these abbreviations, business association, civil procedure, con law, these are the selected response or multiple choice writing groups. And those largely are the people who have been writing our questions for quite a few years, the people who've been writing the MBE questions. We've had to set up new committees to write the business association questions and the family law questions, but they're all essentially trained and doing the same kind of work. Now, the questions are changing from the way they were with the MBE. And I think now I would say probably we've been working on the new items on the next gen multiple choice items, which include the pick 2 of 6 for probably about the last 2 years or a year and a half. So at this point now, we are no longer working on old style MBE type questions. In addition to the people who do the drafting and who do the reviewing, we have people who are bar examiners and justices, and some administrators do policy review for both of these committees. And in fact, right now, Kara and I are in Washington, D.C. With meetings of 10 of our policy committee members. And so right now, the constructed response item set policy committee, which was newly formed, is here meeting and reviewing questions. And then there's also a similar kind of committee for the multiple choice questions. And I'll tell you that they really bring the jurisdiction perspective, the bar examiner perspective, the grading perspective, certainly for the constructed response items. And we do have a broad range of subject matter expertise working on this exam. I would say probably most of the majority of the people who work on our items are law school professors, but we have a great number of judges and practicing attorneys also working on this exam. And you can see that we have a California presence on our items. So both from law schools and a practicing attorney.
And so I won't go into too much detail on this slide, but as you can see, this is sort of the roadmap of what a multiple choice question looks like when it is being developed through to when it gets onto an operational form. The point of sharing this content is just to show that there is quite a long process. We ensure the psychometric properties, we ensure the fairness of the questions, and we're okay with questions falling out of the pipeline. We have a really, really high, what we call survival rate of questions because our drafters are wonderful. But if they don't meet our very high standards, we're okay removing them from the pipeline or improving them. And so the same is true for constructed response questions. With constructed response questions, we have the same long development process, really rigorous, really robust, getting a lot of perspective, a lot of feedback, making sure we go through those fairness and bias reviews before any of these questions ever make it on an operational form. This is also why the tests that we've done, like the prototype and the beta, are so important, and why we have so many examinees sit for these tests, because we want to ensure that we have the number of examinees we need to have that psychometric property stability with the sample sizes. And so by the time NextGen is launched in July, over 10,000 examinees will have tested questions that are going to be on that operation, that one form in July. So it's been really exciting to see all of the incredible testing and all of the incredible improvements that have been happening to the content pool. I did just want to take 1 minute to talk a little bit about the research and development we're doing around responsible AI. Like many organizations, we recognize that AI is an incredibly powerful tool, and we recognize the application of AI is going to be important in the future. Our position has been that when NextGen launches, none of the content or none of the scoring will be, we will not use AI tools on any of the content generation or any of the scoring. That being said, we are conducting a lot of research and development on AI generation and AI scoring now. We think it's important to start that research now so that when the technology is there, we feel that we'll have the information we need to make informed decisions in partnership with the jurisdictions that we serve. And so, for example, we are doing some content development, or doing some automated content development that is then going through our committees and our reviewers to just get feedback so we could better train our homegrown models inside of a really responsible walled garden. We're also looking at AI scoring. We're going to have 2 humans always doing the actual scoring of the questions, but then we're going to have a third AI scorer doing the scoring so that we could just start to see what that reliability looks like between the humans and the AI. And while the development of this responsible AI is incredibly important, as I mentioned, we are taking the position of not introducing AI into NextGen as we launch. I want to take, again, just a moment to talk a little bit about the delivery platform that we are going to be delivering NextGen on. Our guiding principles for the delivery platform are that it is stable, it is reliable, and it is accessible. It's incredibly important to me personally and to the organization as a whole that the technology never get in the way of an examinee demonstrating their proficiency, but rather that the technology enhance how an examinee can demonstrate what they know and can do and their skills. And so that's sort of our guiding principle for the delivery platform of NextGen. You'll have seen that we're going to go through some abbreviated slides here, and you have more content in the materials that were shared. But there are 2 things that we think about when we think about the delivery platform. The first is preparation, and the second is administration. Preparation is incredibly important because there is a whole host of research, and we even saw it in our prototype, that the more familiar an examinee is with the delivery platform, the features, how the questions render on the screen, what the real estate of the screen looks like, the more confident they're going to feel on exam day, the more prepared they're going to feel, and the more that they are going to feel that they can perform in a way that is appropriate to their demonstrating their proficiency. So we feel preparation on the delivery platform is important. And then certainly the administration is important, specifically as it relates to accessibility and accommodations. So when we talk about preparation, all examinees that are on a jurisdiction's eligibility to sit list are required to complete an exam tutorial. The exam tutorial takes them through each of the features of the platform, tells them how they work, what they might use them for, and then provides a set of sample questions. Those sample questions give them an example of each of the question types and lets them try out the different features that are in the platform. Now, this exam tutorial is available to anyone on the NCBE website, so anyone can access this exam tutorial. We just require it of examinees because we know use of the exam tutorial is related to their confidence and their performance on exam day. To give you a little idea of what the question types are going to look like on an examinee's laptop, what you're seeing here is the integrated question set. To call out a couple of the features, if you see that bar in the middle of the screen, we know that some examinees want more real estate on the screen for the content that they're looking at. And then once they've reviewed the content, they want to slide it over and have more real estate for their responses. So we're giving them that option. The panel on the left-hand side gives a lot of features like highlighting, copy and paste, things like that. The top of the screen is the navigation if they want to go to a different question type, for example. And then there's also a notepad, a digital notepad that'll pop up if an examinee wants to use that digital notepad. Here you can see the performance tasks. On the left-hand side of the screen, you can see that there are case files and a library that is always available to the examinee. Tabbed are the different resources that they can review. We've done a lot of user experience research since October 2024. This design has evolved quite a bit based on how we observed examinees performing on these performance tasks and based on their feedback. And so we've landed at a place that is resonating really well with examinees, and we're excited to see perform in beta. As I mentioned, it's a nonlinear exam, so there's always a navigation pane that examinees can use to both see the questions they have completed, see those that are partially completed, maybe those they've flagged for review, and navigate around the section in a way that is appropriate for their time management. We also feel that accessibility is incredibly important in a digital assessment. And so there are a number of built-in accessibility tools that are appropriate for all candidates. So an examinee can change their text size, they can change the contrast of the colors on the screen. We even have a timer toggle on the top right-hand side of the screen. We know that research has demonstrated that some examinees get great anxiety when they see the timer moving down. So if timing gives an examinee anxiety, they can toggle the timer off. It'll always come back on 5 minutes before the end of the section, so they're aware, but we want them to be able to hide it so that they don't have exam day anxiety. So there are a lot of built-in accessibility features. And then the last thing I'll say is that there are also a number of accommodation capabilities built into the delivery platform. So for example, if an examinee has been approved for stop the clock breaks, we don't want administrators in the room to have to count down the timer for the examinees. So we've built into the back end of the system that timer. Here, what you're seeing is an examinee might have 45 minutes of stop the clock breaks. When they click that capability on the platform, they'll see this timer pop up telling them how much more time they have. When they go back to the exam, it'll stop and it'll count down again when they start it again. At the end of those 45 minutes, it will tell the examinee, now your time is not going to be on the stop the clock break. We also have built-in capability for speech to text and text to speech. We've built a really great integration with ITS, our delivery platform provider, where when the jurisdiction provides us an eligibility to sit list, the data goes right to ITS that tells them if Kara Smith has an accommodation for a stop the clock break, her form will immediately have that capability in it. And so we are also testing in beta each of these accommodation capabilities to both ensure the integration is appropriate and ensure the capabilities are functioning properly. The last thing I think we'll talk about is data. I know we're running up to our couple of minutes, but I just want to say quickly that we're also thinking really deeply about the information, the data, and the insights that we share with jurisdictions who are adopting NextGen in terms of initial score send, our score transfer, and analytics and insights. When a jurisdiction adopts NextGen, after the administration, there are a number of insight reports they receive. What you're seeing here is the cohort report. The cohort report is information about every examinee that sat in that jurisdiction and their performance, both at the overall level, the total NextGen level, and in terms of the different subscores that we're providing as percentiles. There's also an individual score that's sent for each examinee that sits in that jurisdiction. And here you can see a little bit more clearly what that information is. I'll pop up the percentiles here. So in addition to the overall score, we provide the national percent below at each of these subscores. We think that this insight, this information can help jurisdictions provide more information to examinees who potentially may be sitting again for the bar exam to understand kind of why they performed the way that they did. This information is strictly up to the jurisdictions to decide whether they want to share with examinees, but we want to provide these insights to the jurisdictions so that you all can decide whether or not this is information that should be shared. Similarly, we share a full data file that has candidate data, score data, and percentile data. We want to ensure that you can use these data or match them to the data that you have to either conduct your own research in your jurisdiction or partner with the incredible researchers and psychometricians we have on staff here to conduct deeper research. So research around subgroup analyses, for example, or trend analyses. If these are the types of analyses that you want to conduct, we want to ensure that we give you the data that you need to be able to do that. And so I think that's where we were going to end, Judy, unless you have other comments before we open it up for questions.
No, I think that's great. Thank you, Kara. And again, thank you. We appreciate the opportunity and we're happy to answer your questions.
Thank you very much, guys. From the committee, are there questions, comments?
I wondered if you could talk a little bit more about the delivery platform and particularly the tech that underlies it. Like, is that a homegrown solution? Is it something, is it a contractor? And then what kind of steps have you taken or do you plan to take to stress test it? I think you mentioned your beta test has got 1,800 examinees, but of course, you know, in a live examination session, you're going to have many multiples of that, not just California, but, you know, across the nation. So could you talk a little bit about what's been done on that front?
Yeah, absolutely. Thank you. It's a great question. Beginning this calendar year, we partnered with an organization called ITS, Internet Testing Systems, they've been around for quite some time. If you're familiar, they deliver the TOEIC exam for ETS. They are delivering the medical exam. And so they have been around for quite some time. Before we even partnered with them, we load tested. And by that, I mean, we made sure that they could handle 90,000 tests at the exact same time. And that's the highest that we have load tested on. So we knew that it was a stable platform before we even partnered with them. And so when we partnered with them in January, we had a pilot test in April. We were able to get the delivery platform up and running before that pilot test. And so we first piloted the delivery platform in April. It was only 230 examinees completing the questions. But we saw from that pilot test that it was a stable environment, that all the capability held up, all the data flowed, all the core capabilities that we expected from a delivery platform were working really well. Then we were able to have another pilot test after that in August. We had enhanced the capabilities some, we increased the sample size, and still the delivery platform was stable. And then in January, we'll have the beta. But a couple of other things that I think are really important are things like security. So ITS has really, really important security measures built into the platform. That was one of our core capabilities that we examined before we decided to partner with them. And so we have a lot of, we don't want to share too much of it publicly, but we have a lot of capability inside there that ensures that our content will stay secure, that there won't be cheating. And so that was a really important piece of it. The other piece that we evaluated before partnering with them was around accessibility and accommodations, which I spoke to a little bit. The ITS has done a great job with accessibility and accommodations. We're actually in the process now of partnering with a third-party organization called Level Access that is doing an evaluation of the accessibility and accommodations of the platform so that we can offer a VPAT, a certificate to all jurisdictions demonstrating that the delivery platform not only meets WCAG standards, but exceeds them. So all of this to say, these were kind of the components of the delivery platform that we evaluated. Certainly the load testing is important. The other thing I'll say about load testing is that ITS has added additional servers. They have on-prem, their servers are on premises, so we don't have to worry about AWS going down, for example. And they've added additional servers to ensure that, we're not going to have any problem. Though with our numbers, we don't expect to, but just as a backup. Does that answer the question, or are there other details that could be helpful?
That's helpful. I guess you also touched on something else I wanted to ask you about. You mentioned test security, and I know traditionally NCBE has been very reluctant to make its content available for remote testing or in any kind of remote testing configuration. And I understand that's the case with NextGen, at least initially. Is there anything on the roadmap about doing that in the future, or at least offering it in a way that it could be offered more often than 2 times a year at specific locations?
Yeah, another really great question. Thank you. As it relates to remote testing, you're right. NCBE is not currently allowing our content to be remote tested. To be transparent, the technology is just not there yet. The security of the technology is just not there yet. I think that from my experience in the assessment industry, for lower stakes or mid stakes assessments, it is appropriate. But for a high stakes assessment like the bar exam, we're just not there yet. And the experience is just not there yet. I feel strongly, and Judy and I have talked about this, that I think that remote proctoring will get there. I think the technology will get there. I think the security will get there. And I think in the future, it is something that, we're going to continue to do research and development around. ITS, our partner in the delivery platform, does a great deal of remote proctoring for mid-stakes and low-stakes exams. And the CEO over there has also said, it's just not there for the bar exam yet. But we do expect that we'll continue to do research and development, and we expect that it could be a future pathway for us. As it relates to moving away from what we call event-based assessment, twice a year assessment, I feel strongly that's the future. I think Judy would agree with me. Right now, what we're working on is thinking about how we deepen our item pool. Content is the real key to getting there. And so we're looking at new and different ways that we can build content that is just as rigorous, just as high quality as it is now, in a way that could advance that a little bit. My goal is so I think that the steps that we'll take is that we're gonna do this when we launch. We're gonna keep the event-based testing when we launch next gen. We'll move to test centers, potentially windows in test centers, piloting that in some jurisdictions. Once we get through window-based testing in test centers, see if we can scale that for the entire bar exam. And then my hope would eventually be that we could potentially get to on-demand testing that would be at a rate that is when it works for examinees, but again, maintains the quality, the reliability, and the rigor of the exam we have now. That's our priority. But it is what we think our future is.
Yeah, thanks, Kara. I just want to add one thing to that, and that would be up to jurisdiction. So let's say right now the big constraint is content, but let's say a jurisdiction says, well, thanks, but no thanks. I don't want to have my examinees test at a test center. That would be up to a jurisdiction to decide that, but we'd like to be able to give jurisdictions that option, but that is a little bit of a ways off yet.
Paul?
Does the platform, you may have answered this, but I didn't quite hear it. Does the platform require a continuously on internet connection?
Thanks, Paul, for the question. Yeah, so NextGen is a completely online assessment. However, we recognize that Wi-Fi, as we saw in this meeting when I froze, Wi-Fi can go down sometimes, there can be bandwidth issues, and so there's a capability in the ITS platform called caching. What that means is, as I mentioned, there are three-hour sections. When a 3-hour section begins, an examinee has to be connected to the Wi-Fi. Let's say the Wi-Fi goes down at some point in those 3 hours, the content has been cached to their device. The examinee won't know that the Wi-Fi has gone down. They can progress through that 3-hour section as they were, even if they were connected to the Wi-Fi. Then when they get to the end of the 3-hour section, they do need to be connected to the Wi-Fi for those to make sure those data are uploaded. When connected to the Wi-Fi, the data are continuously uploaded. But at the end of that 3-hour section, if the Wi-Fi has gone down and it's not back up yet, we have operational protocols in place to start up a hotspot, and then the hotspot would help the data come up. So while the answer to your question is yes, NextGen is a fully online assessment, we have the caching capability that ensures that examinees who aren't online still can progress. And the last thing I'll say about that is, as part of beta in January, we're not only testing sort of what we expect to happen, which is the Wi-Fi will always stay up. We have examinees who have agreed to be part of experiences inside of the beta where we're going to turn the Wi-Fi off on them, and we're going to ensure that the caching continues, and we're going to ensure that their data get uploaded so that we can both test for ourselves and provide jurisdictions the confidence that even if the Wi-Fi goes down, examinees will still progress in the assessment.
I think you're cutting yourself a little bit short then. As I meant the question, your answer could be no, so long as it catches up. And,
so, yeah. I appreciate that. I think the reason that I hedge there is because Wi-Fi is required to start the section and end the section. And so because of that, I would suggest that Wi-Fi is required.
Okay, well, that's good. That would not work for remote proctoring, which
Correct.
is our problem recently.
Correct.
Yeah. Let's see. No, how are jurisdictions going to deal with the portable score? For instance, let's say we had your exam, but we had another 3 hours the second day with California specific subjects or whatever. How are jurisdictions talking about allowing that to work with somebody who brings in a portable score on the 9-hour portion?
Yes, that's a good question. Now, we have 41 current UBE jurisdictions, and so there's complete score portability among all those jurisdictions, provided you make the cut score, right? And the cut scores go anywhere from a 260 to a 270. With the next gen exam, there are 47 jurisdictions that have adopted it. Some of those, so there are current non-legacy UBE jurisdictions that are going to give the UBE, the next gen exam. And I think it's fair to say that they are in the process, I mean, truthfully, of figuring this out. I think one state that has made it clear that they want to give a local component on that open afternoon of day 2 is Virginia. Now, Virginia has also said, and this is through a court order, that that they want to engage in score portability. So exactly how that works, I'm not sure. You know, if you want to get admitted in Virginia, you're still going to have to take that Virginia component on that second day. So possibly a candidate would have to wait for the next administration and possibly only take that afternoon, that Virginia portion. I really don't know how that's going to actually work. There may be other states that do that as well. They're just in the process of determining that and figuring that out. And there are other states that might want to give a local component, but might do it, let's say, online or completely separate from when the next gen exam is given, so that lag in you know, the ability to sit for both parts at one sitting isn't an issue because it's going to be online.
Is your platform available to for a local jurisdiction to give its components via the platform?
Yes.
So ITS, oh, sorry, Judy.
No, go ahead.
Yep. So ITS is very willing to work with jurisdictions to think about what their local components look like. Some jurisdictions are really eager to work with ITS and have their local component, and law schools also have had interest in delivering their assessments on the delivery platform. Over the past year, NCBE and ITS have been working closely to get the platform where we wanted it to be operationally, improving the UI, improving the capability, improving all of the components that we found in research. So they haven't partnered yet, but now that we have a stable UI and now that we understand what the delivery platform is going to look like and feel like at launch, ITS is now engaging more with jurisdictions on that piece of it.
Thank you.
I had a question. I understand that each state would be responsible for grading their own exams.
Yes.
And how would we work calibration between the states vis-a-vis portability? In other words, state X has a reputation of grading one standard, state Y something different, something a little harder, so you go to state X.
Yeah, that's a good question, and we have done quite a bit of work with the grading. So with the legacy exam, everyone used a common set of grading materials, but every state had its own grading platform. You know, some were in-house, others they bought off the shelf from somewhere. We're providing the grading platform, so there will be a universal grading platform that everyone uses and very detailed rubrics for all the constructed response items. And the jurisdiction will be responsible for identifying the graders. We will have an extensive grader training. And in fact, we have graders who are signed up for the California graders who will be participating in beta. So you'll actually know a lot more about what grading looks like, even as early as February. It will be up to each jurisdiction if we'll be able to monitor the graders. But let's say there's a grader who's drifting maybe. and is not staying with the calibrated standards. And we'll know that because we'll be inserting validity papers that are unbeknownst to the graders where they are. And if a candidate, if a grader veers off of that standard, we'll let the staff know in California to say, gee, you might want to check with grader 2 here because it looks like they're not staying consistent with their fellow graders. So we're doing everything that we can to ensure that a score in New York is the same as a score in Connecticut and Missouri, everywhere across the country.
Donna has a question.
Actually, I have 2 questions.
Okay.
I'll tell you what both of them are. First, I would like if you could talk a little bit about the integrated question sets. In particular, I'm curious. We've heard mentioned medium length answers, but we don't know what that means. And so, if you could just give us an idea of sort of the difference between, sort of a performance task, which is we know what that answer may look like, but what's a medium length answer? And then, second, if you could talk a little bit about the double grading requirement.
Okay, sure. Those are good questions. So we do have some item sets on the website, and I think they're in your materials, but you can take a look at those. So they're question sets based on a common fact scenario, and there are 2 formats, right? So there's the drafting set, and then there's the counseling set. And we'll have some multiple choice questions, some short answer, and by short answer we mean literally like a line or 2. The medium length will be more like a paragraph. So we have 30-minute essays on the UBE, so shorter than a 30-minute essay question, but longer than a short answer question. And the drafting exercises as well will vary depending on what the drafting task is, but those won't be pages and pages long of drafting. So I don't know if that's enough information to answer your question about just how long that is, Donna. What a medium length response would be like.
And so the graders would be responsible for grading the longer answers as well as the medium length and the short answers.
Yes. The only thing the graders won't grade, of course, are the multiple choice questions.
Thank you. That's helpful. And then the double grading requirement?
Yes. So double grading is a best practice. And, a lot of states, and I actually don't know what the rule is in California, but I think you do maybe when you get all of your results ready, you maybe regrade people who are above or below, or at least right below the pass line within a certain standard. And a lot of states do that. You can still do that with the next gen exam, but we're kind of building in that regrading or the check on the grading to make sure that the grade is in fact accurate. We're building that into the system. So all materials all constructed response items have to be double graded. And we've done a lot. I mean, imagine, I know you think about how many candidates you have, and your graders are probably saying, oh my gosh, no, that's exactly what they said in New York. And we've done a lot of analysis over the testing that we've done with the prototype and some of the other testing. And we found that it doesn't take any more time for graders, in part because the items are shorter. So there are more items, but they're shorter. And the rubrics are very detailed. And so it's pretty easy to say, no, this doesn't get, or this is not a 4-point answer. This is only a 3-point answer. So the results that we've gotten back from, and the feedback we've gotten back from graders has actually been very positive, and people are sort of pleasantly surprised by the lack of increased time that this takes.
And would the 2 different responses be averaged? Would you go with the higher? What's the plan there?
Yeah, Kara, because I think we've got variances, and it depends on the item.
Yep, it does. It depends on the item. And in fact, inside of the item type, it depends on the item type, and then it depends on the actual item. Each of the items have their own scoring guidelines and rules. But when the 2 graders grade in what we call outside of tolerance, when they're too far away from one another and it can't be rectified between those 2 graders, it's not average, but we select, there's again, there's a method for each of the questions, but if they're outside of that tolerance, it goes to a third grader who is, well, and there are two options. It could go to a third grader who does adjudication or reconciliation and actually grades the question and then actually decides what the grade is going to be. Or in some jurisdictions, they're going with a team adjudication. So the two graders that graded outside of tolerance get together and talk about the response and talk about the question and come to an agreement on what that grade would be. So if it's inside the tolerance, there is a method for each of the questions. Outside of the tolerance, it's either team lead adjudication or team collaboration adjudication.
And that's up to the jurisdiction to decide how they want to do that.
Thank you.
Okay. Yeah. Josh?
Hi, thank you both for your time. I have 5 questions, all testing accommodation related. The first one is, what limitations, if any, does the NCBE impose on our authority to grant individualized testing accommodations to applicants with disabilities? And how might this vary between what you require for the MBE now versus what you require for next gen? That's my first question of 5.
Yeah, it's a great question. Our goal is not to limit the accommodations that you approve for your examinees. Currently, the way that we have approached this is we're working very, very closely with the July 26th, with the examinee, the jurisdictions that have adopted for July 26th to ensure that all the accommodations that they approve that are associated with the delivery platform are built into the delivery platform. We're also working very closely with the jurisdictions that are adopting in 27 and 28 to ensure that if we don't have capability in the delivery platform now to accommodate the accommodations they provide, we can build that in. So I think the short answer is that we don't expect to limit the accommodations that you can offer your examinees. We are, however, very focused on scale. We know it's important to be able to scale. So I'll give you an example. Jurisdictions offer stop the clock breaks. And that varies by jurisdiction, how much time they allow for stop the clock breaks. So we're working together with all of the jurisdictions to come to an agreement that, okay, we're either going to have 30 minutes, 45 minutes, or 60 minutes. By having those 3 options to provide us, then we can scale it on the platform. So the work that we're doing right now is around ensuring that we can support your accommodations and do so in a way that scales and is appropriate and meaningful for the examinee. I will also note that there are accommodations that are outside of the delivery platform. So if you offer snacks or something as an accommodation, if it's nothing to do with sort of the delivery platform or the administration, we leave that up to the jurisdictions. But anything that we can do to support a delivery that accommodates the candidates we're doing.
Okay, that was informative. I appreciate the response. The second question that I have is, if an applicant has a disability-related need to be supervised by proctors using cameras, perhaps from multiple vantage points, instead of with proctors physically present in the exam room, is that something you allow either through on-site camera surveillance in another room to do live proctoring without the need for an uninterrupted internet connection, or through remote testing where a recording is made to address any inadvertent lapses in live internet facilitated remote monitoring?
So, do you want to take that?
Yeah, well, whether or not that has been asked of California or any other state on the current exam, I'm not aware. What we would do with any request, looking at it on an individual basis, I mean, a case-by-case basis for whether or not that's an option. We talked before about just what we view as the technology for remote proctoring, and we have concerns about the technology not providing sufficient security. So it would just have to be on a case-by-case basis.
Okay, that's helpful. Thank you. My third of 5 is, if an applicant has a disability-related need to test at home, whether remotely or by in-home, in-person proctoring, are either of those something you allow?
I mean, at this point, we have not allowed that on the MBE, and I don't know, because that's a part that California uses, and I don't know that we would offer it for the next gen exam either, for the reasons that Kara mentioned before, just about the problems with remote proctoring, the concerns with the validity of the exam. So that would be, again, something I think we'd have to look at on a case-by-case basis.
Okay, I appreciate it. Thank you. The fourth of 5 is, are there specific accommodations such as remote testing or forms of remote testing that you'd consider to be an inherent prohibited risk to exam security or exam content security?
I think as we've noted, my position, and I think NCB's position, is that right now remote proctoring is just not secure enough to enable the validity of the assessment. We'll have all heard about many exams that have been remote proctored. And as we all know, many assessment organizations that had once used remote proctoring are stepping back from that now because of the security concerns. And so I think for right now, the technology is just not there for the security and the validity of the exam.
Got it. That's helpful. Do either of you have technical degrees?
Technical as in information technology. I have a PhD in psychometrics.
Okay, helpful. Thank you. I appreciate it. So my fifth question relates specifically to compliance with the ADA. I imagine that you realize that in order for us to license your exams, the terms of that license have to be compliant with Title II of the ADA, and that we can't claim an inability to license your specific exams if we don't exclude certain accommodations as unavailable. And that a fundamental alteration of those accommodations wouldn't inherently prevent an exam from assessing minimum competency to practice law. Oh my gosh, I did not. Sorry, this one's a mouthful. I didn't write this out clearly. In short, I think I can paraphrase this ridiculously wordy question.
Oh, it's a good question.
I think that we're worried. I mean, my concern is that by prohibiting any form of remote testing through claims of technological limitations, we would run afoul of the ADA, and that we have already. What would you say in response to that?
Well, from NCB's perspective, we work very closely with both inside and outside counsel, both of whom are very well versed in working with the ADA, and NCBE follows the letter and the spirit of the law.
Awesome. Judy, you're famous in the legal community. My last question off the cuff is if you had to pick a bar exam location to take the test for the first time, like so many of us have, where would you take it?
I think for the July 26 jurisdictions that are giving next gen, there are 10 spots, and I think any one of those spots would be a welcome spot for anyone to sit for the exam.
Okay. Thank you. Thank you, Josh. Our time is growing short. Are there any other questions from members of the committee? Questions or comments? Seeing none, Judy and Kara, thank you very much. It's been wonderful seeing you here again, and we look forward to talking to you in the future. But thank you for coming today. Thank you.
Thank you so much for your time. We really appreciate it. We know your agenda is full, so.
Thanks, everyone. Have a good weekend.
Thank you. At this point, I'm going to open this up to, I guess, 4.4C, continuous discussion.
Yes.
Of the options for the future bar exam and draft analysis and cost benefits of each option. So Donna, why don't you start us off?
Yeah, I'm going to introduce two people who are working with us now on the analysis that we are providing pursuant to the rule of court that will ultimately help you and the board develop your recommendation. So I'll introduce them, then just do just a very brief couple of comments, and then I'm going to turn it over to Denise, Danette and Louise. So first we have with us Louise Bari. Louise is an experienced psychometrician and evaluator with extensive technical expertise in assessment design, validation, and analysis. She specializes in building institutional capacity and technical infrastructure for education and assessment systems for governments and agencies worldwide. We also have Danette McKinley. Danette is the principal consultant at Measure for Measure Consulting, LLC. She most recently worked with the National Conference of Bar Examiners for about 5 years as the Director of Diversity and Fairness Research. She's also researched the licensure and certification of health professionals for more than 30 years and has extensive experience in assessment, particularly in the areas of credentialing, certification, and licensure. Her areas of research include the assessment of professionals and identifying factors associated with differences in group performance on examinations. Danette is leading us on some exam development work that we're doing, and Louise on exam administration, and then they're backing each other up on the ones that they are not leading. So I'm going to turn this over to them in a minute. Your materials for today include a presentation that they put together. But just as a quick lead in here, so when I introduced this item 27 hours ago, part of the reason I mentioned the three options that we had initially identified, the three high-level options that we'd additionally identified. And part of the reason that we have started breaking those options down with more granularity into 7 or 8 options is that it really helps us focus on some of the additional decision points that have to be made. Because one of the other points that I have to hammer home repeatedly is it's not simply the choice between 3 high-level options that you all need to recommend to the Supreme Court. I want to just briefly, I can't actually do that. I didn't sign into the Zoom, so I can't share these 2 slides. But I want to point you to a couple of slides that I had shared with the Board of Trustees at their November 2021 meeting. I introduced a couple of decision trees just to get folks thinking about the types of decisions that you all need to make after you make the first decision. So if, for example, you were to recommend adopting NextGen, then you would need to ask yourselves the question, should we add a California-specific component? If no, then you've got fewer decisions from there. We need to conduct a standard setting study and figure out what the passing score is going to be. But a lot of the other questions are answered if it's just NextGen, right? We know it has to be in person. We know it has to be at the types of test venues it has to be at. We know who the vendor is for the technology, et cetera, right? We know all of that. If your answer is yes, there should be a California-specific component, then you have to ask yourself some new questions. What's the purpose of the California-specific component? If the purpose is testing for minimum competence, then that may argue for having the California component on the, thank you, Devin, on the second day of the 2-day NextGen exam. If not, if it's not for minimum competence, but for issue spotting or testing to maybe even deliver knowledge, then maybe that would be something that would be done remotely on demand. Either way, you need to confirm if you want to do it. If you do want to do it in person or remotely, then you need to identify what are the subject matters you're going to be testing and how are you going to test them. Are you going to have multiple choice questions? Are you going to have essay questions, simulations? All of these questions are part of the information that we would need to or want to share in this period of giving 2 years notice, right? So we'd need to say that there is or is not a California component, that it is remote or not, that it is testing the following subject areas and is doing those in multiple choice questions. When we pick subject areas, we have to come up with a content map for those subject areas. So these are the types of things that we would need if the decision were NextGen. Next slide, Devin. If the decision were the Nevada model, and there are many questions not on these slides, by the way. But if you were thinking you would adopt a model like Nevada with the PTs and the multiple choice questions, then you'll want to ask yourself things like, will the exam be bifurcated the way Nevada has bifurcated theirs, with the multiple choice being offered separately from the performance tests? If yes, then what's the timeline for administering each part? Will they both be in person at test venues, test sites? Will they be at smaller test centers? Will any portion of it be remote? You need to again ask about identify the subject matters and the skills that would be tested. What subjects would be tested on the multiple choice? Are we going to leave it as Nevada did with the subjects that are tested on the MBE, which are the question types that Kaplan has been developing for California, and that we have for those multiple choice questions? What are the subjects that you want to be testing on the performance test? So just sort of a way of not scaring you, but that they're just making sure we understand that there are really a lot of decision points here, and we need to be very thoughtful about them. And so ultimately, I'm hoping that as we move forward with some of these presentations, you'll see that Danette and Louise, as they walk through their presentation, they're organizing it differently than we have at the past couple of presentations, because I want you to hear it in different ways and see it in different ways to help you start moving in the direction of coming to a decision on the high level, certainly, so we can then figure out which of those decision paths we need to follow to come to your ultimate recommendation. So now I'm going to stop talking and I'm going to turn it over to Danette McKinley and Louise Bari.
Good afternoon. Danette, thank you so much for being the screen sharer. She's going to hold the keys for this the next few minutes here. Thank you, Donna, for the introduction and sort of situating us as to where we are. I think the real goal of this presentation is certainly not to come away and say you can make every single one of these decisions that has to be made, but to provide a bit of a framework. And in sort of looking at key questions and like very critical decision points, which is what we've sort of wrestled with over the last couple of weeks, allowing some narrowing of the possibilities, hopefully, in the process, and really, really focusing on what are the top priorities. So we're going to just talk a little bit about what is the framework for making a decision that we're sort of proposing, and the way that we're talking about it in our cost benefit analysis document, and what are those decision points? What are we thinking of? And obviously we'll have time to talk at the end, hoping to have a lot of time left over for discussion if there's something that we've missed, or a way that this group has thought about these things that we haven't. And then talking about some priorities and some examples of the kinds of, I guess, factors and inputs that we're thinking about when it comes to the options that exist. Okay. So as I was sort of saying, and as has been said, this isn't, we're not just looking at a set of sort of features side by side and saying, I want this one, I want this one, I want this one. We really are thinking of this in a way of setting what are the absolute core priorities of this bar exam as a revision, as an adoption, as whatever it looks like. What is the priority? And we have a set of these. We have the guiding principles. We have the October 10th court mandate. We have all of these pieces that are sort of their sort of outcomes that we're looking for and that we need to align to. From a decision standpoint, this is why the reframing a little bit is we need to sort of phrase it in terms of so if we want to meet this specific principle, what's the decision that gets us there? What are we deciding between, and what are are there priorities written in the mandate that we can kind of tease out that say we're probably leaning this way or the other way? So that's how we really were thinking about it. And The trade-offs. There are some, major trade-offs that we'd have to look at in terms of the entire spectrum of the system. So from development, administration, looking at resources, both internal and external, and just the philosophical approach to assessment. Thank you, Jeanette. So we've sort of split the work into these two areas: assessment development, assessment administration, and logistics. As a note, it feels very clear here that these are two completely separate sort of domains, but it is important to note how much they affect each other. So the way that something is, the way that we deliver the administration mode can really affect what the composition of the assessment looks like. And things like item types can be predetermined by a platform, which means the administration mode, and all of those things sort of fall out. So again, not to scare you, to echo what Donna was saying, but all of these things are related. So there will be times where there's a trade-off that's happening that means, sort of shutting off the road or saying, nope, we can't go into that particular room, we're closing that door. Under these two, I'll just start with assessment development, so we can go on to the next slide there, Jeanette. So we think about design and development. We're thinking about what are the foundational goals, what is the scope of the content, what is the structure and the psychometric integrity of the assessment. So we are considering, we know that there's a focus on skills and knowledge. We have to think about things like weighting, minimum competency, how we're defining that, how that moves us into the standard setting procedures, things like that, transparency in the way that we talk about what these scores mean. We have to obviously talk about fairness, disparate impact. We talk about bias mitigation. In terms of the structure, we've got to look to sort of job analysis, content alignment, cognitive complexity, all of these important pieces of the structure, thinking about the question types and components, essays, are we doing skills assessment? Is there a performance-based assessment component? And then the reliability, scoring, and reporting piece of this. So, excuse me. So our first decision point, our first sort of question that we found, again, we wrestled with this for a while, but trying again to sort of narrow the focus into what are the key diverging points of decision. So is there a priority to develop a California specific exam? And by that, I mean at any point in the future. So that doesn't necessarily just mean 2 years from now, but is that a priority? Is that a path to go down? And is it an important goal, to avoid cost and risk of extensive internal exam development that this would require? And we think about the big question, and then, when Donna was showing her decision trees, some of these consequences that fall out that are, there are actual literal consequences in terms of if you make a particular decision, there is a specific timeline associated with implementing that decision within the recommendation of the Supreme Court, or what the development timeline just has to be for a particular type of assessment. But there are also some mini decisions that fall out of the consequences as well. So in terms of resources, are you going to use ongoing, or is it ongoing or a temporary question? Are they contracts? Are they internal staff? Are we using a stopgap measure before we're going to get to this California specific exam, or is there something else that we can use? So really, again, trying to think about what is the major question and the consequences / sort of smaller decisions or resulting decision points out of that major critical point. Okay. So it's, once we've sort of thought about these things, decision point 2, what is composition and content? So how are we constructing this exam? how are the formats aligned with knowledge and skills? Again, is there a part of the mandate? Is there a priority to assess a specific type of skill that really is best suited for something like a performance-based assessment? That's going to make a few decisions for us. Are we working with a set of 12 skills from previous lists? Are we working from a set of 9 skills? What are the, what is the sort of crux of the content, and how does it align with CAPA? How does it align with our ability to administer? So as I said, the item types, which there will be follow-up from that as well. And then weighting administration requirements of each of these items. As I mentioned, the development administration are sort of unfortunately inextricably linked in our case. 3. So major question, how well is whatever it is that we are looking at aligned with the specific California needs? Again, we've got our mandate, we've got our guiding principles. This one's really about sort of autonomy and state-specific needs. Is it possible to require a high level of autonomy and still adopt or utilize another model, right? So that's a major question. Can you meet the needs that are required of the bar exam and of our guiding principles, while also sort of outsourcing a piece of this? Things that we would be thinking about would be things like the portability question in this, right? So that's a sort of a secondary decision point and consequence. If there's a possibility that in one of the decisions, portability becomes sort of a foregone conclusion, for example. So there may have to, there may be compromises on content in terms of consequences. There may be compromises on administration mode or flexibility. And then might have to be some conversations about negotiations across states around that portability piece. So when we move into, those are the big sort of key questions around the development piece. When we think about administration and logistics, I know there was a lot of conversation about that, a lot of questions about that in the last presentation, which rightly so. Technology feels like it moves at the speed of light, and I'm sure tomorrow there will be something available that wasn't today in the case of these administration options and opportunities. In this case, we're talking about things like exam delivery, location, test security, so delivery methods, physical sites. Where can we do this? What are the requirements of that? What's the cost of that? Security and vendor oversight, vendor accountability. So who is, is there one platform? Are there multiple platforms required? Is there one for administration, one for scoring? Like, what are we, what are the requirements here based again on what the priorities are? Again, timing, frequency, scoring, so things around scheduling. Is there a priority for bifurcation or taking the assessment in sort of pieces, and what does that mean from an assessment administration perspective, and also what does it mean from a scoring standard setting perspective, and a policy perspective as well in terms of retakes and timing and things like that, and then financial staffing, technology costs, things. We have that financial burden on examinees piece that we're definitely looking at trying to sort of disentangle from everything. So if we're making what is the priority of that? If it is keeping that a low burden, does that then mean that other decisions are essentially made for us because some of these other options are extremely high cost, for example? What is the sort of staffing and resource impact? Including if it's an in-person, there's this need for a large number of humans in a space. There's a need for a very large space and more than one of them. If there's a technology component, there's an infrastructure piece, both from a software and a hardware standpoint to consider. So again, what is the priority from a technology standpoint in terms of administration? is going to allow us to talk about some of those pieces. So delivery, again, what are the priorities? Where do we want applicants to be able to take the exam? How often do we want them to be able to take the exam? What is the priority on this particular front? And again, that's going to cascade into some consequences around procurement, development, timelines, costs, tech support, as I mentioned in the room, and also the possibility of additional development questions. So if there is a flexibility of administration in terms of more frequent exams or an exam window, there's additional test development, item development requirements, which means additional validation, additional scoring. How will it be scored? So what is the approach to scoring? This is related again to that question of like bifurcation or taking the exam in sort of sections. Is it a priority that examinees can take only a portion of the exam, or do they have to take the full thing again? How do we want our scorers to be able to engage with the scoring piece in terms of a reliability, question? So the way in which we answer this question is going to tell us what type of questions we're going to be okay with. If we don't want to have a lot of onus on human scorers, for example, that's going to dictate what kind of an item type you're going to kind of allow or prefer on the assessment. Again, there'd be the possibility of a platform and technology component on this as well. And then last decision point is really all about technology, which is sometimes the most fun and also the most complicated again to talk about. So again, what are the risks and trade-offs here? What is the impact on cost, on long-term flexibility? What is that in terms of short-term investment, for example? So consequences around resources, again, both internal, external, in an ongoing way and in a temporary way. So for, heavy development periods versus in an ongoing way, or during administration periods. And then when you're not administering, you don't, in terms of the temporary status. And it's really thinking on this kind of spectrum of almost like an innovation to kind of a stability spectrum. So what is the appetite sort of for risk in light of the appetite for innovation? So how are we willing to sort of trade those two pieces off? Danette, I think, is going to talk for just a minute about the next couple pieces of the puzzle.
So in considering all of these factors and decision points, it's also important, particularly if we're going to do a risk and benefit analysis, to consider resources that the State Bar already has. The Committee of Bar Examiners develops exams other than the bar exam. So you've already had some experience in doing some of the things that we're talking about. Development had to occur for the February 2025 exam, for example. While it may be a painful memory, it is still something that you were able to accomplish and learn from. And I don't think we can just throw that out. There's a lot of stuff, there's a richness there that we can move forward. The other thing is that you explored exam development contracts, and so you know what some of the benefits are, what you might look for in a vendor, and that type of thing. And the final thing is that you've already done the practice analysis, so you have some evidence-based guidelines to say what you want in terms of content. You already know whether or not you want to stick with the current MBE as a decision point, whether you want to expand the doctrinal areas and skills that you're measuring, that type of thing, and you have evidence to back that up. So here are the challenges. Donna already alluded to this. You don't really have the luxury of taking too long to make a choice. MBE will be eliminated as of July 2028, and given a 2-year notice requirements for some of these decisions, that sets the timeline for when this has to be made. The other challenge is that for all we may be able to hear about with other options, there are always going to be unknowns. We can't possibly know what'll happen in terms of technology changes, in terms of remote testing, for example. We have to go with what we know now, and we'll talk a little bit about how those unknowns may or may not affect the rest. And the technology issues identified with February 2025 may make you more adverse to certain options that are out there and maybe a big part of the decision that you make. And now I'm back to Louise, who's going to talk about prioritizing those objectives.
Right. So along the same lines that I was talking about for the technology, that last sort of decision point, thinking of it as a spectrum, this is sort of trying to, again, just reiterate and rephrase and reconsider the way that we sort of think about the trade-offs and think about really the big decisions and the big points of contention. So it's all trade-off at this point. I think if we had an ideal world, I think you would be able to say we're going to do everything exactly as we want to do it, but that means an unlimited budget and an unlimited timeline, and unlimited resources. So there's always going to be these trade-offs. So for the moment, at least, the way that we've kind of conceptualized these are in these sort of 4 categories, where our hope obviously is to be able to sort of place each of these options along the spectrum as we're completing the cost benefit analysis. So again, I'm always phrasing in terms of questions, but are we prioritizing sort of long-term control and oversight, or the speed with which and efficiency of adopting sort of a ready-made solution? So this is alluding sort of to that that first question that I talked about, like, is this like ready, or the bespoke California exam the priority or not? So we're looking at, control and efficiency. Sometimes those go hand in hand. In this case, we're sort of talking them as two opposite ends of the spectrum. The next would be customization, standardization. So again, this is about the California priorities. So even in the event, perhaps, that there is an adoption or the use of another model, like in the Nevada case, maybe there are some customizations that are possible and that allow you to tailor that exam in terms of California's specific needs and guiding principles, mandates. But you're kind of trading off from like a standardization approach. So that, that idea of, that national portability piece is sort of lost the more that you customize, right? Then flexibility in administration versus sort of that stability piece. So are we needing something so customized and so innovative that there's a development component that allows us to be super flexible and do that? Or is it sort of a ready-made solution in terms of administration, an off-the-shelf product that can be worked with, that's going to provide some sort of stability of that established sort of processes and software? Last one, which I think is probably most interesting, will be most interesting to talk about when all is said and done, sort of an innovation risk spectrum, which I've alluded to several times, I've talked about. So there's uncertainty and risk with innovation. That doesn't mean we don't do it. It's just a matter of finding the right sort of placement in terms of trade-off, and understanding that any level of innovation is going to have some risk, but there are definitely ways, and that's a part of our analysis, certainly whenever we've identified risks, where there's a possibility to mitigate, we're also identifying what that would look like. So this is just a sort of long list of the way that these options have sort of fallen out as they've gotten a little more specified. So I think currently we're looking at 7, really sort of 2 roads. We've got a California developed exam on the one side, and more of an adoption, possibly with some pieces of adaptation on the other side. So these should be, for the most part, familiar. There's components of Next Gen. There's the Nevada exam on here. There's the Nevada sort of model in terms of a California specific component, and then a very like the tailored, customized California specific exam. And then just, you've got to always include a lovely infographic, don't you? So that first question that I talked about, it really is kind of bridging us apart. I guess it's moving us apart. Where on the one side, we really can see the you know, there's the need for customization, more innovation going on that side. Of course, inherently a little bit more risk, but we don't want to be completely risk averse. I think, as Danette said, there's been a lot of learning, so I think there's a lot that can be done to mitigate a lot of that. And it really, it prioritizes what California's specific needs and priorities are. The other side of the coin, sort of the national alignment and efficiency piece. So a little bit more off the shelf, more stability, and very efficient in terms of timelines. There's obviously there's been the talk of like the bridges and things like that. So I know Danette's gonna talk a little bit more about that in her examples, but there's obviously maybe a middle ground somewhere in terms of in an interim at the very least. But the way we're sort of viewing it is this is sort of the divergence of that first question that allows us to really narrow in on what are the priorities. Back to you, Danette.
So I'm going to give 3 examples and a very high level overview of considerations that we think align with these goals and priorities that the State Bar would have. When we complete our report on the cost benefit analysis, we're going to be looking at primarily 4 areas or 4 criteria. Validity, which is the ability of the examination to support the interpretations that you make. In this case, it would be about minimal competence. Reliability, which is the consistency with which outcomes occur. Fairness and equity, as Kara said, it's the opportunity to give all candidates the same chance to demonstrate their skills and knowledge. And the last and probably most important part is practicality and scalability. Here we're talking about feasibility in terms of cost, resource use, and just the possibility of doing it in the timeline that supports that decision. So this first example would be developing a state-controlled exam. It would be similar to going in a direction where you're saying that by maybe as early as February 2028, you would have an exam and you would not use any of the other options. Remember, this is very high level. There are probably more benefits and risks in each area than we've listed here, but this lets you see the type of thing that we were considering in looking at these factors. So the first step would be, okay, how does the content align with what we know should be measured in order to make an assessment of competency? Currently, you have content maps that have been prepared. It's the way that these questions have been developed. The risk would be if you're waiting until 2028, do you want to do additional work to update those maps so that they align with what you found from the CAPA studies? Of course, to mitigate that, you could do a bridging exam and update test specifications as you go along. The unknown here is if you adopt a state-controlled exam, what would the acceptance of scores be by other jurisdictions? So from a fairness perspective for candidates, perhaps, and I see someone raise their hand, I'm just not sure, should I keep going or should I let them ask the question now?
I just need to note that I'm stepping away for about 30 minutes. Please continue.
Okay, thanks. You may need to do that negotiation where we're talking about other states accepting the scores from your exam as for entry to their state bar. For reliability, you do have some information from the February 2025 exam. You know which items work, you know which items don't, you know where you need to develop more items. One of the risks was that it was said that there was insufficient content representation, but you can recover from that by actually continuing question development and improving your content validation. The unknown here is any new items that are prepared while you're waiting to launch would not necessarily have statistics until after the first administration. In terms of fairness and equity, the State Bar would have much more control over the development and administration of the exam. You would have customized bias review. You would be able to look at differential performance factors that are important in California. And here I think of the discussion that we just recently had on whether or not non-ABA accredited graduates are going to be accepted to sit for the exam. A risk here might be that technology introduces challenges for some groups of examinees. And the way to mitigate that is to continue to review performance by different groups and to identify ways to improve the technology that you have decided to include. In terms of practicality, the State Bar would have more control over the administration, how it's administered, how often it's administered, but there may be insufficient time to develop prior to implementation, say if you wanted to have 4 administrations a year and spread them out better over time. You could extend that timeline with some other options that we'll talk about in terms of a bridging exam where you maybe adopt for a while and then eventually have your own exam. The unknowns here are cost. Would we really be working towards continuous administration and the cost associated with that? And the other unknown is remote testing. I think we've heard from a number of folks that remote testing technology is not where we would need it to be. But if that is a priority, how can we move towards something that is currently unknown? This is a different example. It would be adoption for the short term. So you could implement NextGen UBE without any California component and decide that you would do something further down the road. This is sort of a hybrid decision. It would be, we're going to do this for now. If our priority is to continue and develop a California exam, we'll be able to shift a timeline accordingly. The benefits are that the content scope for NextGen is available. It was in the materials that you saw today. They have concentrate, not just the content maps, they actually have a lot of source information about the doctrinal areas and tasks that are going to be measured by each of the skill areas. You have the benefit of having a practice analysis completed, so you'd be able to identify any misalignment with your content, and that would give you a different way to make a decision about how soon you would want to introduce another option if it's a state supplement to the exam or if it's a complete exam. Again, if you went with this other option of a hybrid where you're only doing this for a while, you may have to work on acceptance of scores with other jurisdictions. Obviously, if you take NextGen as it is and don't add anything, then you would have some of the UBE advantages built in. You would still have the information from the February 2025. You would be able to identify components if you did want to eventually develop a supplement to the NextGen exam. You would just need to make sure that you had sufficient scorable units if you have a specific component in any new doctrinal areas, remembering that that was a challenge even for February 2025 when you were only measuring within the MBE content areas. The mitigation, should you make this decision, would be to design an adequate number of tasks and graders. So you can see as you're stepping through and you're saying, okay, maybe in the short term we do an adoption and we actually have a component of our own, the same way that you have now, you would make some of these other ways to balance the risks. The unknown for right now is how would you be scaling to the exam you adopt? What question formats would you want to use? What would the reliability be for the separate components? And then fairness and equity. So if you're not in control, then the technology that another vendor is introducing may introduce challenges for different groups of examinees. I think you've heard a little bit about that. How they would try to mitigate that risk is the continuous improvement of accommodations and what they can do with those accommodations. But we also don't know if this will really improve accessibility and affordability for all test takers. You're still giving an exam that's really controlled by another group and having to set up your own test sites, for example. The practicality is that it is externally developed, so you don't have to take on development cost. And the administration mode and timing is already specified. That's not an announcement you have to make, but you might not have time for review and alignment prior to that implementation. That's a risk that goes with the decision to accept this without necessarily having a supplement to the exam. And then finally, you may want to do exam adoption long term. So this actually gives you a little bit more time. You may say, we are announcing that we're adopting NextGen. We're going to wait a couple of years and then announce whether or not we're going to have a California specific component. Again, some of the advantages are the same. You have content scope. You have sample questions that are already published by NCBE, so it meets your 2-year timeline for being able to announce to faculty and to students. When I say exam statistics will be available by July 2028, I was thinking here that national statistics for NextGen UBE will not be ready until the July exam because it's a stepped approach to adoption. You will have some statistics from what they're doing in July 2026, and then more and more states will be added in. For Nevada, it would be local to them, but they wouldn't be available until their February 2027 administration. And the unknowns are how scoring and scaling would occur if you were to adopt another exam completely. Again, technology may introduce challenges for groups of examinees. Depending on how things go, I don't know if you could adopt the model that Nevada is using and actually get into prometric centers, or if there would have to be some separate work that you would do there. Right now, if you're going to look at differential group performance and identify potential underlying factors, as Kara said, they would be willing to work with you, but that's something that NCBE manages. I think that if you wanted to look at how non-ABA accredited schools, for example, versus accredited schools perform, there are actually other states that have a similar situation, and they'd be able to look at that for you. You'd also have to consider standard setting because that's an unknown. So they do have a way for NCBE to recommend what standards should be, but you probably want to do something for your state. The administration timing would be known. The risk would be finding adequate sites to meet technology and volume. I know they're talking about catching and making sure that there are ways to mitigate some of the risks around losing internet access during the exam, but you'd still need to find enough spots with enough bandwidth for that to occur. And the administration mode and timing questions are unknowns depending on whether or not there's a decision to include a California component. So we've tried to lay out sort of the decision points that you would have to make and then show cascading decisions that come from that and how we would be framing the benefits and risks depending on which of the directions and options you choose to take. And we're open for questions.
Thank you. Thank you very much. So I thought one of the things that might be helpful is if we started going back through some of those key, sort of the first level decision points, and started having a real discussion about some of those and see if we are coalescing toward any particular direction. Because ultimately, we do need to make that decision, as I mentioned before, sooner rather than later, so we can build out any of the other decisions that necessarily have to go underneath it. I do want to point out one of the things that Danette and Louise had talked about was the number of more detailed decisions that need to be made could be put off if there was a decision to have some exam as a bridge to our sort of future development efforts. So whether that is we go forward with the Kaplan multiple choice questions using the same content now, and the California essays and performance test using the same content now that we had same content maps, we use that until we develop a future exam, or we adopt next gen as is until we determine based on the statistics whether we feel we need to develop our own exam or whether we feel the need to adopt a local component. Same with Nevada. We can ask Nevada outright for their exam. We can say we're going to adopt the Nevada model using the multiple choice that have been developed by Kaplan in the 7 subject areas that they've been developed in, and PTs in the content areas that those have been developed in, while we recommend building out those multiple choice and performance tests in the 12 subject areas which were part of the October 2024 order from the Supreme Court, right? So if we say we're going to sort of adopt something, easier, more static now, we could do that and then take X period of time before we have to give the notice for those longer term decisions. So those are just a way of sort of giving some context. If you are, because some of you may very well be feeling, I want a California specific exam, but I don't feel we can make all those decisions about the content maps and whatnot in the immediate timeline. We should take an additional year for that, right? So I just wanted to sort of make sure that you were thinking about that as well.
And we don't expect a decision today.
No.
But we just want to get a sense of the committee. And unfortunately, we're kind of running low on time on this item. I'll start off the discussion. My personal recommendation at this time is we continue with the current format, the California essay questions, and using the Kaplan multiple choice questions as a bridge. As a bridge to developing the new examination as required by the Supreme Court. Thoughts? Paul.
So you mean the California
essay?
No, okay. But keep the current status quo, subbing Kaplan. Yeah, I think we need to have that on the table, regardless, because we're giving the court basically a take it or leave it recommendation given the timing. So if the court doesn't like it, we need to have the analysis of continuing with the status quo, modified status quo, on the table. But then you're talking about taking more time. That's a question to develop a California specific as opposed to the UBE, or leave, or the choice between the two is still on. Needs more time to develop.
I think we need more time to develop. We also have to be careful not to lose momentum, to simply adopt this procedure, to take this approach indefinitely. We don't want to lose momentum, but we do need something fairly soon. So that's why I'm recommending this bridge. We also have the issue of the remote exams. My personal feeling is that the technology just doesn't exist right now. I think we need to keep these two questions separate.
I could go. My preference. I'm leaning towards the UB, the next gen exam. Add a California specific component if we want. I think what portability does. We keep talking about we want more attorneys to practice in California to serve underserved populations. Having more portability scores will remove a barrier for some people to want to come into the state. It's one thing to bring your score. It's another to have to go take another bar exam. And, if you've been out of school for a while, that's a heavier lift than, but I ultimately think that's not the biggest problem. The biggest problem with serving underserved people is finding money to pay the people to serve them. And those people who think they're either going to coerce members of our bar to just do it gratis, I don't think that's going to work. That may drive people out of California. That's not my preferred approach. So, but this may help a little bit. And it also lets our California attorneys, the newer ones who've taken this exam, move to another state if they want. It creates a free market, a freer market in the practice of law, where you don't have these, I need to take another bar exam barriers. I wanted to make one point about the cost-benefit analysis. If we're talking about remote exams, I think we need to be careful not to develop our price model on the proctor to candidate ratio that was used in February, because that was completely inadequate. And I think we'll find that if we bring the number of proctors up to where they can effectively proctor candidates without friction, a candidate having to wait for 30 minutes to get reapproved after they came back from a bathroom break or whatever, the costs are not going to be that different. It's a matter of fewer proctors watching a lot of people in a big room versus one proctor maybe watching at most 5 people. I think we were at 10 in February. So I think I want to make sure that kind of assumption is built into those calculations. And I had the impression from listening to the folks from the national conference that they share your and my healthy skepticism about the current ability of remote proctoring to work, but they are open to using it once that skepticism is no longer justified. So I don't know that we have to have our what's the term I coined, California exceptionalism system in order to achieve that goal. We probably get there almost as soon and safely with the next gen exam.
Judge Reyna.
Thanks. Yeah, I was just kind of interested in the budget analysis for the bridging the gap, because Alan, you indicated maybe sticking with where we're going, and then I know Paul, which initially I think I'm kind of with you on there. If we choose the next gen to bridge the gap, let's say, I'm just curious as to our budget. Like, let's say we do something like bridge the gap or whatever, do next gen with the California component, and we still explore using, doing our own type of exceptional test. I imagine that will add more continuing costs. I'm just curious what kind of analysis has been done there, or if any, if we try to choose that path.
So any cost analysis is going to be, we will be using sort of the best information that we have. But we had estimates for the development of a new California exam that ranged anywhere from $2 million to $10 million for the initial development effort. Obviously, there are then going to be ongoing development costs, because once we've got our own exam, you have to, on an ongoing basis, develop the content and do on an ongoing basis every 7 years, we would do a standard validation study, we would do a content validation study, we would do another practice analysis, et cetera. But so yes, it was a very, that's a very big range, $2 million to $10 million. And so part of it would depend on the direction that we would get in terms of how ambitious and innovative to be with that development, right? So that could certainly impact and keep it on the lower end or the higher end, depending on the direction that we get from whatever steering committee that committee of bar examiners would create in order to guide us through the development of the exam. But if we were doing, yes, both at the same time, then obviously we would have the costs of administering the exam, the license cost to National Conference of Bar Examiners, as well as development costs at the same time.
All right, thanks. Yeah, because we need to, like you presented, we need to make our decision by May of 2026 because the new whatever bar examination we take has to start July 2028. And I guess that's why I guess I guess I'm worried about our, we tried so long to make our own exam. We have since the Blue Ribbon Commission, and now I feel like there's still questions about that have been raised through public comment and other folks about Kaplan and even though I think our EDGE team and our development of our own PTs and essays, I think, are generally positive. I think I'm just worried about the quick turnaround, and I don't know if the next gen bar. It seems like they've been going for 9 years, and it might be a good option, and we can use our own California component and use our EDGE team or our folks to make it specific and allows for the portability. So I think initially just interested in maybe that option, but those would just be my comments now as I listen and think more about it.
Thank you. Christopher.
Yeah, so I just wanted to clarify, like when you're talking about the problem with the February administration and some of the comments about Kaplan, my understanding is the problem in February was largely rooted in the delivery and the technology as opposed to the questions or anything about the exam content. Is that right? Is anyone who was here at the time?
I don't know that we have a final report, but that's my impression, certainly.
Yeah.
There were definitely criticisms that were raised about some of the content and the breadth of the content map and the accuracy of the questions, which is why I think one of the very strong positive directions that we've taken in terms of lessons learned, we've brought to the committee for adoption. You have adopted a policy for the selection, recruitment, and eligibility for content validation panelists. We've added a level of subject matter expert review. You've adopted a policy for selection and recruitment and eligibility for the subject matter experts. We are making a more robust process. One of the things that we have brought Danette McKinley on to do is make sure that we have a comprehensive exam development framework that we follow, or if we don't, we are making smart, intentional decisions and documenting when we're not, so we have that is something that sort of going forward that we would be. I think there's a lot that we've done that will help us restore confidence in those particular questions.
Was that it?
Well, yeah, I was just going to say, I mean, I share Judge Reyna's concerns about the cost. And as I understand it, our Kaplan deal is sort of sunk for the next couple of years. And so, to the extent we can rehabilitate some of that and use it to bridge. So I should back up and say, I like the idea that you mentioned, Alan, of having a bridge exam and then continue a conversation about a bigger effort and kind of stay that course. But I do, like, there's a lot there that we're not going to get done in the next, by the time we need to make an announcement. But if we can use the Kaplan questions or continue that engagement with Kaplan, it removes some of the unknowns that we still have. I'm not opposed to next gen necessarily, but it does seem like there's a lot of unknowns there. And we had challenges with our first attempt at a California administration, but we kind of have a good sense of what those were, we think, right? And so if we can use some of that money or that investment and engagement that's already been invested, I think that may be a fruitful course.
I have one last question, and I think we're going to have to cut it off. What is the effect of next gen? We talk about portability. What is the effect of reciprocity vis-a-vis California and bringing a score from next gen here? Would that require legislation? Changing the rules?
So it would certainly require court sign off. It may require statutory change, but it would certainly require the court to sign off on that. And I think one of the things when the Blue Blue Ribbon Commission recommended to the court that we allow for reciprocity, right? Right, reciprocity in its very name, it's about it going both ways. And so the recommendation was that, and the recommendation that the court adopted, change that. The recommendation, not adopted, the recommendation was that reciprocity be allowed for those who would recognize and allow would recognize graduates of any type of law school in California, or any of the four paths, frankly, that we allow people to become barred in California, right? So not just ABA. One of the things that I have been wanting to do and haven't gotten around to yet is reach out to the 47 jurisdictions who have adopted Next Gen at this point to see if there is openness to allowing portability of the for those who graduated in California from accredited schools or unaccredited schools, or passed, met the passing score through the Law Office Study Program. That's something that I don't know. Not as I understand it, not a lot of the other jurisdictions have yet published what their portability acceptance will be. So that's something that I will need to reach out for. And then, yes, if we wanted to do that, we would need to get direction from the Supreme Court to allow other people from other states to bring their scores into California.
All right. We have a lot to think about and a lot to work on.
Alan, I won't go for more than 2 minutes. Can I add a couple things? It'll be short.
Josh, we really got to move on. 2 minutes, and then Kareem, and then we're going to call it. So go ahead.
Got it. No problem. All right. I just want to say that I am in full support of what you said, in that we should use Kaplan as a bridge for two primary reasons, because we cannot continue to sink money when we have already spent $6 million. And I'm not sure if all of you are aware, but the Board of Trustees rejected the budget that this board passed at our last meeting because it was too costly. So a huge component of what we need to focus on and maintain responsibility for is cost reduction measures. There are so many other points that I was hoping to bring up, but I will wrap it with this. I believe that we have a responsibility to the people who write public comments. And if you read and tallied the public comments, they were overwhelmingly in support of Kaplan. But even more so, they were fiercely opposed to anything NCBE and Next Gen related. And that is a big part of why I am going to support the Kaplan option too. And I hope you guys do as well.
Thanks, Josh. And just for the record, the board did not reject our budget. They modified a couple of the line items, but the fees, yeah, but they weren't totally rejected. All right.
Just had a question for staff. Hard deadline is when?
We must give notice of the exam July 2026, which means that the final recommendation from the Board of Trustees will be adopted May of 2026. At their May meeting, so we can deliver the petition to the Supreme Court, ideally very beginning of June, and they can make the decision by July. That means this committee will hear this, we'll discuss this again at our January meeting jointly with the Board of Trustees, and then you'll have an opportunity again in March and April, and then we have to have that final recommendation.
Okay.
Thank you.
Thank you, everybody. Thank you to our guest, Danette. Louise, thank you for all the work that you've done. At this time, I am going to offer everybody a 5-minute break, 5 hard minutes, and reconvene in closed session pursuant to Business and Profession Code Section 6026.7 C3 and 4, Government Code Sections 11126C1 E2 and E2A. The committee will be hearing all closed session items except for item 3.4, which will be taken up on Saturday. So thank you very much. 5 minutes.
Thank you all. Bye-bye.
Thank you. Oh, don't do that. Are we live, Devin?
We are.
All right. Thank you, everybody. We're now back in open session. There is no reportable action from the closed session. Meeting business has been concluded. The meeting is now recessed until Saturday, December 6th, with the only item on the agenda being closed session item 3.4, approval of the written questions for the February 2026 California bar examination. Thank you, everybody. We are in recess. Thank you.